ng karunungang kumilala sa katotohanan at ng pusong laging inuuna ang kapakanan ng inang bayan. Senator Judge Ejercito, Senator Judge Escudero, Senator Judge Estrada, Senator Judge Gold, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin, Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the Senate President.
With 21 senators present, the chair declares the presence of the court was convened on May 18, 2026. For the record, since then, the court has issued summons and conducted pre-trial proceedings which are all made part of the records of this case. Resolution number 39, or the Rules of Procedure of Impeachment Trials as amended, shall continue to apply.
Your Honors, we are now ready to hear the statement of the Senate President.
Before we begin, with the court's kind indulgence, I wish to deliver a brief opening statement. Ladies and gentlemen, distinguished senator judges, sa araw na ito, binubuksan natin ang pagdinig sa kasong impeachment laban sa pangalawang Pangulo ng Republika ng Pilipinas, ang kagalang-galang na Sara Duterte, alinsunod sa ating saligang batas. Sa pagtupad natin sa tungkuling ito, malinaw ang panata na ating sinumpaan to do impartial justice according to the Constitution and the laws of the Philippines. Ibig sabihin nito, ang bawat pasya natin ay dapat nakabatay lamang sa saligang batas, sa ating mga batas, sa mga alintuntunin ng hukumang ito, at sa mga ebidensyang ihaharap na walang kinikilingan at walang pinapanigan. Impeachment is a constitutional mechanism that holds the highest public officials of the Republic accountable to the people. We cannot achieve accountability, nor can we faithfully serve justice without it. Karapatan ng sambayanan na malaman kung may katotohanan ang mga parada laban sa pangalawang Pangulo. Tungkulin natin timbangin ang mga ebidensyang ihaharap at tiyakin ang ating magiging pasya ay nakabatay lamang sa batas at sa mga katotohanang want to rule 2, paragraph 2 of the Rules of Procedure on Impeachment Trials, as amended, we now proceed to the election of the presiding officer of the impeachment court. Senator Judge Panfilo Lacson is recognized for the election.
Point of order, Mr. Presiding Officer.
Yes, we recognize the gentleman.
Thank you, Mr. President. Mr. President, Mr. Senate President and Presiding Officer, as the preamble of the Constitution said, imploring the aid of the Almighty God, and as you said yourself, that every stage of this impeachment, we have to make sure na patas, we have to make sure na may due process, we have to make sure that it is fair. It is very clear in the Constitution of the Philippines that the presiding officer is the Senate President. Section 3, paragraph 6 of Article 11 of the 1987 Constitution, the Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senator shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of two-thirds of all the members of the Senate. I will go to the other two-thirds inquiry later on because this is another threshold issue, Mr. President. But to further the point of order, with the indulgence of Senator Lacson, so that we can discuss this intelligently. On the final question of whether impeachment, on the issue of who shall preside, under the Constitution, it may seem that it does not say who should preside. But if you look at the records of the Constitutional Commission, number 40, 26 July 1986, the framers deliberately chose the phrase. Sorry, Mr. President. I am referring to Section 6, Article 11, and then Constitutional Commission number 41, 27 July 1986. The presiding officer, Mr. Clenyas, Commissioner David, is recognized. Thank you, Mr. Presiding Officer. I have some proposed amendments on Section 3, subparagraph 5. The presiding officer, Mr. Clenyas, the gentleman may proceed. Mr. David, who later became Chief Justice, this is without prejudice to whatever amendments may be accepted by the committee when the Aquino amendments will be taken up. It would consist in adding a new sentence on line 20 before the phrase "no person shall be convicted," inserted the following: all other cases the President of the Senate shall preside. The presiding officer, what does the committee say, Mr. Monson? Is it not understood that when the President of the Philippines is on trial, it is only time when the Chief Justice of the Supreme Court will preside? It is necessary to say that the Senate President shall decide during all the time. Presiding officer, Mr. David, Mr. Presiding Officer, I precisely presented this because we had a distinction when it comes to the Chief Justice of the Supreme Court. But with that clarification, that in all other cases, it should be the President of the Senate who shall preside, I withdraw my amendment. So it is but elementary, Mr. President, in statutory, especially construction of the Constitution, that the spirit as well as the letter is followed. The spirit of the Constitution is that it is the Senate President who will preside. This is not an ordinary statement, dictum, or it was not a capricious statement in the discussion, precisely because the Senate President is elected by the majority. As an example, when Senator Pimentel did not like the vote and did not vote with the majority, he offered to resign. So the point, Mr. President, is this. Number one, institutional integrity. We need to protect the legitimacy of these proceedings. Even if the substitute presiding officer acts fairly, a conviction or acquittal reached under constitutionally effective process would invite judicial challenge and cast doubt in the entire trial. Do we want to go 30 weeks? If we follow the number of days submitted in the pre-trial, 62 tama ba kung sinong nag-resign. Why is it important? Why can't any of the 24 resign? Remember, under our very rules, hindi ko na babasahin para mas kumikli. In our very rules, the presiding officer can decide on the spot, or he can throw it to the body, or he can call a caucus or whatever you call it to be able to decide. And we experienced that during the FONA the trial, and that's one reason why everyone acclaimed the late Senate President Enrile, not only because of how he carried it himself, but how the consensus and how he carried it with the minority. Secondly, jurisdiction and regularity. The Senate's jurisdiction over the impeachment trial is constitutional. The exercise of jurisdiction must conform to the Constitution, and the Senate's validity adopted impeachment rules. We cannot say we're following the Constitution, then we will not follow the Constitution. If the Constitution and its framers prescribe who shall preside, who are we to change the Constitution here today? We cannot enlarge or diminish the Constitution arrangement through internal rules or through ad hoc resolution. Lastly, due process. Kailangan malinaw po sa lahat ng partido, both the prosecution and the defense, kung ano yung korte, kung ano ang two-thirds, kung ano ang charges, kung sino magpre-preside. So kung now during the first day we're going to change who's going to preside, and it's against the Constitution, what more changes are we going to do in the next few days? Ano ang limit na pwede natin palitan sa Constitution at hindi? The authority must come from the Constitution or the governing law, not from the vote of a tribunal. A litigant is entitled to have the case heard by the decision maker designation by law. The law cannot say that ang mag-hear kay Senator Marcoleta ay Sandigan Bayan tapos sa Court of Appeals natin siya dadalhin. Hindi pwedeng sabihin sa RTC dapat i-hearing si Juan de la Cruz tapos sa Sandigan Bayan natin dadalhin. Hindi pwedeng sabihin tatlo sila sa CA pero in this case nagbotohan kami, isa lang kami mag-hearing. Before proceedings before a judge or hearing officer who lacks the legal authority are invalid regardless of fairness of the proceedings. A judgment rendered by court without jurisdiction is null and void and may be attacked anytime. It creates no right and produces no effect. It remains a basic fact that in law the choice of the proper forum is crucial, as the decision of a court or tribunal without jurisdiction is a total nullity. A void judgment for want of jurisdiction is no judgment at all. All performed pursuant to it and claims emanating from it have no legal effect. Dan versus Hinto, GR number 213054, June 15, 2016, penned by Justice Perlas Benabe, First Division. The constitutional authority, Mr. President, is very clear. Now, let's put that aside for a moment. We're not allowed to do that, but for a moment, let's put that aside. The Constitution is not clear and does not tell us what to do. The rules of the Senate says that any amendment should be presented a day before. And that's why the then minority, when I was Senate President, walked out because your contention was, when we gave it to the Committee on Rules, kahit may isang araw na pinabalik ng rules, we did not follow the rules. So on the rump session or alleged rump session on June 3, first of all, you did not have a quorum of 30. But let's assume for the sake of argument, I'm not giving you that point. As far as I'm concerned, it's in the Supreme Court, walang quorum on 12. Assuming my quorum on 12, you did not follow the rules. There was not a one-day notice for the rules. And then if you look at the records, this impeachment court adopted the rules on May 18th. So that means that it is this impeachment court that now has to adopt any amendment to the rules. We did not debate that amendment to the rule. We cannot now just change the rules. We're here for the opening statements. We're here for the trial. Are we here to change the rules? We're changing the rules here today, Mr. President. So, Mr. President, presiding officer, and the issue of what constitutes two-thirds of all members is a threshold issue. Para maintindihan lang po ng lahat, lalo po sa mga kababayan natin na nanonood, Merriam-Webster, simple definition, a threshold issue is a preliminary question, minimum requirement, or foundation condition that must be met or resolved before proceeding to the substantive merits of a case, project, or process. If this initial criteria is not satisfied, further action is typically dismissed or halted. I want to avoid that this impeachment trial will be declared null and void. I want to avoid walkouts. I want to avoid any delays, Mr. President. Senate President is more than capable. He said he is willing. He said he is ready. He has been in many situations in his life that people say you cannot do it, but he has done well. He has studied. So what's the issue? Why do we have to vote for a presiding officer, Mr. President? Why can't we follow the Constitution? So the point of order, Mr. President, is that amending the rules, implementing a null and void rule, and violating the Constitution will endanger this whole hearing, Mr. President. So please rule on the point of order, and I hope that the Senate President was more than able to preside.
Thank you to the gentleman from the team. Before I express my views on the matter, let me just put into the record the facts on when we amended Rule 2 of the Rules of Procedure on the impeachment trials. On June 3, 2026, Senator Juan Miguel Zubiri proposed Senate Resolution number 430, and that was adopted during that time. And then, on the same day, the same resolution was adopted and renumbered to Resolution number 40. It was published on June 9, 2026 in the Philippine Daily Inquirer as well as Malaya. During that time, in June 3, when we amended the rules, everyone had the opportunity to express their views regarding the proposed resolution. And since no one objected, we adopted Resolution number 430 and renumbered it to Resolution number 40. That is anchored on our Constitution, Article 6, Section 3, Paragraph 8 of the Constitution, that the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. So, my view to the good gentleman, let me just finish, sir. My view is this resolution has been duly approved, and everyone was given an opportunity to discuss that, to object. However, it was no one objected to that resolution, and it was duly approved by the body. So any discussion regarding this resolution should be discussed in plenary when the Senate convenes as a legislative body. In the past precedents, during the era of impeachment, November 15, 2020, the body as well approved the rules of impeachment in
follow our own rules in changing the rules. We cannot follow the rules. Secondly, Mr. President, the impeachment court already adopted our rules. Iba po ang plenary, tama po kayo doon, I agree with you there. Iba po yung impeachment court. So is the impeachment court now hostage or subject to whatever changes the legislative body does, and we will not adapt? Then why did we adopt the rules when we took our oath? We adopted it because the impeachment court is not powerless to talk about our rules. But finally, Mr. President, for the sake of argument, just for the sake of argument, huwag na natin tignan yung mga amendments. It's against the Constitution. So can the impeachment court disobey the Constitution? If the Constitution says the presiding officer should be the Senate President, can we now say na no, pagbotohan natin kung sino? Because if we say that we can, what next? Will we add to the articles of impeachment? Will we lower the bar of the quantum of evidence needed? Will we say that baliwala na yung pre-trial brief at bahala na si Batman? So, Mr. President, I thought that's why we have the rules. Because when we have the rules, it dictates fair play. And the rule says it is the Senate President who will preside. So if now we're not going to follow the rules, anong pinag-uusapan natin patas? Anong pinag-uusapan natin due process? Anong pinag-uusapan natin na fairness? It is who we chose as Senate President is a political. So we made our case na we would have a more fair. You made your case, you got the majority. Now you got the majority. We will give you all the support, Mr. President. But we have to follow the Constitution. We cannot have a trial where we do not follow the Constitution, Mr. President. I think pinaka-basic po yun. Saan sa Constitution po nakalagay, Mr. President, na ang nakalagay dito po, only in case the President, let me give you a hypothetical. God forbid, God forbid may mangyari sa Pangulong Marcos, maging Pangulo ngayon po, si Sara Duterte. My view is tuloy yung impeachment. Pero, ang mag-represent na yung Chief Justice. Kung pwede ba tayo magbutuhan na huwag yung Chief Justice ang huwag yung Chief Justice ang mag-present. So how is it possible that today, we're starting out on the wrong foot by arguing who will preside when the Constitution already settled it, Mr. President? So I appeal to my colleagues. There are a lot of accommodations, there are a lot of things, may bigayan talaga dito. May botohan, may caucus, may in-camera discussions. Pero pagdating kung sino mag-preside na malinaw sa Constitution, huwag na natin pag-awayan. The prosecution is here, I think they're ready. The defense is here, I think they're ready. Let's give the Filipino people, a fair trial. Hindi po fair kung pipiliin natin kung sino ang kahit kung sino magaling, kahit ako piliin yun. Hindi ko po tatanggapin yun kasi mali po yun. Hindi po yun ang nakalagay sa Constitution natin. Very, very clear po sa records ng Constitutional Commission. Walang makaka-amendo. We are not given any latitude on this matter, Mr. President. I appeal to you, Mr. President. This is your Senate presidency.
Thank you for that, those views, the good gentleman from Taguig. Kanina po, nabanggit ko po na in my manifestation as the Senate President, that resolution number 39 for the rules of procedure on impeachment trial as amended shall continue to apply. So in other words po, rin-recognize po nitong impeachment court yung amendments na ginawa po natin noong June 3. At kagaya po ng nasabi ko po kanina, the humble view of this presiding officer is if there are any discussion on resolution number 43 as adopted as resolution number 40, it should be done in plenary because doon po natin in-amend doon po natin in-adopt yung impeachment rules of impeachment, doon rin po natin in-amendahan at nabigyan naman po ng oportunidad ang bawat isa para magkomento, magbigay ng pahayag, magbigay po ng kanilang any comments, any legal opinions, and issues, it should be done through the legislative body of the Senate.
Mr. President, there is no conflict, Mr. President, with your permission. There's no conflict. If you want to discuss it, in 3 weeks may session na tayo. So all we have to do today is follow the Constitution. We recite. Then pagdating ng plenary, then we can debate whether we are allowed to amend the Constitution or not. Because Mr. President, that's why I premise this not as a parliamentary inquiry or as a point of information or whatever we may call it. That's why it's a point of order. A higher point of order than the point of order in the rules is a point of order in the Constitution. The Constitution says it is the Senate President who will preside. So are we saying now, Mr. President, that the rules can amend the Constitution? Is not the ruling of the chair.
Before I make my final ruling on this matter, may I recognize the gentleman from Pampanga, Senator Kiko Pangilinan.
Thank you, Senate President. Mr. President, with all due respect, the Constitution does not provide that the Senate President must resign in cases of impeachment. What the Constitution provides is that when the President is undergoing impeachment and going through the trials, being tried, this Chief Justice must resign. Nowhere in the Constitution, in the provisions on public accountability and impeachment, does it say that the Senate President must resign when the Vice President is overthrown, or any other impeachment officer. And precisely because of this, and precisely because the Constitution likewise allows Congress, not the impeachment court, Congress, to promulgate its own rules, which is what the Senate did in June 3. We proposed amendments to the rules under our rulemaking power, which, by the way, was subsequently ratified when we convened in a special session on June 17. The June 3 journal was ratified unanimously on June 17 when we had our special session. And in the June 3 minutes and the journal, precisely we approved the amendments to the rules. This was further ratified on June 17. Therefore, it is considered regular. The presumption of regularity now comes into force. But having said that, Mr. President, the good gentleman from Taguig has brought this matter before the Supreme Court. And we agree with the point earlier raised by the Senate President. This matter should be either discussed in Senate plenary as a legislative body, or if he has questions which may in fact turn out to be valid, he has brought this matter before the Supreme Court. Therefore, this impeachment court is not the venue for this debate.
let's call someone from UP to see whether they were taught the same thing as Senator Pia. May I ask Senator Pia
We
to
recognize the gentlelady from Taguig, Senator Pia Cayetano.
Thank you, Mr. President. Sa Ateneo UP issue, but always happy to stand before our colleagues and share our experience in the UP College of Law. I was prepared to address this to all our members of the bar in the Senate, but since it is Senator Kiko, my schoolmate, my teammate actually, the Law University, who stood out, I'll also specifically address it to Senator Kiko. So, dear Senator Kiko, and our colleagues in the majority, knowing that you have members in the majority that are lawyers, and for those who are not lawyers, you definitely have consultants who are lawyers. Wala naman siguro isang senator dito na walang consultant na abogado. Kahit ako abogado, ang dami kong staff na abogado din. Why? Because these are legal issues. We need to talk to the experts. Pag-uusapan natin ang mental health, physical health ng Vice President, then of course we will not listen to lawyers. We will listen to doctors, diba? So it's a legal issue. Let's hear what the lawyers have to say. But let me just quote, because I know the Senate President doesn't have time to call on all the lawyers. So when you ask your lawyers, your staff, I'm sure nag-abala sila to look at the constitutional records, to look at the journal. I'm sure. And if they did not, please take your cell phone now and text your staff. What does the constitutional journal, the records of the debate show? Sinabi na po ni Senator Alan Cayetano, you can question him, you can doubt him, ask your staff. May I ask you, dear colleagues, let's do our job well. The same way when you stand up and you tell me to do my job well, and you disagree, I disagree with your point of view, I will listen intently to your point of view. And I'm looking at each one of you because this is our solemn duty. What does the Constitution say? Nakalagay doon, the Chief Justice, but the President. Silent na po sa iba. So sabi ng iba, at yan ang sinasabi ng Senate President natin na mukhang pwedeng iba. So we look at what the constitutional framers said. What did they say? Nagdebate na po sila, colleagues. Nagdidebate tayo dito. Pag sinabi ng sponsor, ito na yung paliwanag, yung nag-i-interpolate at nagbibigay ng amendment, sinasabi niya, okay, yung pala paliwanag ko, okay na ako. No need to amend. Yun din ang sinabi. Let's place ourselves in that position. Because that happens to us every day. Every day. Somebody stands up and says, ano ibig sabihin nito? And the sponsor will explain. Pag hindi maliwanag, sasabihin nung nag-interpolate or nag-amend, ay papa-amend ko kasi hindi maliwanag or I want to improve it. Pero kung nagkaintindihan naman, okay na. Eh yun nga yung binasa, tanongin nyo naman po yung staff nyo. Or let's pause, let's all get a copy. Let's show it. Because this is the foundation of this trial na tama yung nakaupong presiding officer. So that's my first point. Mag-abala naman tayo. Read it yourself, ask your staff to print a copy. In fact, on that note, may I ask Senator Alan's staff to print a copy and give it to all our colleagues. Mabilis lang yan, hindi na yan mapapatagalan. Show it. We can take judicial notice naman po siguro of it. Siguro naman, alam na natin ang ibig sabihin ng judicial notice. You can go to the actual records. Nandito na makakuha naman natin yun kung magdududahin nyo yung ipapaprint ko. So that's my first point. My second point, Mr. President, is addressed to His Honor. If His Honor will insist that we have to call a regular session, we have to be in session to amend the impeachment rules. Hindi, tawagan niyo po ang Malacanang. Nagpa-special session naman po siya, di ba, with all due respect, to pass the national orbit law. To pass, what else? Tatlo yun eh. Oo nga, yun na. Yung waling-waling national orbit, ano pa yung dalawa? No, I know, I'm not questioning it. I'm saying that there was a special session called to pass 3 laws. Naalala ko yung waling-waling because I love it. This is important. O ano pa yung dalawa? Unfortunately, hindi ko na maalala. majority-minority botohan. Ayusin natin yung pagboboto natin dahil pinapanood tayo, pinapaniwalaan tayo, umaasa sa atin ang taong bayan. Maraming salamat po.
Once again, it is, again, before I did share rules, let me acknowledge the former Senate President, Senator Tito Soto.
Thank you, Mr. President. Tama-tama yung sinabi ng distinguished lady from Taguig, tanongin daw ng legal stock. Binigay nga sa akin ng legal stock, for example, Article 11, Section 6, page 154. The Constitution is silent regarding the presiding officer of Senate impeachment. However, expressly provide, the Constitution expressly provides that the Chief Justice will preside if President is on trial. O ngayon, yung mga graduate ng Ateneo at saka ng mga UP, ito ngayon yung legal maxim. Expressio unius et exclusio alterius. In other words, the express mention of one thing is the exclusion of another. Okay, maintindihan nyo lahat ngayon. Itong akin sa publiko yung sa akin. Ang sinasabi ng publiko ngayon, nanonood sa atin, dapat you should not resort to too much technicalities kasi ang public interest ang iniisip nila rito. They want to expedite the proceedings. They want the trial, not rules. They're interested in the trial, not rules. In the interest of justice, sabi nga nila, sometimes rules are not sacrosanct. But itong nangyayari dito pa ang publiko ang importante rito. Where does the Constitution emanate from? From the public, from the people of the Republic. So, decision na nila ito, Mr. President, para matapos na.
Mr. President, can I have
Again, once again, let me reiterate the position of the chair. My humble position is that this matter should be discussed during plenary when the Senate is convened as a legislative body. And may I ask the gentleman of the gate if he is objecting to this position?
I'm objecting to the position and will call for a vote. May I explain? I think up to the rules I can explain why I'm asking.
We'll go for a vote first, and then we'll allow.
Mr. President, under the rules I can explain why I'm calling for a vote first, so that I can convince them to vote for.
Under the rules, there's an objection. The vote will proceed without any explanation, and after that, we will allow the gentleman from the gate to explain his vote.
Mr. President,
We call for a division of the House. So those who are
Mr. President, when you object, you're allowed to explain your objection. And
Senator Lacson is recognized.
Your Honors, pursuant to Rule 2 of the Rules of Procedures on Impeachment Trials as amended, I move to elect Senator Judge Francis Joseph Guevara Escudero as the presiding officer of this court.
objection, Mr. President, and may I allow
We proceed.
objection, Mr. President. I'm allowed to object and I'm allowed to
Yes,
explain
you're
my
allowed to
objection.
object. You're allowed to object, but we proceed
Mr.
with the
President.
division
Mr.
of the House.
President, point of
For
order.
those who are
Point of order,
Senator shall, under the same oath taken on May 18, 2026, immediately assume and exercise all powers, functions, duties, and prerogatives pertaining to or vested in the person presiding over the impeachment trial under the rules of procedure on impeachment trials, as amended, and shall give full effect to the powers inherent to the courts under Rule 135, Section 5 of the Rules of the Court.
President, may I now explain my vote?
You're allowed to explain your vote.
Mr. President, first of all, we cannot violate the Constitution. We put the whole impeachment trial at risk here. What Senator Tito Soto, former Senate President, what his staff did not tell him is that there is such a thing as procedural due process, and that who presides goes into due process and fairness. The Latin term that he mentioned was for enumerations. That when there are enumerations at hindi kasali doon, in this case, there was a statement that in only one case it would be the Chief Justice, because member of the Constitutional Commission who became Chief Justice the day there was going to amend precisely on the Constitution to state the Senate President shall preside. But upon explanation by the sponsor that it is understood that it is the Senate President, then it should be the Senate President. And dun sa sinabi ni Senate President Soto na ang gusto ng tao ay mag-umpisa na, precisely, kanina pa dapat tayo nag-umpisa kung nag-preside ang Senate President. Secondly, this is when you have threshold issues, issues that go into due process fairness. If we're going to say that ang gusto ng tao i-convict na lang, then let's just blurt it out. Now, if we're going to say we want a fair trial, let's make sure that every aspect of this trial is fair. So that's why, Mr. President, if you read the rules, the presiding officer shall have the power to make and issue by himself or by the Secretary of the Senate all orders, mandates, writs, authorized by these rules of the Senate, and make and enforce such other regulations, orders, premises that the Senate may authorize or provide. Nandito din, Mr. President, that the Senate President may by himself or bottom line, Mr. President, pwedeng mag-decide ang Senate President o sa atin. And Mr. President, there are issues that goes into fairness. You know, the AMLA will be a witness here. And I have information that the 20 years AMLA records of Senator Escudero and his credit cards and bank accounts were all opened up in the office of the Senate President, where members of the Blue Ribbon Committee was here. Then we're going to ask him to preside. So there's a problem. This is my explanation. This is my explanation. This is factual and this is my explanation. So I will stop there.
With all due respect, your statements are already out of order. It has nothing to do with the topic on hand. And the presiding officer will strike off.
It has all to do with this.
Will strike off
It has all to do.
the statements
Mr. President,
pertaining to Senator
Mr.
Escudero.
President, kaibigan ko si
I
Senator
direct the
Escudero.
stenographers
with that clarification that in all other cases, it would be the President of the Senate who will resign, I withdraw the amendment. Kaya clear sa Constitution that in all other cases, the President of the Senate will decide. Wala, hindi ho applicable dito yung excluso unios. Hindi ko na-memorize yan kasi I graduated in 1991. And we took that up in 1987. But the phrase is, pag hindi kasama, excluded. Hindi po applicable yun. With all due respect to our former Senate President, it is the intention of the framers that matter. I will ask the page to help me distribute this among our colleagues. I have also asked our staff to actually copy. I am environmentally friendly, so ayoko sana ng papel. Pero alam ko na hindi po lahat sa atin ay gumagamit ng digital, ng electronic gadgets, kaya pinapil ko na lang. Pero kailangan ko pakita sa inyo yung mismo nasa journal. Yan din yun. Yan din yun, my dear colleagues. Yun lang hiling ko sa inyo. Intindihan naman natin yung nandito. Pumoto na. Pero intindihan naman natin. This is just the first day. We cannot disregard the Constitution, and I continue, Mr. President. We have enough jurisprudence, more than enough, to explain to us, even in layman's terms, what basic legal principles are. And one of the most fundamental principles of constitutional construction states that we give effect to the intents of the framers of the Constitution. With this vote, did we give effect to the intentions of the framers of the Constitution? Sinabi nga Senate President ang magpe-resign. Hindi na siguro napakating bagay yun dahil kahit sinong ipalit nyo, maayos naman ang mga kasama natin sa colleagues natin, maayos naman. Hindi ko yun ang point. The point is, what are we required to follow? That's why may Constitution. And I will now state for the record a few cases that point out that this is what we are supposed to do. Give effect to the Constitution. Lambino versus Commission election in GR number 174153, the Supreme Court looked explicitly to the Constitution Commission deliberation to determine the nature of people's initiative. Because the text was debated, the court used the framers' explicit intention. I repeat, the court used the framers' explicit intention revealed in the plenary debates to prevent deceptive or misleading petition processes and establish a stringent full text requirement. So anong ginawa sa kaso? Tinignan ang intent ng framers of the Constitution. Another case, Calderon versus Carale, GR number 9163. God bless his soul. Si Team Carale was my team. And Senator Ivys as well. Senator Kikos as well. He was with my father in the University of Michigan. So articulated a definitive rule. The fundamental principle of construction is to give effect to the intent of the framers of the organic law and of the people adopting it. Dear colleagues, I can stand here and read more cases to all of us. We have law students. We have freshman law students. We have fresh graduate. We have bar reviewees listening to us. Tapos tayo pa lang, hindi natin mabigyang mahalaga ang very clear legal principles. Pati yung prosecution and defense, nakikinig. Sana po, huwag niyong abalahin yung oras namin. Bigyan niyo naman kami ng maliwanag ng mga arguments ninyo because we are willing to listen. Pero colleagues, patunayan naman natin that we are willing to listen. Hindi yung pagpasok natin, nag-prejudge na tayo. Kasi sad to say, mukhang ganun. I tell you, there will be times I probably will not vote with the minority because I believe tama yung sinasabi ng majority. Sana po, yun ang pakita natin sa taong bayan. So, hindi ko na abalahin yung time. Kakaupo pa lang ng bagong presiding officer, pero ang dami pang kaso that says, look at the intent of the framers of the Constitution. And today, we disregarded the intent of the framers of the Constitution. Magandang hapon po. Ngayon ang pag-uumpisa ng hearing na ito.
We know the remarks of Senator for the introduction of the resolution with their explanation of the vote. What is the pleasure of Senator Judge Soto?
I'd like to explain my vote also, Mr. President.
The gentleman may proceed and he has 2 minutes.
I
And maybe like to the timer.
have one line to say that's the reason I voted in favor. Because the minutes of the Constitutional Commission are merely research source.
What is the pleasure of the Honorable Padilla? Will the gentleman explain his vote? The gentleman may proceed. You have 2 minutes, sir.
Maraming salamat po, Ginoong Punong Tagapamahala. Mga mahal kong kasama, sa loob po ng 4 na taon na ako po ay ibinoto ng ating mga kababayan at nagsilbing senador, ako po ay naging tagapangulo ng komite ng Constitutional Amendment. At tuwing meron pong pagdinig, ang lagi po naming pinapatawag ay yung mga sumulat ng konstitusyon bilang sila po ang nakakaalam kung ano ang puso, ang diwa ng konstitusyon. Malinaw po na kung meron tayong pakikinggan ay yung creator, di po ba? Tayo naman po lahat ay naniniwala sa Panginoong Diyos, kaya tayo po ay naniniwala sa salitang creator, tagapaglikha. At ang lumikha po ng konstitusyon ay itong mga taong nabanggit sa ipinamahagi ng ating mahal na Senadora Cayetano. Malinaw po dito, nasabi na po sa English ito. Mainam po ay sabihin po natin sa Tagalog upang mas maintindihan po ng ating mga kababayan. Hingi po ako ng tulong sa Google kasi legal terms po ito. Hindi naman po ako nagtapos sa UP, hindi rin po ako nagtapos sa Ateneo, nagtapos po ako ng criminology at UP rin sa University of Quezon. Ang sabi po dito, sa Tagalog po, Ginoong Presiding Officer, eksakto ko itong hinihain dahil nagkaroon tayo ng pagkakaiba pagdating sa punong maestrado ng Korte Suprema. Ngunit sa paglilinaw na iyon, na sa lahat ng ibang mga kaso ay ang Pangulo ng Senado ang mamumuno. Kaya binabawi ko ang nasabing susunod. Ang nagsabi po nito ay ang dating Justice David. Ngayon, mga mahal kong kasama, sa ang saligang batas ay sana po ay panghawakan natin. Ngayon, sa loob po ng 4 na taon po dito, lagi pong sinasabi yung tradisyon. Minsan, yung rules na yan, nawawala yan. Ilang beses na ako naguluhan dito dahil teka, sundin natin yung tradisyon kaysa yung rules. 2 beses na po nagkaroon ng impeachment. Yung unang impeachment, ang nag-preside ay Chief Justice kay Pangulong Estrada. Yung sumunod po, nandito na po ako nun. Ang nag-preside ay ang mahal na Bicolanong kaibigan ko, Senador Jesus Poder. Yun po kasi yung nasasabi sa saligang batas at tradisyon. Yun na po yung nangyari. Ngayon, gusto ko pong tanungin yung mga kasama ko sa majority. Personal na tanong ko ito. Nung hinihikayat po akong sumama, majority, lang ang sinabi ko. Kung si Senator Jesus Codero ang kababayan kong Bicolano ang gagawin yung Senate President, lilipat ako sa inyo. Ang hindi ko maintindihan, bakit ngayon pinipilit natin na ang ating presiding officer eh si Jesus Codero? Eh ba't hindi natin siya ginawang Senate President no? Yun lang po ang tanong ko. Maraming salamat.
The remarks of the gentleman is noted. Senator Marcos, what is your pleasure? The lady may do so. You have 2 minutes, ma'am. Kindly be mindful of the clock.
Yes, thank you very much. Ang sabi sa atin ng bata tayo, kapag mali ang umpisa, mali na ang lahat na susunod. Ayoko naman magkamali sa umpisa pa lamang na napakahalagang paglilinis na ito. Unang-una, paulit-ulit na nating sinaan na ang ating saligang batas ay hindi maaaring magtutin. At napakaklaro nito at ang sinasabi ng ating Constitution of 1987, Article 11, Section 3, number 6, all other impeachable officers. Ang sinasabi, carving out therefore the exception that proves that rule, that the Chief Justice is the single exception and otherwise the presiding officer should be the Senate President. It is the exception that proves the rule. Palibasa na uso ang Latin, may kabaliktaran din sa kinote ni Senator Soto, expressio unius es exclusio alterius. Palibasa, hindi naman in-exempt, ibig sabihin na laging dapat ang Senate President ang presiding officer. Ikalawa, nakita naman natin ang mga debate, ang listahan ng mga sinabi at paliwanag nung dating Chief Justice natin, si Mr. Davide, noong panahon ng convention. Contextual reading and thorough debate do not allow for any interpretation whatsoever. And we should abide by that. Ikatlo, yung kaduda-dudang forum noong June 3 na pinapaliwanag ng aming minority leader na hanggang ngayon nakatenga pa rin. Kung tutuusin, nung sinasabing na amyenda, yung Senate, yung Supreme Court petition ay pending pa. Kaya hindi karapat-dapat na yun ang sundan. Ikalima, it's not the impeachment court but the Senate that amended the rules. Kaya para sa akin, napakaraming dahilan. Huwag sana nating sayangin itong napakahalagang responsibilidad natin at huwag mag-umpisa sa mali itong paglilinis. Maraming salamat.
Thank you, Senator Marcos. Duly noted and entered into the records. The pleasure of Senator Ligarda. Senator Judge Ligarda.
Thank you, Mr. Presiding Officer. Where the Constitution is cited,
You will explain her vote. Make a
it's
manifestation.
a manifestation, which
You may proceed with the
seems like a
manifestation.
manifestation vote. Thank you. Where the Constitution is silent, the intent of the framers should guide the choice of the presiding officer. Any departure from the traditional arrangement must be approached with caution, as it may place the validity and the legitimacy authorities, including the authority of the body then that adopted Senate Resolution number 430. This manifestation is made to place on record that we are not yielding our position in the pending case and is without prejudice to the final determination of the Supreme Court. Thank you, Mr. Presiding Officer.
Thank you, Senator Duterte. The presiding officer would like to make a statement. Sa mga ginagalaang mong kapwa, Senator Judge, sa ating mga minamahal na kabayan, sa mga partido sa kaso na kabitbit ngayon sa Senado, isa pong maganda at pinagparang hapon sa ating lahat. Sa araw na ito, muling gagampanan ng Senado ang isa sa mga pinakasagradong tungkulin iniatas ng saligang batas. Ang pag-upo natin bilang isang impeachment court para litisin at husgahan ang pangalawang Pangulo. Kinikilala ng ating saligang batas na may mga opisyal na may hawak na kapangyarihan at pananagutan na napakabigat para sa kanila lamang itinakda ang impeachment bilang tanging paraan para sila ay panagutin. Article 11, Section 2 of the Constitution enumerates these officials: the President, the Vice President, the members of the Supreme Court, members of the Constitutional Commissions, and the Ombudsman. They are not ordinary public officers. According to the late former Senate President Juan Ponce Enrile, they hold, quote, the highest and most sensitive offices of government. They may be removed from office only upon conviction for offenses of the highest constitutional gravity: culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of the public trust. Impeachment is a means to preserve constitutional government through the removal and disqualification, if so warranted, of an unfit official from a position of public trust. 5 opisyal pa lamang ang na-impeach ng Kamara de Representantes sa ating kasaysayan sa ilalim ng 1987 Constitution. Una, si dating Pangulong Joseph Estrada noong 2001 na ang paglilitis ay naungusan ng mga pangyayaring humantong sa EDSA 2. Ikalawa, si Ombudsman Mercy Gutierrez noong 2011 na nagbitiw bago pa man mabuksan ang kanyang paglilitis ng Senado. Ikatlo, si Chief Justice Renato Corona noong 2011 din na nilitis na patunayang nagkasala at inalis sa tungkulin ng impeachment court bilang punong maestrado. Ika-apat, si dating COMELEC Chairman Andres Bautista noong 2017 bagamat nagbitiw siya sa pwesto bago pa man mapadala ang articles of impeachment sa Senado. At ika-5, si Vice President Sara Duterte noong 2025. Subalit ang nasabing articles of impeachment ay idineklara ng Korte Supremang null and void ab initio kung kaya't ito ay in-archive ng Senado. Siya ay muling na-impeach sa kasalukuyang taon at ngayon naharap sa paglilitis na ito. Ipinakikita lamang na may tala nito na ang impeachment ay hindi isang pangkaraniwang kaganapan. Turing nga ng Korte Suprema, quote, it is the most difficult and cumbersome mode of removing a public officer from office. Subalit, ang paglilitis na ito ay hindi lamang hindi pangkaraniwan. Ito ay tunay na bukod-tangi. Bakit? Una, si Vice Presidente Sara Duterte ang kauna-unahang opisyal na 2 beses na na-impeach ng mababang kapulungan. Pangalawa, siya ang kauna-unahang Vice Presidente na haharap sa paglilitis ng isang impeachment court at pangalawang opisyal lamang na halal ng sambayanan na sasailalim sa prosesong ito. Pangatlo, siya ay hinahalal ng may pinakamalaking mandatong pinagkaloob ng sambayanang Pilipino sa sinumang kandidato sa ating kasaysayan. Mahigit 32 milyon o 61% ng kabuuang boto para sa ikalawang Pangulo. Pang-apat, ang articles of impeachment laban sa kanya ay inendorso ng 277 na miyembro na kumakatawan sa ating mga mamamayan mula sa iba't ibang distrito at sektor at ng ating bansa, na katumbas ay mahigit 80% ng kabuuan ng Kamara de Representantes. Terminating an elected mandate before the end of its term is among the most drastic acts our constitutional democracy can undertake. This is why the trial must be guided with prudence, tempered by caution,
and marked with unquestionable impartiality. We must avoid even the appearance of impropriety and observe the cold neutrality of an impartial judge at all times. May I therefore caution my fellow senator judges, the prosecutors, the respondent, and their respective counsels and witnesses to refrain from making any comments and disclosures to the public pertaining to the merits of this trial as mandated by the impeachment rules itself. Let us heed the words of the Supreme Court that said, impeachment is not a chance to settle political scores. It is not a stage for political theater or personal attacks. Because when the focus shifts to the person rather than the alleged wrongdoing, the process loses its integrity. As presiding officer, I shall do my part to uphold the fairness and integrity of this process and shall see it through to its proper conclusion. I would like to thank my colleagues for their trust and confidence. I did not seek nor did I ask for this responsibility, but neither will I shirk from fulfilling this duty without fear or favor. This now brings me to the threshold questions that will guide the conduct of this trial and the rulings of the chair. First, what is the number of votes needed to convict the respondent? Second, what is the quantum of proof required to sustain a judgment of conviction or acquittal in these proceedings? Third, how strictly or liberally will this court apply the rules in resolving questions of procedure and evidence? On the first issue, the Constitution provides that no person shall be convicted without the concurrence of two-thirds of all the members of the Senate. With 24 members of the Senate, a literal interpretation of this means that conviction requires the affirmative vote of at least 16 senator judges. This literal interpretation finds direct support in the 2000 case of Bayan versus Zamora, which concerned the Senate's compliance with the two-thirds vote required to concur in a treaty. Despite having only 23 incumbent senators at that time, then Senator Gloria Macapagal Arroyo was elected as vice president. Therefore, there were only 23 senators. The court held the charter provides that the Senate shall be composed of 24 senators. Without a tinge of doubt, two-thirds of the figure, or not less than 16 members, is an unquestionable compliance with the requisite number of votes mentioned in Section 21 of Article 7. It behooves, therefore, all of us to observe the same fidelity with the Constitution in this trial, which affects not only the mere ratification of a treaty, but more so affects the substantial rights of the respondent, as well as the sovereign will of the people as expressed in the overwhelming mandate given to her. This is the prevailing law today, and whether we agree with it or not, we must abide by it. However, those who disagree are not without recourse, because this is without prejudice to the right of any party who holds a different view to seek judicial relief. And should the Supreme Court, who possesses the sole authority to interpret the Constitution, by virtue of its power of judicial review, render a different ruling on this question other than what the chair has stated, this court and this representation shall faithfully abide by that ruling of the Supreme Court. On the question of quantum of proof, given that impeachment is a sui generis constitutional proceedings, the standards of proof that govern administrative, civil, and criminal proceedings do not apply. However, this does not mean that senator judges shall rely solely on their conscience in deciding this case. No less that the Supreme Court also said that, quote, decisions regarding whether to acquit or convict must be based upon clear charges supported by sufficiently clear and convincing evidence. Furthermore, let me be clear that the burden of proof in these proceedings rests upon the prosecution. It does not and will not shift. The respondent is afforded the presumption of innocence and has no obligation to disprove the charges against her. Finally, we turn to the application of the rules of court in these proceedings. Rule 1, Section 6 of the Rules of Courts provide that the rules shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. We are also guided by the Supreme Court's Bench Book for Trial Judges, which reflects a long-standing principle of adjudication. In case of honest doubt about the admissibility of evidence, it is a better policy to rule in favor of admission and let the senator judges decide whether to give it little or no weight when deciding upon the case in the final outcome. But let me be clear. A liberal construction of the rules is not a license to ambush the opposing party, bypass due process, or introduce unverified evidence that would prejudice the fair and orderly conduct of this trial. Accordingly, consistent with the demands of due process, fair play, and the orderly administration of justice, the chair will construe the rules liberally so that, number one, the prosecutors may be able to adequately present their case, that the respondent may be able to rigorously test it. Number three, that the senator judges may be able to weigh the evidence for themselves. And fourth, so that the Filipino people may hear the whole and impartial truth regarding the allegations against the Vice President. Let us remember what our oath requires us, to do impartial justice according to the Constitution and the laws. Hindi po tayo nandito upang itaguyod ang anumang pampolitikal na agenda. Hindi tayo narito upang paglingkuran ang kagustuhan ng alinmang panig. Narito tayo upang alamin ang katotohanan at sa pamamagitan nito, mapairal ang hustisyang walang kinikilingan. Ang tungkulin natin bilang mga hukom ay hindi maaaring talikuran. Sa gitna nito, batid ko ang mga problemang kinakaharap ng ating bayan na patuloy natin dapat pa rin pagtuunan ng buong pansin at hanapan ng solusyon. Tayo ay mga senador bago tayo umupo bilang mga hukom at mananatili tayong mga senador na patuloy na magsusumikap na tugunan ang mga pangailangan ng ating mga kababayan bilang Senado at hindi mababago ito. Kaya't aking hiling at dalangin na huwag sana malunod ang diwa ng pagkakaisang nagbigay sa atin gaano man katindi ang mga debate at pagtatalo sa hukumang ito. Dahil anuman ang magiging kalabasan ng paglilitis na ito, laging kinakailangan ang Senadong nagkakaisa. Dalangin ko po na sana pagkalubad tayo ng katatagan, karunungan, pagpapakumbaba at pag-unawa upang magampanan nating lahat ang ating tungkulin bilang mga hukom. Pagpalain na po lahat sana tayo ng buong may kapal. Maraming salamat at magandang hapon po.
Sir Presiding Officer.
Before we continue, Chair would like to make of record that Senator Joel Villanueva will insert his explanation of vote into the records. If there are no objections, Chair dispenses with the reading of the minutes of the Journal of the May 18 Proceedings, 2026, and consider the same as approved. Ma'am, on the motion? There being no objection, Journal is hereby approved. Senator Gaetano?
Sir President, let me thank you and just make the manifestation that this representation believes that it is a threshold issue, the number of senators to convict and two-thirds logical, fair, that would give justice to the Constitution 16. So I thank you for that statement. And as you mentioned, it is a statement of the court, not only of the presiding justice, because napaka-importante na sa umpisa pa lang, alam na ng prosecution at alam na ng depensa kung ilan. Having said that, Mr. President, as to the issue of the presiding officer, not to take up more time, I'd like to register a continuing objection, but instead of giving my arguments, may I submit it in writing, right? Basically saying that violation of the Constitution is not a technicality. But if our dear colleagues will allow, we will just submit it in writing, Mr. President.
The
Whoever wants to
continuing
join.
objection of the gentleman is noted, and he may so submit his extended written explanation in writing for the record. Senator Gaetano?
Thank you, Mr. President. Just a few administrative matters with your indulgence, dear colleagues.
The lady may proceed.
Thank you. I read that we have rules for our resource panel and also our prosecution and defense that no drinks and food allowed. May I respectfully request that they be allowed to have water. It's a basic human right naman siguro na makainom ng tubig. I read something. I'm just saying, I saw rules. I'm making clear because knowing them, they will follow our rules, and I think it's not right to not allow drinks. And then, there may be some who are pre-diabetic or diabetic and need to eat something. So, if they have to have crackers or whatever it is that they need to have, I think we should allow them to do that, Mr. President. Sama-sama ko na yung rules ko, Uh, and then they should also be allowed to have a bathroom break. I don't want them to also, may ibang klaseng sakit naman yung hindi nakakapunta sa banyo. So may automatically be allowed. I think they're responsible enough to, they're a whole team. There's like a dozen of them here. And then finally, sitting is the new smoking. May we also allow them without them having to ask for permission to stand up, stand in the back, and to stretch their legs, because it is not healthy to be sitting down for 2, 3, 4 hours, and I think our hearings will go on for a long time. So that's my humble submission for the health and wellness of our prosecution and defense panel. Thank you, Mr. President.
Noted, and we will discuss the matter with the parties. Senator Pangilinan.
Yes, Mr. President, if I may be likewise allowed to submit a written explanation of my vote, particularly on the matter of referring to the Constitutional Commission when the debates of the Constitutional Commission, Mr. President, where I believe there is a contrary opinion, which the Supreme Court, in fact, ruled in previous rulings, the Chavez case. For the record.
Noted, the gentleman may do so. If there are no other matters, we now proceed to trial. The clerk of court will please call the case before this impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances for the prosecution.
Good afternoon, Your Honors. We are 11 House prosecutors and 15 private prosecutors. I am Representative Cherville Jinky Pitrix Luistro, appealing for the prosecution. We are ready, Your Honor.
May we get the names of the other panel of prosecutors as well as the counsel for prosecutors one by one for the record?
Good afternoon, if Your Honors, please. We have already submitted the names of the public and private prosecutors who have formally entered their appearance. Ako po si Representative Jose Manuel I. Diokno, magalang pong humaharap sa Senate Impeachment Court. Ready po.
Noted.
Good afternoon, Your Honors. I am Representative Laila De Lima from the Mamamayang Liberal or ML party list, respectfully appearing as public prosecutor. We're ready.
Good afternoon, Your Honor. I am Congressman Joel Chua, respectfully appearing for the public prosecutor representing the 3rd District of Manila.
Good afternoon, Your Honors. I am Arlene Kakabagaw from Dinagat Islands, representing the public prosecutor right here.
Good afternoon, Your Honors. I'm Representative Lawrence Rivera Defensor from the 3rd District of Iloilo, respectfully appearing as public prosecutor.
Good afternoon, Your Honors. Representative Jonathan Keith Flores of the 2nd District of Bukidnon as public prosecutor, Your Honor.
Good afternoon, Your Honors. Representative Isabel Maria Jorge Zamora from the Lone District of San Juan City as public prosecutor.
Good afternoon, Representative Terry Don of Bicol Saro Party List. We are ready, Your Honor. Maraming salamat po.
Good afternoon, Your Honors. Representative Ramon Rodrigo L. Gutierrez of One Red Party List, respectfully entering appearance for the public prosecution.
Good afternoon, Your Honors. Representative Lordan Swan of the 1st District of Cagayan de Oro City, respectfully appearing for the prosecution.
For the record and for the information of our prosecutors, the term used in our rules for the public prosecutors, as you so mentioned, should be panel of prosecutors of the House of Representatives, and insofar as I've been hearing the term private prosecutors, the private lawyers will be referred to as counsel for the prosecutors. You may proceed.
Good afternoon, Your Honors. I'm Attorney Lorna. Good afternoon, Your Honors. I'm Attorney Lorna Pataw Kapunan, counsel for the prosecutors under the control and supervision of the panel of prosecutors from the House.
Magandang hapon. Ako po si Attorney Amando Virgil D. Ligutan ng Sapayan Lim Alvarez and Ligutan Law Offices or sa Legal Law from Cebu City. We are under the direct control and supervision of our honorable prosecutors from the House of Representatives. Ready, Your Honor.
Good afternoon, Your Honors. I am May Sancho Divina Gracia of the Co and Divina Gracia Law Offices, and I am respectfully entering my appearance as counsel for the prosecutors.
Your Honors, good afternoon. I'm Attorney Lino Chris Patao-Kapunan, respectfully appearing as counsel for the prosecutors, acting under the direct control and supervision of the panel of prosecutors of the House of Representatives.
Good afternoon, Your Honors. Attorney Sonia Castillo, private prosecutor, under direct control and supervision of the public prosecutors. We are ready, Your Honor.
Good afternoon, Your Honors. Attorney Dina Melissa Lorenzo Singyan for counsel for the prosecutors. We are ready, Your Honor.
Good afternoon, Your Honors. I'm Attorney Marford T. Fua, appearing as counsel for the panel of prosecutors. Good afternoon. We are ready, Your Honor. Counsel for the prosecutors. We're ready to proceed today, Your Honor.
Good afternoon, Your Honors. I'm Attorney Reynaldo Robles of the law firm of Chan Robles and Associates, appearing as counsel for the prosecutors under the control and supervision of the public prosecutors. Ready, Your Honor.
Good afternoon, Your Honors. Bettina Nepomuceno Zamora, respectfully appearing as counsel for prosecutors. We are ready.
May it please the court, Attorney Duterte, appearing as counsel and under the control and supervision of the House panel of prosecutors.
Good afternoon, Your Honors. Attorney Benjamin Siguatolosa Jr., respectfully appearing as counsel for the prosecutors, acting under the direct control and supervision. The prosecution is ready, Your Honors.
No other NGO appearances? Is it? How many in all, Representative Luistro? 11 on the part of the House insofar as the panel of prosecutors is concerned, and
We understand, Your Honor, that only 13 private prosecutors entered their appearance today. Nevertheless, Your Honor, as manifested by the Honorable Jokno, the written entry of appearance has been filed already with the Honorable Impeachment Court.
nevertheless, as they appear or will be participating in the trial, kindly inform them to enter their formal appearance during the trial.
Your Honor, the entire 15 private prosecutors have filed already their written entry of appearance with the impeachment court. The articles of impeachment will be presented by 4 separate teams, Your Honor. That explains why the House prosecutors or the panel of prosecutors are joined by 15 private prosecutors, Your Honor.
Noted. Thank you, ma'am. Senator Cayetano, what is the pleasure of the lady from Taguig?
Yes, Mr. President, I just have a question for the prosecution panel. I understand that there is no requirement for the members of the House who form part of the prosecution to be lawyers. But may I know if they are all lawyers, and if some are not, may we know who are not lawyers? Thank you.
Your Honor, all the 11 House prosecutors are members of the legal profession.
Does that satisfy the Senator Judge?
Yes, I was just curious, Mr. President, because it's not a requirement, so I was just curious if, in fact, they are lawyers. Thank you.
Duly noted. The response of the lead prosecutor is duly noted.
Your Honor, may I just enter a correction to the earlier manifestation?
The lady may proceed.
Instead of 13, 14 private prosecutors are able to enter their appearance today. Nonetheless, all the 15 have filed their written entry of appearance with the impeachment court, Your Honor.
Appearances for the respondent.
Good afternoon, Your Honors. I am Sheila Sison, respectfully appearing for Vice President Sara Duterte. With the permission of the court, my co-counsel will enter their respective appearances.
You may proceed.
Gregorio Weiner Pasa II.
Christine R. Ferrer for the Vice President.
Good afternoon, Your Honors. Michael Wesley Poa for the Vice President.
Good afternoon, Your Honors. Carlo Joaquin T. Narvasa for the Vice President. Good afternoon, Your Honors. I am Mark C. Viluan for the Vice President.
Good afternoon, Your Honors. Justin Nicole P. Goulart for the Vice President.
Good afternoon, Your Honors. Lyndon Miguel C. Bacuel for the Vice President.
Good afternoon, Your Honors. I am Ralph Borja Bodota for the Vice President.
Good afternoon, Your Honors. Roberto Nervasa Batongbacal for the Vice President.
Good afternoon, Your Honors. David Ronel Angoli VII for the Vice President.
Good afternoon, Your Honors. Carol Grace G. Oroseo for the Vice President.
Good afternoon, Your Honors. Clarlene Radok for the Vice President.
Good afternoon, Your Honors. Francesca Marie V. Flores for the Vice President.
Good afternoon, Your Honors. Miguel Carlos Albar Fernandez for the Vice President.
Chair notes the entry of appearance. The counsels for respondent Vice President Sara Zimmerman Duterte and Chair likewise notes that the Vice President is not physically present but represented more than adequately by her counsels who entered their appearance. On May 19, 2026, the court, pursuant to Rule 7 of our rules, issued the summons to Vice President Sara Zimmerman Duterte to answer to the articles of impeachment. On May 20, 2026, the Sergeant at Arms served the summons of the Vice President and made a return of service under oath before the Secretary of the Senate. Let the return be entered at large into the records pursuant to Rule 8 of the Rules of Procedure on Impeachment Trials. So ordered. Likewise, the court received pleadings, comments, manifestations filed by the parties. All such pleadings, comments, manifestations, and requests filed by the parties, as well as all issuances and orders of the clerk, as well as the clerk of court, made through the presiding officer, are hereby deemed read into the records of the case. So ordered. At this juncture, the chair would like to direct the parties to prepare for their opening statements. We will start with the prosecution. May I know from the prosecution who will deliver the opening statement, and from the respondent who will deliver the opening statement? Under our rules, only one lawyer shall deliver the opening statement for either side. I presume Representative Luistro, you will deliver for the prosecution and for the part on the part of the respondent?
I will deliver the opening statement for the defense, Your Honor.
Representative Luistro from the panel of prosecutors of the House of Representatives is now recognized to deliver her opening statement for the prosecution. You may proceed, ma'am, and you have 15 minutes.
Your Honor, before I proceed, the prosecution respectfully moves for the reading of the 4 articles of impeachment and the entry of the corresponding answer or plea for each article of impeachment, Your Honor. Your Honor, this is consistent to the Senate rules on impeachment, particularly Rule 7, Your Honor, the last paragraph of which mentions about failure to appear, failure of the lawyer to appear, and failure to file answer. There should be an entry of plea of not guilty. Likewise, Your Honor, under Rule 9 of the Senate Rule of an Impeachment, which says that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. In this rule, Your Honor, it was likewise provided that the name of the person appearing in behalf of the respondent should be entered into the record. And by the answer, Your Honor, it is humbly believed that it pertains to the particular plea of whether guilty or not guilty of the respondent, Your Honor. Likewise, Your Honor, under Rule 22, 21, Your Honor, the trial of all the articles of impeachment shall be completed before the senators vote on the final question of whether or not the impeachment is sustained. It is gleaned from these rules, Your Honor, that the senators will be voting on a per article basis, Your Honor. And that is why it is the humble submission of the prosecution that there should be reading of the article and entry of the particular plea per article, Your Honor. This likewise, Your Honor, manifests our complete adherence to the mandate of the Constitution sa pagbasa po ng mga artikulo ng impeachment at pagpapasok ng sagot ng respondent. Maipakita po natin sa sambayanang Pilipino ang ating pagsunod sa mandato ng Konstitusyon. Likewise, Your Honor, it upholds due process not only of the respondent but also of the Filipino people. Sa pagbasa po ng mga artikulo ng impeachment, she will be informed of the nature of the accusation against her bago pa po siya sumagot whether she is guilty or not guilty, Your Honor. Likewise, Your Honor, ang 4 na artikulo po ng impeachment ay nakabase sa iba't ibang alegasyon ng facts at iba't ibang nature of accusation or cause of action, Your Honor. And with that, Your Honor, it is perceived that there's a possibility that the plea of the respondent to each and every article will be different from one another, Your Honor. And lastly, Your Honor, this is consistent with the Senate rules on impeachment because the senator judges, the honorable senator judges, Your Honor, will be voting on a per article basis after the conclusion of the trial of this impeachment case, Your Honor.
Chair will respond. Unless the counsel for respondent would like to say something about the motion of the distinguished lead prosecutor.
Yes, Your Honor, may I comment?
The lead may proceed.
Before the presiding officer can rule on the motion or request of the lead prosecutor. But before I give my comment, may I just clarify if the lead prosecutor is now making a motion to arraign the respondent accused.
Your Honor, whether this is arraignment or otherwise, the motion of the prosecution is very much consistent with the Senate rules on impeachment.
I think the question, Your Honor, is very simple.
As I have mentioned, Your Honor,
yes or no, Your Honor.
Rule 7,
Is the lead prosecutor,
Rule 9,
is the lead
Let this
prosecutor
not be a debate between the
requesting
counsels.
for the respondent accused
Counsel
to be
for
arraigned, Your
respondent, kindly make your comments and asking questions from the counsel prosecutor. We will recognize the counsel for respondent for her comments on the motion and the manifestations made by the lead prosecutor for the House. You may proceed, ma'am.
Thank you, Your Honor. I believe I have a standing question to the lead prosecutor, and I would like to ask her for the legal basis for requiring the respondent to be arraigned today. Because, Your Honor, I note that in her request earlier and manifestations given for the respondent to be arraigned today, she cited Rule 7, Rule 9, and Rule 21. However, in Rule 7, it very clearly states that if the person impeached after service shall fail to appear either in person or by counsel on the day so fixed, or appearing shall fail to file his answer to such articles of impeachment, the trial shall proceed nevertheless as upon a plea of not guilty. Well, this rule is clear. It does not talk about any arraignment. And if you take a look at this sentence, everything here has been satisfied. The respondent accused is here, has attended through counsel. She may not be in person, but the notice given to the defense is that she may appear through counsel. Second thing is that the respondent accused was also able to file her answer. And so Rule 7 does not support the request of the lead prosecutor that the respondent accused be arraigned today. Now, on the matter of Article 9, counsel also say that the person impeached then be called to appear and answer the articles of impeachment against him or her. And if he or she appears, or any person for him or her, the appearance shall be recorded, stating particularly if by himself or by agent or counsel, naming the person appearing in the capacity in which or she he appears. If he or she does not appear, either personally or by agent or counsel, the same shall be recorded. And for all intents and purposes, respondent is present today through counsel. There is also nothing in Rule 9 that requires the reading of a 23-page articles of impeachment, which will be a waste of judicial time. Now, finally, under Rule 21, Your Honor, may I just correct the manifestation earlier by counsel, because it would seem to me, unless a reading of the transcript would say that I'm mistaken, but I seem to have heard the lead prosecutor claim that the voting on the articles of impeachment will be per article. Well, that's true, but the first sentence of Rule 21 says, the trial of all the articles of impeachment shall first be completed before the senators vote on the final question on whether or not the impeachment is sustained. Now, honestly, I do not see how Rule 21 is related to the motion now being requested or propounded by the lead prosecutor. And at any rate, Your Honor, given that the respondent is represented by her counsel today, and this is consistent, her appearance is consistent with the notice given and in accordance with rules on rules of procedure of this court, then we can enter her plea on her behalf.
The arguments of the parties are duly noted. Chair will now make its ruling. The articles of impeachment were deemed read and spread into the records when it was referred by the Senate to the Committee on Justice for the proper issuance of summons. And a plea of not guilty will only be entered in accordance with our rules in behalf of the Vice President if she does not file an answer. But in this case, she has filed an answer and in fact has appeared through counsel. Insofar as the reading of the articles of impeachment is concerned, it will be done at the final resolution of this case when it is put to a vote by the senator judges, where each article of impeachment will be read before a vote shall be taken thereon. For those reasons, the motion is denied, and the lead prosecutor, Representative Luistro, may proceed with her opening statement. Kindly be mindful of the clock, and before recognizing you, ma'am, may I remind the counsels for the parties to kindly address the chair with respect to anything and everything they want or wish to say before the court, and not to address each other. The lady may proceed. Representative Luistro, you're recognized, and you have 15 minutes for your opening remarks.
We thank the court, Your Honor.
Mr. Presiding Officer, the Honorable Cheese Escudero, the Honorable Senate President, Honorable Win Gatchalian.
Magkain ka muna.
Sa atin pong mga kagalang-galang na Senator Judges, Mga minamahal na kababayan, sa loob ng bulwagan o sa labas man, mga nakatutok sa telebisyon, sa cellphone o sa radyo, saang sulok man ng mundo, kayo naroroon. Maraming Pilipino ang nagtatanong ngayon, bakit mahalaga ang paglilitis na ito? Ano ang kaugnayan nito sa buhay ng ordinaryong Pilipino?
Yung food mo kanina pa rin.
Lubos po naming nauunawaan ang mga tanong na yan. Sa katunayan, may isang driver na nagtatanong, paano sasapat ang kita sa pasada
Saan galing to?
upang mapakain niya ang kanyang pamilya? May isang OFW na nagtatanong, hanggang kailan kailangan lumayo upang mapaaral niya ang kanyang mga anak? May isang guro na nagtatanong,
Dito ka
paano
magkain.
pagkakasyahin ang
Kaya
kanyang
magbasa
sahod
ka.
sa dami ng utang na hinuhulugan? May isang manggagawa na nagtatanong, hanggang kailan magtitiis sa pansamantalang trabaho at kakarampot na sweldo? Sa unang tingin, maaring sabihin na malayo sa buhay nila ang paglilitis na ito. Ngunit hindi. Hindi po. Sapagkat ang usapin ngayon ay patungkol sa isang bagay na pag-aari nilang lahat. Ang kanilang pera, ang kanilang tiwala, ang kanilang karapatan na maningil ng pananagutan mula sa mga pinuno na kanilang pinagkatiwalaan. Kapag ang isang empleyado ay nagkamali ng paggamit ng pera ng kumpanya, siya ay pinagpapaliwanag. Kapag ang isang barangay treasurer hindi maipaliwanag ang nawawalang pondo, siya ay iniimbestigahan. Kapag ang isang principal ay naglustay ng pera ng bayan, kahit 5,000 lang yan, siya ay pinaparusahan. Natural lamang na magtanong ang sambayanan kung ang ordinaryong Pilipino ay pinapanagot. Bakit hindi ang pinakamakapangyarihan na opisyal ng pamahalaan? Ito ang dahilan kung bakit mahalaga ang paglilitis na ito. Hindi upang usigin ang isang tao, hindi upang maghiganti sa kalaban, hindi upang manalo sa politika, kundi upang sagutin ang isang tanong na napakahalaga sa kinabukasan ng ating republika. May saysay pa ba ang pananagutan sa ating bansa? Sapagkat ang kasong ito ay higit at lampas sa sino mang opisyal. Higit at lampas sa anumang partido. Higit at lampas sa alinmang administrasyon. Your Honors, the framers of the Constitution understood that there may come a day when extraordinary power would be entrusted to extraordinary office. They also understood that there may come a day when trust would be broken. And that is why they gave the House of Representatives the power to impeach, and the Senate the duty to judge, not to punish political opponents, not to settle political scores, but to protect the republic itself. That is why the Constitution declares public office is a public trust. Ang kapangyarihan ay hindi pag-aari ng sino mang opisyal. Hiram lamang ito sa taong bayan. At ito ang dahilan kung bakit naririto tayo ngayon. Your Honors, the prosecution will present exactly what the Constitution requires. Evidence. Hindi chismis. Hindi haka-haka. Hindi propaganda. At lalong hindi SOCMED narrative. Evidence. Official records. Financial documents. Government reports. Video recording. Statements under oath. Independent findings of institutions created by law. Mga dokumento na hindi bumoboto. Mga records na walang partido. Mga katotohanan na walang kulay pampolitika. Sa unang tingin, maaring magmukhang magkakahiwalay ang 4 articles of impeachment. Confidential fund, unexplained wealth, bribery and corruption, threat against constitutional order. But these are not 4 separate stories. These are 4 chapters of the same story. Story about power size without accountability. Story about public trust betrayed. Story about public office that stopped answering to the public. On the first article of impeachment, the evidence will show that more than 612 billion pesos in confidential fund entrusted to the office of the Vice President and the Department of Education were disbursed, transferred, and liquidated under circumstances that cannot withstand scrutiny. 612 million pesos. Hindi ito pera ng gobyerno. Pera ito ng sambayanan. Pera ng manggagawa. Pera ng magsasaka. Pera ng OFW. Pera ng guro. Pera ng bawat Pilipino na nagbabayad ng buwis at nagtitiwala na gagamitin ito ng tama. The evidence will show liquidation reports supported by questionable documents. The evidence will show acknowledgement receipts bearing names government records could not verify. Names that transformed accountability into a mockery. Pananagutan na naging kalukuhan. Names that insulted the intelligence of the Filipino people. Mary Grace Piatos, Milky Sikuya, Kokoy Villamin. On the second article of impeachment, the evidence will show financial transactions involving billions of pesos associated with the respondent and her husband. Billions. Hindi milyon, bilyon. At habang milyon-milyong Pilipino ang nagtratrabaho at nag-iipon buong buhay upang magkaroon ng sariling bahay, makapagpaaral ng mga anak, magkaroon ng konting seguridad para sa pamilya. Aba, bilyon-bilyong piso ang dumaan sa mga bank accounts na hindi may paliwanag ng maayos. This article is not about wealth. This is about accountability. This is about explanation. If wealth was lawfully acquired, where is the lawful explanation? If transactions were proper, where is the complete accounting? If numbers truly add up, then why do they refuse to reconcile? On the third article of impeachment, the evidence will show bribery, graft and corruption through the distribution of cash payments and monetary gifts to officials under the supervision of the respondent. This article is not simply about envelopes. This is about institution. This is about whether loyalty was purchased rather than earned. Government cannot function if loyalty is purchased instead of earned. Kapag nabibili ang katapatan, nawawala ang integridad. At kapag nabibili ang opisyal, nabubudol ang bayan. Perhaps the greatest tragedy is where the conduct allegedly occurred. In the Department of Education, Tama po sa DepEd. The institution entrusted with teaching future generations honesty, responsibility, integrity. On the fourth article of impeachment, the evidence will show culpable violation of the Constitution, high crime, betrayal of public trust, through conduct that threatens constitutional order. Among all allegations before this court, none strikes more directly at the heart of constitutional order than this one. Ito na po ang pinakamatindi. And unlike in many cases, which depends upon competing accounts, this evidence comes substantially from the respondent's own recorded public statements. The court will see them. The court will hear them. The court will judge them. Public officials may disagree. We may criticize one another. They may compete fiercely for power. That is democracy. But democracy ends when violence begins. Sa kasaysayan ng ating republika, walang vice-presidente na may kaibigan na hitman. Ngayon lang. Walang vice-presidente na nagpapapatay ng Pangulo. Ngayon lang. Walang vice-presidente na handang magpapatay para lamang makaupo sa pwesto. Ngayon lang. The Constitution provides many means on how to resolve political conflict. Election, legislation, public debate, judicial review, and even impeachment. But it does not permit threats. It does not permit violence. It does not permit people entrusted with power to place themselves above constitutional restraints. Your Honors, at the center of this case lies a simple question, perhaps the most important to any republic. When the people entrust power to a public official, does the public official remain accountable to the people? Or do the people become accountable to the public official? The Constitution's answer is very clear. Power belongs to the people. Public office is merely borrowed. And every borrowed power carries with it the obligation to account for its use. If a barangay treasurer must account for public fund, then so must the vice president. If an ordinary public servant can be investigated, then so can the highest officials of the government. If ordinary citizen is expected to obey the rules, then surely those who govern them must obey them first. Otherwise, what lessons do we teach our children? That there is law for the powerful and another for everyone else? That accountability exists only for the weak? That public office grants immunity against accountability? Your Honors, this is not the republic envisioned by the Constitution. This is not the republic deserved by the Filipino people. Therefore, the prosecution asks only this. Look at the evidence. Listen to the witnesses. Examine the records. Follow the evidence wherever it leads. Judge this case not by politics, not by popularity, not by fear, not by loyalty. Judge this case by the Constitution. Judge this case by the evidence. Years from now, future generations will not remember today's political alliances. They will not remember today's headlines. They will not remember today's slogans. What they will remember is when accountability was tested, the institutions of the Republic stood firm. They will remember only one thing: what this court did when the Constitution called. Future generations will not ask how powerful the respondent was. They will not ask how loud the political debate became. But they will ask one thing: when the Constitution called, did the Republic answer? Your Honors, this is that moment. This is the moment the Constitution anticipated. This is the moment when accountability must mean exactly what it says. This is the moment when public office must truly remain in public trust. This is the moment when the Republic must demonstrate that laws are applied equally to the powerful and the powerless alike. At matapos marinig ang mga saksi, matapos masuri ang mga dokumento, matapos matimbang lahat ng ebidensya, ang prosekusyon ay naniniwala at naninindigan. Isa lamang ang maliwanag na konklusyon: ang tiwalang ipinagkaloob ay nilabag. Ang kapangyarihang ipinahiram ay inabuso. At ang konstitusyon mismo ang humihingi ng pananagutan. Amid the clarity of the mandate of the Constitution, political noise continues. Political squabbles continues. Political division continues. Please, let me conclude. Salus populi est suprema lex. The welfare of the people is the supreme law. Thank you, Your Honor.
The opening remarks of the prosecution through the lead counsel is duly noted. Opening remarks for the respondent. Counsel for respondent has 15 minutes, and we will give you the same latitude we gave counsel for the prosecution for an additional 3 minutes, should you so need. You may proceed, ma'am.
Thank you, Your Honor. Your Honors, fellow Filipinos, good afternoon. As we begin today the impeachment trial of the Vice President, and in the days ahead, this court will undertake its constitutional task of receiving and weighing the parties' evidence, and ultimately to decide whether these pieces of evidence justify either a judgment of conviction or acquittal, guided only by its members' conscience and their solemn oath to do impartial justice. The present undertaking of this court, therefore, not only carries the weight of the Constitution, but also the imprint of our nation's history, because the Filipino people have shown that they never forget. We, as a nation, never forget. But why is the act of remembering important? What does it matter to our history and to ordinary Filipinos? Because in this trial, the prosecution proposes that we unseat the Vice President elected to office by more than 32 million Filipino people, more than the number of votes cast for the sitting president, and much greater than any of the votes secured by each of the members of the House of Representatives who now are here to prosecute her and seek to undo this people's choice. Sa makatwid, ang malinaw na layunin sa likod ng mga paratang na ito ay ang pagpapatalsik sa isang vice-presidenteng inihalal ng mahigit 32 milyong Pilipino at bunga ng kanilang malayang pagpapasya. Whatever one's political persuasion is, the reality is that the prosecution now comes before this court to remove a vice president chosen by an overwhelming number of the electorate. You all have heard the prosecution say repeatedly that this is because they seek accountability, that the people have a right to hold their leaders accountable. This is not a matter of debate. Indeed, the people have a right to demand accountability from their leaders. What we have yet to hear from the prosecution, however, is this. When the Constitution declared under Section 1, Article 11, that public office is a public trust and that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. The Constitution does not only speak to the Vice President, it also demands the same standards from the prosecutors. Being public officers themselves, the public prosecutors and the members of the House of Representatives are also held to the same constitutional standard. And so we must remember what history tells us. This is not the first time that members of the House of Representatives have attempted to remove the Vice President, and in a manner not compliant with the Constitution. In a July 2025 decision, the Supreme Court unanimously declared in Duterte versus House of Representatives, GR numbers 278353 and 278359, that the impeachment proceedings in the House of Representatives were tainted with grave abuse of discretion, rendering the articles of impeachment that the House transmitted last year to the Senate as void ab initio. Early this year, the Supreme Court unanimously denied with finality the House of Representatives' motion for reconsideration of that decision, with a reminder that while impeachment is a powerful democratic process to call out corruption and grave abuse, impeachment can be abused, and that impeachment should never be abused to maintain the hegemonic dominance of greed by shaming those who occupy high government positions into preventing them from doing what they wish to do. But perhaps the most enduring reminder of the Supreme Court that we must not forget in the entire course of this trial is that, in the words of the court, the rule of law that does justice is our lodestar, and that justice includes accountability. Justice includes fairness. Without fairness, there is abuse. This fairness is what our democracy is all about. It is in light of these reminders that we draw attention to certain fundamental legal principles that we think we must not forget throughout this trial. Mga batayang prinsipyo na dapat nating tandaan sa buong panahon ng paglilitis na ito, anuman ang ating kulay o politika. If we are to be true and honest to our proclaimed values, such as the pursuit of accountability, justice, and integrity in our system of government, then we must remain possessed of an unyielding resolve to ensure that the trial and judgment in this case are done in accordance with the command of the Constitution, the majesty of the law, and the discipline required by the rules. Otherwise, those who stand in sanctimonious judgment of the Vice President will send a clear message that the law can be bent when it suits the convenience of the powerful, and that justice can be sacrificed at the altar of partisan interests. Mahalagang tandaan ang mahigpit na paalala ng ating Korte Suprema. Impeachment is not a purely political proceeding. It is primarily a legal, political, and constitutional mechanism. Ibig sabihin, kailangang naayon sa batas at konstitusyon ang anumang proseso nito. According to the Constitution, it is the Senate that shall have the sole power to try and decide all cases of impeachment. This power is not shared. The Constitution gives no other body, department, tribunal, agency, or a mere committee of any of these institutions the power to try an impeachment case. The House merely initiates, the Senate tries. Yet, we have seen the Committee on Justice conduct what its chairperson, the lead prosecutor in this case, described as a mini trial, which, as we all had witnessed, became a vast fishing expedition of alleged evidence that were not even part of the impeachment complaints under its consideration and which the respondent accused was made to answer. In that mini trial, we saw how the purported pieces of evidence were curated to construct a narrative against the vice president even before this case reaches trial. The articles of impeachment presented before this court as an exercise of the House's power to initiate impeachment cases are therefore, in super truth, the product of an impermissible intrusion of clear constitutional boundaries. Over the course of the impeachment trial, the prosecution will attempt to convince this court and the court of public opinion that the allegations in the articles of impeachment are supported by materials they obtained during their trial and that evidence exists to sustain a judgment of conviction. They will claim that the notices of suspension and disallowance issued by the COA and the COA decision denying the Vice President's appeal of that disallowance support their accusations, with the release of that decision by the COA conveniently timed and coinciding with the committee hearings. They will claim that the certifications of the PSA confirm their allegation that recipients of the confidential funds do not exist, even though they listed one Mary Grace Beatos in their pre-trial brief as among their witnesses, or that the liquidation of the confidential funds in a span of 11 days was allegedly swift as to invite suspicion. The prosecution will assert that the supposed NBI findings of similar signatures across a number of acknowledgement receipts submitted to the COA are supportive of their conclusion that the disbursements of the confidential funds were irregular. What the prosecution avoided informing the public so far are these: that it was the then Secretary of the Department of Budget and Management, Amena Pangandaman, who issued a memorandum for the President through Executive Secretary Lucas Bersamin on October 18, 2022, recommending the approval of the Office of the Vice President's request for confidential funds. That the Office of the President did in fact approve that recommendation of the DBM through a memorandum from the Executive Secretary dated November 28, 2022, and signed by the former Executive Secretary Lucas Bersamin by order of the President. That on December 13, 2022, the DBM issued a special allotment order number SARO-BMB-C-22-001-2004, signed by former Secretary Amena Pangandaman, to cover the request of financial assistance subsidy and confidential funds of the OVP that, notwithstanding the impending end of the fiscal year, the confidential funds were nonetheless released to the OVP on December 20, 2022 under this documented approval process. That the COA decision is far from being final, that there is a pending motion for reconsideration of that decision that, assuming arguendo, the COA denies that MR today, or while this trial is ongoing as could plausibly happen under the circumstances, the respondent accused still has legal remedies available under the law and rules and can file a petition to question the validity of any forthcoming resolution of the COA on the MR under Rule 64 via petition for certiorari under Rule 65 of the Rules of Court, and more importantly, that nothing in the notice of disallowance or COA decision states any findings of supposed misuse of confidential funds as confirmed by attorney Gloria Camora when she was asked on this point during the committee hearing on April 14, 2026. Across all other articles, the prosecution will lay a landscape of what it deems to be their evidence in support of their speculations and conclusions. We are not strangers to all these accusations precisely because this was not the first first time these narratives were foisted into the minds of the general public. We have heard the same tales and stories of these accusations since 2024, when the House conducted its Quadcom hearings and most recently the mini trial of its Committee on Justice. But what we must not forget amid all these accusations is the fundamental legal principle that the burden of proof never shifts. The burden of proof never shifts. He who accuses must prove his allegations with evidence that meets not only the degree of proof required, but also meets the evidentiary standards of admissibility, credibility, relevance, materiality, and competence. We therefore should not lose sight of the core principle that the burden of proof is on the prosecution, and unless it discharges that burden, the accused need not even offer evidence on her behalf, and she will be entitled to an acquittal. This is the law then. This is the law now. And the underlying principle for this burden of proof is simple. Under our Constitution, every accused is presumed innocent until proven otherwise. An accused has in her favor the presumption of innocence, which the Bill of Rights guarantees. This also brings to fore the reality that, in the words of the Supreme Court in People versus Pagal, the individual citizen is but the speck of particular molecule vis-a-vis the vast and overwhelming powers of government, and his only guarantee against oppression and tyranny are his fundamental liberties under the Bill of Rights, which shield him in times of need. Sa madaling salita, kinikilala ng ating saligang batas na sa bawat paglilitis, ang isang individual ay nahaharap sa malalim at napakalaking makinarya ng buong estado. At ang tanging sandigan lamang niya laban sa anumang pang-aabuso ng kapangyarihan ay ang kanyang mga batayang karapatan sa ilalim ng ating konstitusyon. Kaya't mahalagang linawin na sa gitna ng pagtatangkang ikondisyon ang kaisipan ng mamamayang Pilipino at sa gitna ng walang humpay na komentaryo sa mga pampublikong espasyo, wala pang maituturing na anumang ebidensya o aligasyon na nagpapatunayan ng prosekusyon sa simpleng dahilan na ang bawat ebidensya ay kailangang dumaan muna sa pagsuri ng korteng may tanging kapangyarihan sa ilalim ng ating salita. Paglilitis at pagsusuri ng korteng may tanging kapangyarihan sa ilalim ng ating saligang batas. Higit sa lahat, ang anumang paglilitis ay kailangang naayon sa itinatakda ng ating batas at konstitusyon at hindi lamang sa kagustuhan ng iilang may hawak ng kapangyarihan. One might ask, why is it important that we must not forget these basic principles? The ruling of the Supreme Court tells us why. The Bill of Rights applies to the entire impeachment process because inasmuch as our court recognizes that impeachment is a political process, it reminds us that it is not a purely political process but a legal and constitutional mechanism. Thus, if we are to uphold the rule of law, serve justice, and invoke the accountability mechanism, then this court and we as a people must guarantee that all efforts to hold our leaders accountable must be done right. This we must not forget. I thank the court and the public for the privilege of your time. May God bless your country.
written statement of the counsel for respondent. Duly noted and entered into the records. The court will now proceed to dispose of some of the incidents that were brought up during the pre-trial conference, as well as other pending matters and motions. First, on the sequence of the presentation of the articles of impeachment, the pre-trial order stated that the prosecution has a free hand to determine the sequence of the presentation of the articles of impeachment. However, respondent will be similarly accorded the same right insofar as the presentation of their evidence and witnesses in chief is concerned. May we now learn from the panel of prosecutors rather, what will be the sequence of presentation of articles of impeachment that they intend to pursue? Attorney Jokno is recognized. You may proceed, sir.
Thank you, Your Honor. The first article we will be presenting will be Article 4 on grave threats. Second will be confidential funds, Article 1. Third, bribery, that is Article 3. And fourth is unexplained wealth, Your Honors. That's Article 4.
Ano yung sa'yo?
Two.
I'm sorry, Article 2. I stand corrected.
So the sequence of presentation shall be Article 4, Article 1, Article 3, and then Article 2.
Yes, that is correct, Your Honor.
So I presume that beginning tomorrow, once we issue the subpoena for your first set of witnesses, you shall begin with Article 4.
Yes, Your Honor.
Again, chair rules that the respondents have the same and equal privilege of presenting its case as it so desires when it's time to present its evidence in chief shall come. What is the pleasure of the counsel for respondent?
Thank you, Your Honor. May I ask if the prosecution is ready to present its first witness today because defense is ready today, Your Honor?
Should noted, we will get to that later. Next item on the agenda.
If Your Honor, please.
Yes,
I
Representative Joe.
just noticed that Your Honor had already directed the counsel for the defense not to propound questions to the prosecution. This is already the second time that she's doing that.
Ano kayo dito?
We assume we are allocating the powers of the court. Because as I understand the rules, it's only the court that can propound questions to the counsels.
Your Honor, may I comment?
The lady may comment.
I
Counsel
take
for respondent
exception
may
to
comment.
that. Yes, Your Honor. I take the manifestation of the good counsel.
Kailan
In
tumapos?
fact, the record would show, and if we can run the transcript back, my question was addressed to the presiding officer.
Tapos, yung sa'yo nilingan.
Next item for us to dispense with, the witness disclosure rule. The prosecution proposed a 3-day witness disclosure rule. The respondents proposed a 5-day witness disclosure rule. But they understand the prosecution is amenable to the 5-day witness disclosure. Would that be correct, Representative John?
We are amenable to the 5-day disclosure.
Share therefore rules that insofar as disclosure to both to either party of a witness to be presented, not mentioned in the pre-trial order and or briefs of the parties shall be for 5 days. This is subject also to the chair's reminder that at the end of every week, that will be a Wednesday while we are on recess, we will ask the party presenting their case in chief to enumerate the witnesses they intend to present for the following week with the corresponding motion for the request of issuance to be submitted the day before or on Tuesday. So we can act on it before the last day of the week so that the subpoena can be properly issued in due course and in due time. It's ordered. On the examination of a witness by more than one counsel as propounded or proposed by the prosecution, the rules of the Senate are clear. Article 15 of the Rules on Impeachment states, witnesses shall be examined by one person on behalf of the party producing them and then cross-examined by one person on the other side. Therefore, rules that as a rule only one person shall present present a witness. However, in the exigency of the delivery and the administration of justice, and under certain exceptions, the court may allow more than one counsel to examine and or propound questions to a witness. To cite an example, just for the sake of the record, if, for example, the panel of prosecutors agrees with how the counsel for prosecutor is handling the case, the panel of prosecutors or one of them can take over, and that is not proper and should be allowed and will therefore be considered as an exemption to that rule. And other similar exigencies will be allowed in order to afford the orderly administration of justice and of these proceedings. So ordered. Insofar as the BIR box is concerned, what is the pressure?
My topic is about how separation methods helps our communities. I am also tasked to summarize our report
This
and
box was
hold
turned
your
over to the
conclusion.
Senate as part of the documents, including the articles of impeachment. However, the court is not yet in custodia leis of this box, given that there is no lawful order issued by the court for this box to be turned over to the Senate. More so that it is not yet offered in evidence, not even as of yet marked. The chair therefore orders that the BIR box, closed, sealed, and as it is received, be sent back to the BIR or the Bureau of Internal Revenue without prejudice to any action that the court may take. If a motion will be filed by either party for the issuance of a subpoena, and we shall await action, if any, by the BIR Commissioner should that time come. So, now, firstly, subpoena requested by the prosecution for the two NBI agents, may I request the clerk of court to kindly read the motion for the issuance of subpoena ad testificandum. Prosecution to the other side public prosecutors respectfully request the issuance of subpoenas ad testificandum. Directed the following witnesses to appear before the Honorable Impeachment Court on July 6, July 7, and July 8, 2026 at 2 p.m. As their testimonies are material, relevant, and necessary to establish the allegations under Article 4 of the Articles of Impeachment, as well as matters necessarily incidental thereto, and for purposes of the identification and authentication of other evidence before the Impeachment Court. Number 1. Attorney Jeremy C. Lotto, Regional Director, National Bureau of Investigation. Number 2. John Mark Calido, Senior Agent, National Bureau of Investigation. Respectfully submitted, Quezon City for Pasay City, July 1, 2026. We are not in receipt of any reservation or objection on the part of the respondent, counsel for respondent rather. However, Chair would like to ask the prosecutors, do you only request for a subpoena ad testificandum or a subpoena duces tecum as well?
If I understand the record, Your Honor, please say subpoena both for ad testificandum and duces tecum.
The motion filed by the prosecutors is only for a subpoena ad testificandum. That's why the chair is clarifying.
Good morning, everyone. Today, I am asked to clarify separation method help our communities.
Counsel for respondent?
Why
If I
is
may, Your
this
Honor,
method
just to set the
important
record
in our
straight,
daily
the
life?
presiding officer earlier inquired
And I will
mentioned
also give
that
I
the court
will
is not
also give
received any objection
summarization
from
and
the
last
respondent. But just to set the record straight, the respondent has not received any copy of the request for subpoena being mentioned today. What we received, Your Honor, was a manifestation containing the list of the witnesses of the prosecution for July 6, 7, and 8, Your Honor. And so it would be impossible for the defense or the respondent to object or to even comment on a request that we were not served with any copy.
The two witnesses against whom a subpoena has been requested by the prosecution mentioned in the pre-trial brief of the prosecution and was not commented on by the respondents in their pre-trial brief. But if you do have any objections now, the court would be be more than glad, or reservations, the court would be more than glad to hear before ruling on the motion for the issuance of a subpoena.
That's
Please,
fine.
agents.
At this point, Your Honor, that's fine. We'll just place on record our objections as the testimonial evidence is presented.
Duly noted. Chair hereby orders that the subpoena ad testificandum and duces tecum be issued to the aforementioned two NBI agents contained in the motion filed by the counsel for the prosecutors. Although by nature subpoena is ex parte, we would Chair would instruct the clerk of court to kindly upload all of the filings of all of the parties to the website for
Palagyan mo
information
mamukod
of the
na.
judges, but also of the parties and their counsels. The chair earlier, counsel for respondent said that witnesses for the succeeding week shall be manifested in open court on the last day of the trial, in this case by Wednesday, insofar as the next week's trial is concerned. So ordered. Now, insofar as the request for subpoena for bank records and AMLC records, Chair recognizes the clerk of court to kindly read and spread into the records the request for the issuance of subpoena, both, I believe, ad testificandum and duces tecum, or just duces tecum, for the aforementioned documents. The clerk of court may proceed.
Request for issuance of subpoena duces tecum. The prosecution respectfully requests the issuance of a subpoena duces tecum to the branch manager of the following banks: BPI Julia Vargas Branch, BPI Green Hills EDSA Branch, Philippine Savings Bank Wilson Branch, BDO Unibank Inc. Davao CM Vector Branch, Metrobank Davao Ecoland Branch, BDO Unibank Davao Rizal Branch, Security Bank Bikutan Branch, Land Bank San Pedro Branch, Philippine Savings Bank Davao MABR Branch.
Tapos kasi
Requiring him or her, or his or her authorized representative to submit to the clerk of the impeachment court on or before 24 June 2026 at 9 a.m. the certified true copies of documents, books, papers, electronic data, communications, and information in the possession, custody, or control of the bank relating to any account, deposit, investment, trust, loan, safety deposit, or other financial transactions maintained, open, closed, controlled, beneficially owned, or jointly held by Sara Z. Duterte and or Manasseh R. Carpio, whether individually, jointly with each other, jointly with any other person, or through any authorized representative, nominee, attorney-in-fact, or signatory for the period January 1, 2007 to December 31, 2025, including but not limited to records identifying account numbers, account types, know your customer documents such as but not limited to customer information forms, and signature cards. Number 2, monthly bank statements, average daily balances for per calendar year, year-end balances from January 1, 2007 to December 31, 2025. Number 3, all account and transaction records, ledgers, and journals and similar instruments from January 1, 2007 to December 31, 2025. And number 4, all other relevant bank documents. Request for subpoena duces tecum to the Anti-Money Laundering Council, to Honorable Eli M. Remolona Jr., Chairman, AMLC, to Attorney Ronel U. Benaventura, Executive Director, AMLC, requiring him or her, or his or her authorized representative to submit to the clerk of the impeachment court on or before 24 June 2026 at 9 a.m. original or certified true copies of the following. Number 1, all reports of covered transactions and suspicious transactions filed by banks and all other financial institutions and covered persons required to submit covered transaction reports and suspicious transaction reports to the AMLC involving Sara Duterte Carpio and or Manasseh R. Carpio covering the period of 2006 to 2025. Number 2, any and all investigation reports or related reports or documents prepared by the AMLC involving the reported covered transactions or suspicious transactions. And number 3, Electronic copies, including Microsoft Excel files, database extracts, or machine-readable formats of AMLC, CTRs, and STRs for the period 2007 to 2025 involving Sara Duterte Carpio and or Manasseh R. Carpio, respectfully submitted, Quezon City for Pasay City, June 18, 2026.
Your Honor, may I comment?
If Your Honor, please, before the defense makes a comment, just to obviate the proceedings and to facilitate the hearing today, if I may.
The chair has not recognized anyone yet.
May I be recognized, Your Honor?
Yes, the counsel for prosecutor.
If Your Honor, please. The subpoena request that was just read by the clerk of court pertains to a request that the prosecutor brought to the honorable court on June 24. Since that date has passed and no subpoena has been issued, we have refiled just this afternoon a subpoena reiterating the same request. And in the interest of justice and to allow the defense to comment or if they want object to the request that we filed this afternoon, perhaps if I may suggest, if Your Honor, please, that we provide the copy to the defense, give them a period of time to submit their opposition or objection, and as well the same period of time to the prosecution to reply before the honorable court rules on the request.
Is the motion for subpoena ducis tecum and or ad testificandum that you filed today exactly the same as what you filed before?
No, Your Honor. It contains the same documents that we had requested earlier, but there were some additional documents that were also mentioned in the request we filed this afternoon.
So you asked for additional documents?
Yes, Your Honor.
What does counsel for respondent say?
Your Honor, before I give my comment on the request for subpoena, I thank the good counsel for offering to provide us a copy of the request for subpoena, but we would also ask that we be provided with the June 2026 copies of the request for subpoena as well as the new one that the counsel mentioned today. But just for the record, it would seem to me that the request for subpoena covers documents involving years from 2006 up to 2025. And again, just for the record, this would seem to violate the Duterte versus HOR ruling, which very clearly states that the impeachment must be only for those acts or omissions within the impeachable years and terms and office of the official. But nonetheless, Your Honor, just so we're able to fully ventilate whatever objections or comments that we may have on this request, and considering that for today and in the disclosure made by the prosecution, they will begin with Article 4 and all these documents seem to pertain to Article 2, then we will ask for 10 days to file our comment on this request for subpoena. From today.
Chair hereby directs that all motions for the issuance of subpoena and testificandum subpoena ducis tecum filed by either parties be furnished to opposing party and or counsel before filing it before this court in order to provide full disclosure and fairness. But instead of 5 days, counsel, Chair is giving both parties 5 days to submit their respective memoranda and or position insofar as this is concerned. We will afford the parties time to argue their position before the court so that the senator judges can hear your position in addition to your extended written memoranda insofar as this crucial issue of issuance of a subpoena ducis tecum ad testificandum on certain bank records and AMLC records, which the chair will schedule, giving ample notice to the parties in due time. Is that okay with both sides?
Just for clarity, Your Honor.
Yes, counsel for response.
May I ask that the period, if the
parties to submit, or the respondent to submit its comment, her comment on the request for subpoena would be 5 days from today, Your Honor.
From today, but you can submit it on Monday since it lands on a Saturday.
Second, Your Honor, the presiding officer mentioned that we also must submit a memorandum or position paper on this, Your Honor.
If you so desire, or you simply can argue it in open court, okay. But you may want to submit an extended written memorandum on the matter for the easy reading of the senator judges pertaining to this issue.
Last, Your Honor, will the court also schedule an oral argument on the respective positions of the parties?
Yes, Chair will do that.
Thank you, Your Honor. And this would not be on Monday, Your Honor?
No, that will not be on Monday.
Thank you, Your Honor.
If Your Honor,
Counsel
please.
Prosecutor.
Yes. May I be allowed to make a counter manifestation, just a brief one, with respect to the statement of the Defense Counsel regarding the application of the case of Duterte versus House of Representatives.
The gentleman may proceed briefly.
Your Honor, the decision and the resolution of the Honorable Supreme Court in that case did not say that any preterm evidence is inadmissible. There is no statement like that at all in the entire decision and the resolution. What the Supreme Court said, and I quote, was very simple. The basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. All of the articles in this particular case pertain to impeachable acts committed by the Vice President during her term as an impeachable officer, including unexplained wealth. If I may just be allowed 1 minute, Your Honor, to explain that. The unexplained wealth, Your Honor, that is amassed prior to the term of a Vice President is relevant and material to her being an impeachable officer, because wealth of the magnitude of millions or billions ay meron pa rin pong pakinabang po yan ang Vice President kahit hanggang ngayon. It's very clear that when a local government official, for example, who later becomes a national official, amasses hundreds of millions, if not billions of pesos, then that benefit continues today. Second, if Your Honor, please, integrity, hindi po pwedeng biyak-biyakin po yan na kesa dati ay hindi po ganun at ngayon may integridad. It's very clear that integrity is a continuing requirement of fitness for office. Thank you, Your Honor.
Duly noted and entered into the records.
Just very briefly, Your Honor.
Counsel Correspondent.
Much time of the impeachment.
As a rejoinder to the statement and manifestation of Representative Jokno, briefly.
Thank you, Your Honor.
You may proceed.
I think the good counsel has already stated precisely the reason for our position. We maintain our belief that the Duterte versus HOR ruling precludes any of these falling incursion, again, on private records of so many individuals and so many entities when nothing in the articles of impeachment point to any specific allegations as to the relevancy of all these documents, Your Honor. But nonetheless, we will include all our position and as well as our objections on the request made today with respect to these documents, and what it would seem to the defense would be another 2.0 version of a fishing expedition. May I also, Your Honor, just to clarify also the period given to us to comment on the request for subpoena, may we ask that the 5-day period run from our receipt of the copies of the documents.
We will make sure that the counsel correspondent will get that today.
Thank you, Your Honor.
The comments of both counsels of the parties are duly noted and entered into records.
Ilang
I would like to
question
apologize
i-prepare?
to Senator Cayetano has been waiting for quite some time. Thank you for your patience and indulgence. Senator Cayetano is recognized. What is your pleasure?
Senator
Judge.
Si teacher na lang.
Since we already stated as a court that we will take literally Section 3, subparagraph 6 of Article 11 of the 1987 Constitution that no person shall be convicted without the concurrence of two-thirds of all members of the Senate. May I ask the members of this court through the presiding justice to consider, not today, I have a proposal, but not today, but to consider communication with the Sandigan Bayan for the attendance of Senator Dante Marcoleta and Senator Jingoy Estrada, considering that the presiding officer may correct me if I'm wrong, but if we get to Section 21, as discussed a while ago by the defense, the prosecution and defense, and we do not know what will happen. Their case may be dismissed and they can be out on bail. So we want them to be able to participate and observe the witnesses as senator judges here. I do know that Senator Jingo is under suspension, but there's an argument to be made that the impeachment court is sui generis. In ordinary committee hearings, we do coordinate with courts to ask that persons under their custody be delivered to the Senate under, or the House of Representatives under certain conditions. So I'd like to formally ask Mr. President that this court consider that I will submit whether you'd rather have a caucus or a in-camera discussion, or if you want us all to submit our legal opinion. I wouldn't also mind the prosecution and defense weighing in. But considering that if they do not attend and they are here, sorry, Mr. President, considering that if they do not attend at all and cannot vote, their vote will be equal to a acquittal. And as we said from the start, we want a fair and we want justice. We want a fair impeachment trial. Sinabi ng prosecution na sana tingnan yung ebidensya, pakinggan mga witnesses. So kahit gawin to ni Senator Marcoleta at kahit gawin to ni Senator Jinggoy, and of course this is my personal opinion that may politika sa pagpapakulong sa kanila. That's my personal view. Allowing them to attend here might add to the integrity of the proceeding and actually make things easier when the time comes to render. So may I submit that to the court and to our colleagues for discussion at the proper time, Mr. President.
The chair notes the comments and requests of Senator Judge Cayetano and will consult the senator judges regarding this matter and shall coordinate with his office with respect to his requests pertaining to Senators Jingoy Estrada and Senator Marcoleta, including whether or not we will enlist the comment and position of the parties to this case. So ordered. Senator Tulfo, what is the pleasure of Senator Judge Tulfo? Rafi?
Mr. Presiding Officer, as far as I'm concerned, I would allow siguro mag-monitor yung mga si Senator Jinggoy, Senator Marcoleta. It will be allowed na kahit man lang yung sa TV monitor. Para sa akin, I do agree with what Senator Alan Peter Cayetano suggested. Mr. Presiding Officer.
The point of Senator Judge Rafi Tulfo is well taken by the chair. Any others? If there are none, presiding officer would now like to deal with an administrative matter before we adjourn for this afternoon. On the matter of providing public access to case records, yes, Senator Judge Marcos, what is your pleasure?
Yes, presiding officer, may I request an update? As I recall, during the pre-trial conference, there was disagreement on how to go about the markings on the various documents, and among the thousands of pages that we have received in evidence for the trial, it apparently was resolved that the council should place their initials on the evidence. Is that correct? Is that still what stands today? And each party will take their respective evidence or files and present the same during the trial to guarantee that the same evidence would be presented.
That is correct, with the exception of some, I think, documents that where the original was not presented, which is being corrected, I think, by the parties as we speak.
Are we in fact in receipt as judges of all these thousands of pages? Dahil ako, simple lang hinahanap ko yung affidavit of investigation, yung dalawang NBI na unang testigo na sana haharap ngayon, nakita ko sa libu-libong pahina na sinabmit, mali-mali ang pagka-annex ng AOI, hindi ko talaga mahanap. Tapos, ang sabi doon, Annex G. Pero nung kinalkal ko yung Annex G, hindi naman affidavit yun, kundi disbursement voucher or something like that. Kaya, hindi ko alam kung nag-provide ba talaga ang clerk ng Senate ng records as marked during pre-trial at kung binal na talaga ito at pag-aaralan natin.
At this point in time, Your Honor, documentary evidence as of yet has not been formally offered and therefore has not been turned over to the court. Neither is it as of yet been identified by a witness to authenticate the same and to be allowed admission into the records of this court. That time will come. Once the prosecution presents their witness and identifies the piece of evidence, that will be the proper time, perhaps, that the good senator judge can ask for a copy because the lady might want to ask questions of the witness should that time come for the witness to testify as to the document marked previously erroneously or rightfully by either party.
Yes, precisely. Thank you very much, Presiding Officer. We wish to prepare for the three first witnesses and we're unable to access any of their affidavits or other documents. Thank you.
Duly noted and entered to the records. What is the pleasure of Senator Judge Padilla?
Ginoong tagapamahalang hukom, gusto ko lamang pong sundan yung sinabi ni Senator Judge Alan Peter K. At pasalamat po kay Senator Judge Rafi Tulfo. Gusto ko lamang pong linawin na ang hinihingi po namin kung hindi man makapag-participate dahil sinasabi nga po ay ipinagbabawal silang makapag-participate. Bumoto si Senator Jingo Estrada at Senator Judge Marculeta. Ang hinihingi po namin ay makapunta po sila dito bilang observer. Hindi lang po basta monitor. Yun lamang po. Maraming salamat.
Noted at the proper time we shall discuss this matter and settle it as a court or in caucus. There being no other senator judge who wishes to make a manifestation, comment, and or motion, Chair would now like to dispose of an administrative matter. Consistent with Article 2, Section 28 of the Constitution on the policy of public disclosure in matters involving public interest and to give life to the directive under the rules to open the impeachment proceedings to the public, the court hereby directs the clerk of court to create the necessary internet web pages to allow the electronic records of impeachment to be made accessible to the public through the Senate website, whereby all pleadings, memoranda, motions filed by the party shall be uploaded, including the journal of the proceedings after it shall have been approved by the impeachment court. Yun lang po siguro yung madidili ng konti dahil kailangan aprubahan muna ng impeachment court yung journal bago po namin ma-upload sa website. Yes, what is the pleasure of Senator Judge Bam Aquino?
Yes, Mr. President, on this note, firstly, we'd like to second and congratulate this move of the impeachment court to make all of the evidence available to the public. May we know in how many days will the clerk of court make this evidence available to the public, Mr. President?
They've started, but they have not completed it yet. As Senator Judge Marcos said, the documents are voluminous. I think it covers until 9Q, if I'm not mistaken, initially, when it was marked. About more than 10,000 documents.
Mr. President, of course, in the same way, if this is made available to the public 6 months from now or 1 year from now, that defeats the purpose of having this made public.
No, that will not happen.
Yes, may we get a commitment from the clerk of court as to the delay by which presented evidence is made public, Mr. President?
No. clarify, Your Honor. I believe the articles of impeachment as well as its annexes have been uploaded. The answer as well as its annexes have been uploaded. And most of the exhibits that were marked, not all, um, are annexes of either the impeachment complaint and or the answer. Um, can the chair give you an update before the week is over as to a realistic timetable to upload in real time already? Again, except for the journal, which we need to approve. So we cannot upload the Wednesday transcript or journal until we meet again on Monday and approve the journal of Wednesday. So that would be the only delay, if at all, in uploading it. That should be the only delay.
So if I take it correctly, Mr. President, the clerk of court will endeavor to upload all of the presented evidence in real time at the soonest possible time, except for the journal, which needs approval of the body.
That is correct, Your Honor.
Thank you, Mr. President.
Senator Judge Cayetano Alan.
Presiding Senator Judge, just a clarification. No? So no problem with complete transparency with any public records. But when we talk about evidence, precisely that's why we want a fair trial, due process. There's a process wherein the prosecution submits evidence, then they will offer it. And then if there's a question as to the relevance or if it is prohibited, for example, if a evidence presented is a fruit of the poisonous tree, will we upload that? We haven't decided yet here whether we will accept it as evidence or not. So let me tell you first which ones personally I don't have a problem with. Don't have a problem with the public records in general being completely transparent. I have no problem with senator judges given time to review everything, and I assume we're all trained um, to consider only the evidence that is later on admitted, offered and admitted. So my problem is that, for example, no, if someone offers now, between now and the trial, wiretapped recordings, do we upload that when we have not made a ruling yet on that? So I just want to be clarified on that.
The chair will clarify, as the chair said earlier, only the pleadings, motions, and memoranda filed by the parties, and insofar as the exhibits marked are concerned, only those attached as annexes to either the articles of impeachment and or the answer to the impeachment complaint. Insofar as documentary evidence is concerned, it will only be admitted and, if at all, admitted by the court and published once formal offer has been made. Until such time, we will not publish any documentary evidence even after being identified by a witness, because it is the formal offer that will determine its admission by the court after
same thing rests. Just to clarify, same with if we do issue a subpoena.
The subject matter of the subpoena will not be published, but the motion for the issuance of a subpoena.
Thank you for that clarification.
Thank you. Senator Judge Erwin Tulfo is recognized. What is your pleasure, sir?
Thank you, Mr. President. Thank you, Mr. Presiding Officer. Just want to be clarified. I need a clarification, Mr. Presiding Officer, with regards to this anti-money laundering council documents or pieces of evidence that will be submitted here. Will it be okay if we tackle this in public, or shall we tackle evidence from the block during an executive session? I believe this is under the bank secrecy law, or we can tackle it because this is an impeachment court, Mr. Presiding Officer.
What we will debate upon, if at all, on the scheduled date to be set by the chair is a debate on whether or not to issue the subpoena duces tecum ad testificandum in relation to AMLC records, not the actual records yet. Once it is granted by the court and is issued, it will have to be presented by the parties. We we cannot tackle and discuss it in executive session because anything and everything discussed in executive session cannot be revealed into the public and used by this court. Secondly, it can only be, if at all, revealed by a unanimous consent by all the senator judges, which effectively hog ties that piece of evidence if we discuss and talk about it only in executive session. Whether or not it is to be made public, whether or not it can be legally obtained, will be decided by this court after hearing the oral arguments of the parties.
Thank you for that clarification, Mr. Presiding Officer.
No questions.
What is the pleasure of Senator Judge Villanueva?
Yes, Mr. President. Considering that we have been acting and asking of pieces of evidence, I think there's a lot of questions with regard to the Mahiwagang BIR box, Mr. President. Yung clarification lang po, where is it now and when are we going to transfer it to the Bureau of Internal Revenue?
It is with the Clerk of Court in the Office of the Secretary General as instructed by the Chair. It should be sent back to the BIR by tomorrow morning in the condition that it was received, meaning sealed.
The same. Thank you, Mr. President.
Any other manifestations or motions on the part of the senator judges? Senator Judge Ontiveros is recognized. What is your pleasure, ma'am?
Salamat po, Mr. Presiding Officer. Just to make a brief statement in support of the ruling recently proclaimed by the Presiding Officer on executive session. Thank you. If I may,
Noted.
Mr. Presiding Officer. And just to add a little bit of that, Mr. Presiding Officer, thank you. The executive session is only for Congress acting in its usual legislative functions, and impeachment trials do not contemplate executive session. So I join with the presiding officer in the call that he made, which I believe is the default also of this impeachment trial court for transparency as a general rule and as a default. Salamat po, Mr. Presiding Officer.
Thank you, Senator Judge Ontiveros. Before the court adjourns, Chair directs the Clerk of Court to kindly make sure that the subpoena for the two NBI agents will be issued this afternoon and duly received, and entrusts it to the Council for Prosecutors to make sure of the attendance of their two witnesses tomorrow. Likewise, the Chair reminds the Clerk of Court to furnish, right after we adjourn, Council correspondence with a copy of the requests for the issuance of subpoena thus far submitted and filed with the Office of the Clerk of Court. So ordered. There being no other business to discuss, the trial is hereby adjourned until 2 p.m. of Tuesday, tomorrow, July 7, 2026.
Senator Judge Ejercito, Senator Judge Escudero, Senator Judge Estrada, Senator Judge Go, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin, Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the Senate President.
With 21 senators present, the Chair declares the presence of a quorum. The court was convened on May 18, 2026. For the record, since then, the court has issued summons and conducted pre-trial proceedings which are all made part of the records of this case. Resolution number 39, or the Rules of Procedure of Impeachment Trials as amended, shall continue to apply.
Your Honors, we are now ready to hear the statement of the Senate President.
Before we begin, with the Court's kind indulgence, I wish to deliver a brief opening statement. Ladies and gentlemen, distinguished Senator Judges, sa araw na ito, binubuksan natin ang pagdinig sa kasong impeachment laban sa pangalawang Pangulo ng Republika ng Pilipinas, ang kagalang-galang na Sara Duterte, alinsunod sa ating saligang batas. Sa pagtupad natin sa tungkuling ito, malinaw ang panata na ating sinumpaan to do impartial justice according to the Constitution and the laws of the Philippines. Ibig sabihin nito, ang bawat pasya natin ay dapat nakabatay lamang sa saligang batas, sa ating mga batas, sa mga alintuntunin ng hukumang ito, at sa mga ebidensyang ihaharap na walang kinikilingan at walang pinapanigan. Impeachment is a constitutional mechanism that holds the highest public officials of the Republic accountable to the people. We cannot achieve accountability, nor can we faithfully serve justice without it. Karapatan ng sambayanan na malaman kung may katotohanan ang mga paratang laban sa pangalawang Pangulo. Tungkulin nating timbangin ang mga ebidensyang ihaharap at tiyakin ang ating magiging pasya ay nakabatay lamang sa batas at sa mga katotohanang mapatutunayan sa paglilitis. Ipagkakaloob ng saligang batas sa Senado ang natatanging kapangyarihan dinggin, titisin at pagpasyan ang lahat ng kaso ng impeachment. Kakibat ito ang pananagutan tiyakin na ang paglilitis ay isinasagawa ng may integridad, kaayusan at buong paggalang sa proseso. Sisiguraduhin natin na magiging maayos, bukas at madaling maunawaan ng ating mga kababayan ang prosesong ito. Pagkakaluban, ang magkabilang panig, ang prosekusyon at ang depensa ng sapat at makatarungang pagkakataon upang magharap ng ebidensya, magsuri at magtanong sa mga testigo at may lahat ng buo ang kani-kanilang mga argumento. Sa ganitong paraan, may hiharap sa taong bayan ang malinaw na batayan upang maunawaan ang mga isyong nakapaloob sa Articles of Impeachment. Sa kasabay ng paghahanap sa katotohanan, ang tungkulin natin tiyakin, iginagalang ang mga karapatan ng bawat panig, lalo na ang karapatan ng respondent vice president sa isang patas at makatarungan paglilitis. Due process and fair play must remain paramount at every stage of this trial. Let us be firm in the search for truth. Let us remain faithful to the rules of this court, the rule of law, and above all, the Constitution. Nakatutok ang buong sambayanan. Bawat kilos, salita, at pagpapasyang ating gagawin ay huhubog sa kasaysayan. At ang kasaysayan ang huling huhusga kung tayo ay kumilos ng tapat at nararapat. Nais kong bigyan ng katiyakan ng lahat, lalo na ang ating mga kababayan. Gagampanan ko ang aking tungkulin ng patas at may katapatan. Magalang kong hinihikayat ang bawat senator judge, naway ito pa rin natin ang ating tungkulin ng may dangal at pananugatan sa ating konstitusyon upang maging karapat-dapat tayo sa tiwalang ipinagkaloob sa atin ng sambayanang Pilipino. Thank you, distinguished Senator Judges. Pursuant to Rule 2, Paragraph 2 of the Rules of Procedure on Impeachment Trials, as amended, we now proceed to the election of the presiding officer of the impeachment court. Senator Judge Panfilo Lacson is recognized for the election.
Point of order, Mr. Presiding Officer.
Yes, we recognize the gentleman from the green.
Thank you, Mr. President. Mr. President, Mr. Senate President and Presiding Officer, as the preamble of the Constitution said, imploring the aid of the Almighty God, and as you said yourself, that every stage of this impeachment, we have to make sure na patas, we have to make sure na may due process, we have to make sure that it is fair. It is very clear in the Constitution of the Philippines that the presiding officer is the Senate President. Section 3, paragraph 6 of Article 11 of the 1987 Constitution, the Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senator shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of two-thirds of all the members of the Senate. I will go to that other two-thirds inquiry later on because this is another threshold issue, Mr. President. But to further the point of order, with the indulgence of Senator Lacson so that we can discuss this intelligently. On the final question of whether impeachment, on the issue of who shall preside, under the Constitution, it may seem that it does not say who should preside. But if you look at the records of the Constitutional Commission, number 40, July 1986, the framers deliberately chose the phrase, sorry, Mr. President. I am referring to Section 6, Article 11, and then Constitutional Commission number 41, 27 July 1986. The presiding officer, Mr. Treñas, Commissioner Davide is recognized. Thank you, Mr. Presiding Officer. I have some proposed amendments on Section 3. Sa paragraph 5, the presiding officer, Mr. Treñas, the gentleman may proceed. Mr. Davide, who later became Chief Justice, this is without prejudice to whatever amendments may be accepted by the committee when the Aquino amendments will be taken up. It would consist in adding a new sentence on line 20 before the phrase "no person shall be convicted," inserted the following: all other cases, the President of the Senate shall preside. The presiding officer, what does the committee say? Mr. Monson, is it not understood that when the President of the Philippines is on trial, it is only time when the Chief Justice of the Supreme Court will preside? It is necessary to say that the Senate President shall decide during all the time. Presiding Officer, Mr. Davide, Mr. Presiding Officer, I precisely presented this because we had a distinction when it comes to the Chief Justice Supreme Court. But with that clarification, that in all other cases, it should be the President of the Senate who shall preside, I withdraw my amendment. So it is but elementary, Mr. President, in statutory, especially construction of the Constitution, that the spirit as well as the letter is followed. The spirit of the Constitution is that it is the Senate President who will preside. This is not an ordinary statement, dictum, or it was not a capricious statement in the discussion. Precisely because the Senate President is elected by the majority. As an example, when Senator Pimentel did not like the vote and did not vote with the majority, he offered to resign. So the point, Mr. President, is this. Number one, institutional integrity. We need to protect the legitimacy of these proceedings. Even if the substitute presiding officer acts fairly, a conviction or acquittal reached under constitutionally effective process would invite judicial challenge and cast doubt on the validity of the entire trial. Do we want to go 30 weeks? If we follow the number of days submitted in the pre-trial, 62 and 30, and 3 days every week, so 30 weeks yon. Then after the 30 weeks, we'll end up in the Supreme Court kasi kuni-question natin kung tama ba kung sinong nag-preside. Why is it important? Why can't any of the 24 preside? Remember, under our very rules, hindi ko na babasahin para mas umikli. In our very rules, the presiding officer can decide on the spot, or he can throw it to the body, or he can call a caucus or whatever you call it to be able to decide. And we experienced that during the Corona trial, and that's one reason why everyone acclaimed the late Senate President Enrile, not only because of how he carried it himself, but how the consensus and how he carried it with the minority. Secondly, jurisdiction and regularity. The Senate's jurisdiction over an impeachment trial is constitutional. The exercise of jurisdiction must conform to the Constitution, and the Senate's validity adopted impeachment rules. We cannot say we're following the Constitution, then we will not follow the Constitution. If the Constitution and its framers prescribe who shall preside, who are we to change the Constitution here today? We cannot enlarge or diminish the Constitution arrangement through internal rules or through ad hoc resolution. Lastly, due process. Kailangan malinaw po sa lahat ng partido, both to the prosecution and the defense, kung ano yung korte, kung ano ang two-thirds, kung ano ang charges, kung sino magpre-preside. So kung now during the first day we're going to change who's going to preside and it's against the Constitution, what more changes are we going to do in the next few days? Ano ang limit ng pwede natin palitan sa Constitution at hindi? The authority must come from the Constitution or the governing law, not from the vote of a tribunal. A litigant is entitled to have the case heard by the decision maker, designation by law. The law cannot say that ang mag-hear kay Senator Marcoleta ay Sandigan Bayan, tapos sa Court of Appeals natin siya nadalhin. Hindi pwedeng sabihin sa RTC dapat i-hearing si Juan de la Cruz, tapos sa Sandigan Bayan natin dadalhin. Hindi pwedeng sabihin tatlo sila sa CA, pero in this case, nagbotohan kami, isa lang kami mag-hearing. Before proceedings before a judge or hearing officer who lacks the legal authority are invalid regardless of fairness of the proceedings. A judgment rendered by court without jurisdiction is null and void and may be attacked anytime. It creates no right and produces no effect. It remains basic fact that in law, the choice of the proper forum is crucial, as the decision of a court or tribunal without jurisdiction is a total nullity. A void judgment for want of jurisdiction is no judgment at all. All performed pursuant to it and claims emanating from it have no legal effect. Tan versus Cinco, GR number 213054, June 15, 2016. Penned by Justice Perlas Benabe, First Division. The constitutional authority, Mr. President, is very clear. Now, let's put that aside for a moment. But we're not allowed to do that. But for a moment, let's put that aside. The Constitution is not clear and does not tell us what to do. The rules of the Senate says that any amendment should be presented a day before. And that's why the then minority, when I was Senate President, walked out, because your contention was, when we gave it to the Committee on Rules, kahit may isang araw na binabalik ng rules, we did not follow the rules. So on the rump session or alleged rump session on June 3, first of all, you did not have a quorum of 30. But let's assume for the sake of argument, I'm not giving you that point. As far as I'm concerned, it's in the Supreme Court, walang quorum ang 12. Assuming may quorum ang 12, you did not follow the rules. There was not a one-day notice for the rules. And then if you look at the records, this impeachment court adopted the rules on May 18. So that means that it is this impeachment court that now has to adopt any amendment to the rules. We did not debate that amendment to the rule. We cannot now just change the rules. We're here for the opening statements. We're here for the trial. Are we here to change the rules? We're changing the rules here today, Mr. President. So, Mr. President, later on I'll ask permission to talk about yung two-thirds, because both the issue of the presiding officer and the issue of what constitutes two-thirds of all members is a threshold issue. Para maintindihan lang po ng lahat, lalo po sa mga kababayan natin na nanonood, Merriam-Webster, simple definition, a threshold issue is a preliminary question, minimum requirement, or foundation condition that must be met or resolved before proceeding to the substantive merits of a case, project, or process. If this initial criteria is not satisfied, further action is typically dismissed or halted. I want to avoid that this impeachment trial will be declared null and void. I want to avoid walkouts. I want to avoid any delays, Mr. President. The Senate President is more than capable. He said he is willing. He said he is ready. He has been in many situations in his life that people say you cannot do it, but he has done well. He has studied. So what's the issue? Why do we have to vote for a presiding officer, Mr. President? Why can't we follow the Constitution? So the point of order, Mr. President, is that amending the rules, implementing a null and void rule, and violating the Constitution will endanger this whole hearing, Mr. President. So please rule on the point of order, and I hope that the Senate President, who's more than able, will present.
Thank you to the gentleman from Taguig. Before I express my views on the matter, let me just put into the record the facts on when we amended Rule 2 of the Rules of Procedure on the impeachment trials. On June 3, 2026, Senator Juan Miguel Zubiri proposed resolution number 430, and that was adopted during that time. And then, on the same day, the same resolution was adopted and renumbered to resolution number 40. It was published on June 9, 2026 in the Philippine Daily Inquirer as well as Malaya. During that time, in June 3, when we amended the rules, everyone had the opportunity to express their views regarding the proposed resolution. And since no one objected, we adopted resolution number 430 and renumbered it to resolution number 40. That is anchored on our Constitution, Article 6, Section 3, Paragraph 8 of the Constitution, that the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. So, my view to the good gentleman, let me just finish, sir. My view is this resolution has been duly approved and everyone was given an opportunity to discuss that, to object. However, it was no one objected to that resolution, and it was duly approved by the body. So any discussion regarding this resolution should be discussed in plenary when the Senate convenes as a legislative body. In the past precedents, during the era of impeachment, November 15, 2020, the body as well approved the rules of impeachment in plenary. During the Corona impeachment, March 2023, March 23, 2011, once again, resolution number 39 was adopted in plenary. So any issues pertaining to this resolution should be discussed in plenary when the Senate convenes as a legislative body. So that is the position of the chair and the view of the chair of this matter.
Mr. President, first, may I dispute that you used the word fact. It is not a fact that the rules were changed because it is being disputed that first, there was no quorum on that day. Second, if we are going to amend the rules of impeachment for the impeachment trial in plenary under the rules of the Senate, Section 136, second paragraph says, the rules may be amended by means of a motion that should be presented at least one day before its consideration. It was not presented on June 2. So, we did not follow our rules. So, a rule that was passed that did not follow our rules, or amendment that was passed that did not follow our rules, is void. You cannot get anything out of it. It is a nullity. So, if today we pass a change in our rules and we do not follow our own rules in changing the rules, we cannot follow that rules. Secondly, Mr. President, the impeachment court already adopted our rules. Iba po ang plenary, tama po kayo doon, I agree with you there. Iba po yung impeachment court. So is the impeachment court now hostage or subject to whatever changes the legislative body does and we will not adapt? Then why did we adopt the rules when we took our oath? We adopted it because the impeachment court is not powerless to talk about our rules. But finally, Mr. President, for the sake of argument, just for the sake of argument, wag na natin tignan yung mga amendments. It's against the Constitution. So can the impeachment court disobey the Constitution? If the Constitution says the presiding officer should be the Senate President, can we now say na no, pagbotohan natin kung sino? Because if we say that we can, what next? Will we add to the articles of impeachment? Will we lower the bar of the quantum of evidence needed? Will we say that baliwala na yung pre-trial brief at bahala na si Batman? So, Mr. President, I thought that's why we have the rules. Because when we have the rules, it dictates fair play. And the rule says, it is the Senate President who will preside. So if now we're not going to follow the rules, anong pinag-uusapan natin patas? Anong pinag-uusapan natin due process? Anong pinag-uusapan natin na fairness? It is who we chose as Senate President is a political. So we made our case doon na we would have a more fair. You made your case, you got the majority. Now you got the majority, we will give you all the support, Mr. President. But we have to follow the Constitution. We cannot have a trial where we do not follow the Constitution, Mr. President. I think pinaka-basic po yun. Saan sa Constitution po nakalagay, Mr. President, that ang nakalagay dito po, only in case the President, let me give you a hypothetical. God forbid may mangyari sa Pangulong Marcos, maging Pangulo ngayon po, si Sara Duterte. My view is tuloy yung impeachment. Pero, ang magpre-preside na yung Chief Justice. O pwede ba tayo magbotohan na wag yung Chief Justice ang mag-preside? So how is it possible that today we're starting out on the wrong foot by arguing who will preside when the Constitution already settled it, Mr. President? So I appeal to my colleagues. There are a lot of accommodations, there are a lot of things, may bigayan talaga dito. May botohan, may caucus, may in-camera discussions, pero pagdating kung sino mag-preside na malinaw sa Constitution, huwag na natin pag-awayan yun. The prosecution is here, I think they're ready. The defense is here, I think they're ready. Let's give the Filipino people, a fair trial. Hindi po fair kung pipiliin natin kung sino ang kahit sinong magaling, kahit ako piliin nyo. Hindi ko po tatanggapin yun kasi mali po yun. Hindi po yun ang nakalagay sa Constitution natin. Very, very clear po sa records ng Constitutional Commission. Walang makaka-amend doon. We are not given any latitude on this matter, Mr. President. I appeal to you, Mr. President. This is your Senate presidency.
Thank you for that. Those views to the good gentleman from Taguig. Kanina po, nabanggit ko ho na in my manifestation as the Senate President, that resolution number 39 or the rules of procedure on impeachment trial as amended shall continue to apply. So in other words po, rin-recognize ko nitong impeachment court yung amendments na ginawa ho natin noong June 3. At kagaya ho ng nasabi ko kanina, the humble view of this presiding officer is if there are any discussion on resolution number 43 as adopted as resolution number 40, it should be done in plenary because doon ho natin in-amend yung at doon ho natin in-adopt yung impeachment rules of impeachment, doon rin ho natin inamendahan. At nabigyan naman po ng oportunidad ang bawat isa para magkomento, magbigay ng pahayag, magbigay ho ng kanilang legal opinion. Pero at that time, wala naman po ang nag-object at inadopt po ng Senado in a legislative body. So the position of the chair, if there are any comments, any legal opinions, any issues, it should be done through the legislative body of the Senate.
Mr. President, there is no conflict, Mr. President. With your permission, Mr. President. There's no conflict. If you want to discuss it, in 3 weeks may session na tayo. So all we have to do today is follow the Constitution. You preside. Then pagdating ng plenary, then we can debate whether we are allowed to amend the Constitution or not. Because, Mr. President, that's why I premise this not as a parliamentary inquiry or as a point of information or whatever we may call it. That's why it's a point of order. A higher point of order than the point of order in the rules is a point of order in the Constitution. The Constitution says it is the Senate President who will preside. So are we saying now, Mr. President, that the rules can amend the Constitution? Is that the ruling of the chair?
Before I make my final ruling on this matter, may I recognize the gentleman from Pampanga, Senator Kiko Pangilinan.
Thank you, Senate President. Mr. President, with all due respect, the Constitution does not provide that the Senate President must preside in cases of impeachment trial. What the Constitution provides is that when the President is undergoing impeachment, going through the trial, is being tried, the Chief Justice must preside. Nowhere in the Constitution, in the provisions on public accountability and impeachment, does it say that the Senate President must preside when the Vice President is under trial or any other impeachable officer. And precisely because of this, and precisely because the Constitution likewise allows Congress, not the impeachment court, Congress, to promulgate its own rules, which is what the Senate did in June 3. We proposed amendments to the rules under our rulemaking power, which, by the way, was subsequently ratified when we convened in a special session on June 17. The June 3 journal was ratified unanimously on June 17 when we had our special session. And in the June 3 minutes and the journal, precisely, we approved the amendments to the rules. This was further ratified on June 17. Therefore, it is considered regular. The presumption of regularity now comes into force. But having said that, Mr. President, the good gentleman from Taguig has brought this matter before the Supreme Court. And we agree with the point earlier raised by the Senate President. This matter should be either discussed in the Senate in plenary as a legislative body, or if he has questions which may in fact turn out to be valid, he has brought this matter before the Supreme Court. And therefore, this impeachment court is not the venue for this debate, Mr. President. If there is anyone who is out of order, with due respect, I think the proper process is the matter is pending before the Supreme Court. There is no temporary restraining order. There was a request for a status quo ante order. It was not granted. And therefore, the presumption of regularity behooves us as an impeachment court to proceed. And finally, Mr. President, allow me to reiterate, the point of order is
improper. In fact, the debate on this matter here in the impeachment court is out of order, Mr. President.
Sir President. Sir President.
Before you decide, Mr. President. The chair has already.
Sir President, before you rule.
The chair has already
wants
ruled.
to ask for the floor.
Just 2
And
minutes.
may I respond to
Senator
Pangilinan?
I'll allow the gentleman from Taguig to rebut for 2 minutes, and then we will make the final ruling.
Before I rebut, I'm from Ateneo Law School. And what they taught us there is that you look at the records of the Constitutional Commission and then pag klaro. But let's call someone from UP Law to see whether they were taught the same thing, Senator Pia. May I ask Senator Pia?
We recognize the lady from Taguig, Senator Pia Cayetano.
Thank you, Mr. President. Sa Ateneo UP issue, but always happy to stand before our colleagues and share our experience in the UP College of Law. I was prepared to address this to all our members of the bar in the Senate, but since it is Senator Kiko, my schoolmate, my teammate actually in the UP Volleyball Varsity team who stood up, I'll also specifically address it to Senator Kiko. So dear Senator Kiko and our colleagues in the majority, knowing that you have members in the majority that are lawyers, and for those who are not lawyers, you definitely have consultants who are lawyers. Wala naman siguro ni isang senador dito na walang consultant na abogado. Kahit ako abogado, ang dami ko kong staff na abogado din. Why? Because these are legal issues. We need to talk to the experts. Kung pag-uusapan natin ang mental health, physical health ng Vice President, then of course we will not listen to lawyers. We will listen to doctors, di ba? So this is a legal issue. Let's hear what the lawyers have to say. But let me just quote, because I know the Senate President doesn't have time to call on all the lawyers. So if you ask your lawyers in your staff, I'm sure nag-abala sila to look at the constitutional records, to look at the journal. I'm sure. And if they did not, please take your cell phone now and text your staff. What does the constitutional journal, the records of the debate show? Sinabi na po ni Senator Alan Cayetano, you can question him. You can doubt him. Ask your staff. May I ask you, dear colleagues, let's do our job well. The same way when you stand up and you tell me to do my job well and you disagree, I disagree with your point of view, I will listen intently to your point of view. And I'm looking at each one of you because this is our solemn duty. What does the Constitution say? Nakalagay doon, the Chief Justice, pag the President. Silent nga po sa iba. So sabi ng iba, at yan ang sinasabi ng Senate President natin na mukhang pwedeng iba. So we looked at what the constitutional framers said. What did they say? Nagdebate na po sila, colleagues. Nagdidebate tayo dito. Pag sinabi ng sponsor, ito na yung paliwanag, yung nag-i-interpolate at nagbibigay ng amendment, sinasabi niya, okay, yung pala paliwanag mo, okay na ako. No need to amend. Yun at yun din ang sinabi. Let's place ourselves in that position. Because that happens to us every day. Every day. Somebody stands up and says, ano ibig sabihin nito? And the sponsor will explain. Pag hindi maliwanag, sasabihin nung nag-i-interpolate or nag-a-amend, ay papa-amend ko kasi hindi maliwanag or I want to improve it. Pero kung nagkaintindihan naman, okay na. Eh yun nga yung binasa, tanungin nyo naman po yung staff nyo. Or let's pause, let's all get a copy. Let's show it. Because this is the foundation of this trial na tama yung nakaupong presiding officer. So that's my first point. Mag-abala naman tayo. Read it yourself, ask your staff to print a copy. In fact, on that note, may I ask Senator Alan's staff to print a copy and give it to all our colleagues. Mabilis lang yan, hindi na yan mapapatagalan. Show it. We can take judicial notice naman po siguro of it. Siguro naman, alam na natin ang ibig sabihin ng judicial notice. You can go to the actual records. Nandito na makakuha naman natin yun kung pagdududahin nyo yung ipapaprint ko. So that's my first point. My second point, Mr. President, is addressed to His Honor. If His Honor will insist that we have to call a regular session, we have to be in session to amend the impeachment rules, eh di tawagan niyo po ang Malacanang. Nagpa-special session naman po siya, di ba, with all due respect, to pass the National Orchid Law. To pass, what else? Ay, tatlo yun eh. Oo nga, yun nga, yung waling-waling as National Orchid, ano pa yung dalawa? No, I know, I'm not questioning it. I'm saying that there was a special session called to pass 3 laws. Naalala ko yung waling-waling because I love it. This is important. O ano pa yung dalawa? Unfortunately, hindi ko na maalala. Dalawang naturalization. Sports-minded po tayo. Love po natin yan. Nagkaroon ba ng laban between now and July para mag-special session tayo para doon? Hindi ko alam. But in any case, ito importante to, di ba? Eh di kung pa-i-insist nyo na yung impeachment amendment na yan kailangan gawin ng special session, eh, papapatawag tayo ng special session. Mukha namang very supportive naman ang Malacanang sa majority. Di ba? Pero I take the position that we are in impeachment court. We are already in impeachment court. Therefore, the amendments must happen here. Medyo common sense din naman po yan. I rest my case. Yun lang po. But as soon as the copies come, I will give it to you. Colleagues, look at it. Huwag tayong majority-minority botohan. Ayusin natin yung pagboboto natin dahil pinapanood tayo, pinapaniwalaan tayo, umaasa sa atin ang taong bayan. Maraming salamat po.
Once again, it is, again, before the chair rules, let me acknowledge the former Senate President, Senator Tito Soto.
Thank you, Mr. President. Tama-tama yung sinabi ng distinguished lady from Taguig. Tanungin daw yung mga legal staff. Binigay nga sa akin ng legal staff po, eksakto na ito eh. Article 11, Section 6, page 154. Constitution is silent regarding presiding officer of Senate impeachment. However, the Constitution expressly provides that the Chief Justice will preside if President is on trial. O ngayon, yung mga graduate ng Ateneo at saka ng mga UP, ito ngayon yung legal maxim. Expressio unius et exclusio alterius. In other words, the express mention of one thing is the exclusion of another. Palagay ko, naintindihan nyo lahat ganyan. Itong akin, sa publiko yung sa akin. Ang sinasabi ng publiko ngayon, nanonood sa atin, dapat you should not resort to too much technicalities kasi ang public interest ang iniisip nila rito. They want to expedite the proceedings. They want the trial, not rules. They're interested in the trial, not rules. In the interest of justice, sabi nga nila, sometimes rules are not sacrosanct. But itong nangyayari dito, ang publiko ang importante rito. Where does the Constitution emanate from? From the public. From the people of the Republic. So, decision nyo na ito, Mr. President, para matapos na.
Mr. President, can I have my 2 minutes?
Once again, let me reiterate the position of the chair. My humble position is that this matter should be discussed during plenary when the Senate is convened as a legislative body. And may I ask the gentleman from Taguig if he is objecting to this position?
I'm objecting that position and will call for a vote. May I explain? I think under the rules I can explain why I'm asking.
We'll call for a vote first.
Mr.
And then
President,
we'll allow.
Mr. President, under the rules I can explain why I'm calling for a vote first, so that I can convince them to vote for me.
No, under the rules, there's an objection. The vote will proceed without any explanation,
no,
and after that, we will allow the gentleman from Taguig to explain his vote.
Mr. President,
we call for a division of the House. So those who are,
Mr. President, when you object, you're allowed to explain your objection and state
Senator
your
Lacson
objection.
is recognized. Thank you.
Honors, pursuant to Rule 2 of the Rules of Procedures on Impeachment Trials as amended, I move to elect Senator Judge Francis Joseph Guevara Escudero as the presiding officer of this impeachment court.
Objection, Mr. President, and may I allow to...
We proceed
Objection, Mr. President, I'm allowed to object and I'm allowed to explain my objection.
You're allowed to object, but we will proceed
No, Mr.
with
President.
the division
Mr.
of the
President,
House.
point of
So
order.
those who are,
Point of order, Mr. President.
in favor of the
Mr.
motion
President,
of Senator
you're allowed to
Lacson,
explain para
please-
ma-convince mo nga
please
yung iba.
raise your hand. We will vote by raising of hands. So, those who are in favor of the motion of Senator Lacson electing Senator Chis Escudero as the presiding officer, please raise your hand. The clerk of court is directed to count the votes.
No, in our rules, parliamentary procedure.
How many?
Explain my vote, Mr. President.
Hold on. Let's allow the chair to make a ruling. Those who are against to the motion of Senator Lacson electing Senator Chis Escudero as the presiding officer, please raise your hand. The official count is 12 in favor, 8 against. The majority, those who are in favor, has it.
Mr. President,
The court resolves to elect Senator Chis Escudero as presiding officer of the impeachment court. The duly elected presiding officer shall, under the same oath taken on May 18, 2026, immediately assume and exercise all powers, functions, duties, and prerogatives pertaining to or vested in a person presiding over the impeachment trial under the rules of procedure on impeachment trials, as amended, and shall give full effect to the powers inherent to the courts under Rule 135, Section 5 of the Rules of the Court.
Mr. President, may I now explain my vote?
You are allowed to explain your vote.
Mr. President, first of all, we cannot violate the Constitution. We put the whole impeachment trial at risk here. What Senator Tito Soto, former Senate President, what his staff did not tell him is that there is such a thing as procedural due process, and that who presides goes into due process and fairness. The Latin term that he mentioned was for enumerations. That when there are enumerations at hindi kasali doon, in this case, there was a statement that in only one case it would be the Chief Justice, because member of the Constitutional Commission who became Chief Justice Davide was going to amend precisely the Constitution to state the Senate President shall preside. But upon explanation by the sponsor that it is understood that it is the Senate President, then it should be the Senate President. And dun sa sinabi ni Senate President Soto that ang gusto ng tao ay mag-umpisa na, precisely, kanina pa dapat tayo nag-umpisa kung nag-preside ang Senate President. Secondly, this is when you have threshold issues that go into due process fairness. If we're going to say that ang gusto ng tao i-convict na lang, then let's just blurt it out. Now, if we're going to say we want a fair trial, let's make sure that every aspect of this trial is fair. So that's why, Mr. President, if you read the rules, the presiding officer shall have the power to make an issue by himself or by the Secretary of the Senate all orders, mandates, writs, authorized by these rules of the Senate, and make and enforce such other regulations, orders, premises that the Senate may authorize or provide. Nandito din, Mr. President, that the Senate President may by himself or bottom line, Mr. President, pwedeng mag-decide ang Senate President o sa atin. And Mr. President, there are issues that goes into fairness. You know, the AMLA will be a witness here. And I have information that the 20 years AMLA records of Senator Escudero and his credit cards and bank accounts were all opened up in the office of the Senate President, where members of the Blue Ribbon Committee was here. Then we're going to ask him to preside. So there's a problem. This is my explanation. This is my explanation.
To the gentleman.
This is factual and this is my explanation. So I will stop there.
With all due respect, your statement's already out of order. It has nothing to do with the topic on hand.
No, Mr.
And
President.
the presiding officer will strike off.
It has all to do with this.
Will strike off.
It has all to do.
The statements
Mr. President,
pertaining to Senator
Mr.
Escudero.
President, kaibigan ko si
I
Senator
direct the
Escudero.
stenographers to
I
strike
don't
off
doubt
these statements.
He is the victim here. I'm not doubting him. I'm not doubting he will be fair.
We will
want a fair
suspend
trial
the
or not,
session
Mr.
for a few minutes to request the presiding officer, Senator Chis Escudero, to ascend the rostrum. Session
Mr.
suspended.
President,
And as Senator Alan read, sinabi ni Mr. Monsod, is it not understood that when the President of the Philippines is on trial, it is the only time when the Chief Justice of the Supreme Court will preside? Is it necessary to say that the Senate President will preside during all other times? Ulitin ko yung tanong, kasi yun ang tanong natin today. Is it necessary to say in the Constitution that the Senate President will preside during all other times? Ang sagot ni Mr. Davide, Mr. Presiding Officer, I precisely presented that because we have a distinction when it comes to the Chief Justice of the Supreme Court. But with that clarification, that in all other cases, it would be the President of the Senate who will preside, I withdraw the amendment. Kaya clear sa Constitution that in all other cases, the President of the Senate will decide. Wala, hindi ho applicable dito yung excluso unos. Hindi ko na-memorize yan kasi I graduated in 1991 and we took that up in 1987, but the phrase is, pag hindi kasama, excluded. Hindi po applicable yon with all due respect to our former Senate President. It is the intention of the framers that matter. I will ask the page to help me distribute this among our colleagues. I have also asked our staff to actually copy. I am environmentally friendly, so ayoko sana ng papel. Pero alam ko na hindi po lahat sa atin gumagamit ng digital electronic gadgets, kaya pinapil ko na lang. Pero kailangan ko pakita sa inyo yung mismong nasa journal, yan din yon, my dear colleagues. Yun lang hiling ko sa inyo, intindihan naman natin yung nandito. Bumoto na. Pero intindihan naman natin kasi this is just the first day. We cannot disregard the Constitution. And I continue, Mr. President. We have enough jurisprudence, more than enough, to explain to us, even in layman's term, what basic legal principles are. And one of the most fundamental principles of constitutional construction states that we give effect to the intents of the framers of the Constitution. With this vote, did we give effect to the intentions of the framers of the Constitution? Sinabi nga Senate President ang magpe-preside. Hindi na siguro napakalaking bagay yun dahil kahit sinong ipalit nyo, maayos naman ang mga kasama natin sa colleagues. Sa colleagues natin, maayos naman. Di ho yun ang point. The point is, what are we required to follow? That's why may Constitution. And I will now state for the record a few cases that point out that this is what we are supposed to do. Give effect to the Constitution. Lambino versus Commission election in GR number 174153. The Supreme Court looked explicitly to the Constitutional Commission deliberation to determine the nature of people's initiative. Because the text was debated, the court used the framers' explicit intention. I repeat, the court used the framers' explicit intention, revealed in the plenary debates to prevent deceptive or misleading petition processes and establish a stringent full text requirement. So anong ginawa sa kaso? Tiningnan ang intent ng framers of the Constitution. Another case, Calderon versus Carale, GR number 9163. God bless his soul. Si Dean Carale was my dean. And Senator Imis as well. Senator Kikos as well. He was with my father in the University of Michigan. So, pagbigyan nyo na ako a moment of remembering him. In GR number 91636, the court resolved a dispute regarding the President's power to make appointments without confirmation by the Commission appointment. The court examined the historical and textual context of Article 7, Section 16 of the 1987 Constitution, noting that the clear and express intent of its framers was to exclude presidential appointments from confirmation except for those expressly mentioned. So, balik pa sa kasong to. What was the clear intention? That the Senate President presides. That is the clear intention. Dear colleagues, umpisa pa lang. I beg all of you, makinig naman tayo. Masumunod naman tayo kung ano yung sinasabing trabaho natin. The Constitution, the intention of the framers, and then the clear construct. O, another case. Gold Creek Mining Corporation, Rodriguez. This is a very old case. So yung mga binanggit sa inyo, bago-bago pa yun dahil si Dean Carale, buhay pa naman as of the pandemic. So, 2,000 plus. Ito, 66 Philippines, 259. So, for lawyers and law students, pag sinabing Philippines, pag yan yung ni-record, alam mo ng 50s, 1940s, something like that. Justice Jose Abad Santos articulated the definitive rule. The fundamental principle of construction is to give effect to the intent of the framers of the organic law and of the people adopting it. Dear colleagues, I can stand here and read more cases to all of us. We have law students. We have freshman law students. We have fresh graduate. We have bar reviewees listening to us. Tapos tayo pa lang, hindi natin mabigyan pahalaga ang very clear legal principles. Pati yung prosecution and defense, nakikinig. Sana po, huwag niyong abalahin yung oras namin. Bigyan niyo naman kami ng maliwanag ng mga arguments ninyo because we are willing to listen. Pero colleagues, patunayan naman natin that we are willing to listen. Hindi yung pagpasok natin, nag-prejudge na tayo. Kasi sad to say, mukhang gano'n. I tell you, there will be times I probably will not vote with the minority because I believe tama yung sinasabi ng majority. Sana po, yun ang pakita natin sa taong bayan. So, hindi ko naabalahin yung time dahil kakaupo pa lang ng bagong presiding officer pero ang dami pang kaso that says, look at the intent of the framers of the Constitution. And today, we disregarded the intent of the framers of the Constitution. Magandang hapon po. Gaya ng pag-uumpisa ng hearing na ito.
We know the remarks of Senator B in connection with their explanation of vote. What is the pleasure of Senator Judge Soto?
I'd like to explain my vote also, Mr. President.
The gentleman may proceed and he has 2 minutes.
I have one line to say. That's the reason I voted in favor. Because the minutes of the Constitutional Commission are merely research source.
What is the pleasure of the Honorable Padilla? Will the gentleman explain his vote? The gentleman may proceed. You have 2 minutes, sir.
Maraming salamat po, Ginoong Punong Tagapamahala. Mga mahal kong kasama, sa loob po ng 4 na taon na ako po ay ibinoto ng ating mga kababayan at nagsilbing senador, ako po ay naging tagapangulo ng komite ng Constitutional Amendments. At tuwing meron pong pagtinig, ang lagi po naming pinapatawag ay yung mga sumulat ng konstitusyon. Bilang sila po ang nakakaalam kung ano ang puso, ang diwa ng konstitusyon. Malinaw po na kung meron tayong pakikinggan, yung creator. Hindi po ba? Tayo naman po lahat ay naniniwala sa Panginoong Diyos, kaya tayo po ay naniniwala sa salitang creator, tagapaglikha. At ang lumikha po ng konstitusyon ay itong mga taong nabanggit sa ipinamahagi ng ating mahal na Senadora Cayetano. Malinaw po dito. Nasabi na po sa English ito. Mainam po ay sabihin po natin sa Tagalog upang mas maintindihan po ng ating mga kababayan. Bingi po ako ng tulong sa Google kasi legal terms po ito. Hindi naman po ako nagtapos sa UP, hindi rin po ako nagtapos sa Ateneo, nagtapos po ako ng criminology at UP rin sa University of Prison. Ang sabi po dito, sa Tagalog po Ginoong presiding officer, eksakto ko itong hinihain dahil nagkaroon tayo ng pagkakaiba pagdating sa punong maestrado ng Korte Suprema. Ngunit sa paglilinaw na iyon, na sa lahat ng ibang mga kaso ay ang Pangulo ng Senado ang mamumuno. Kaya binabawi ko ang nasabing susuki. Ang nagsabi po nito ay ang dating Justice David. Ngayon, mga mahal kong kasama, at sa ating pong mga taga-subaybay, ang batas po ay precise. Hindi po ito pwedeng iba-ibahin o paluputin. Kung ano ang sinabi lalo ng saligang batas, ay sana po ay panghawakan natin. Ngayon, sa loob po ng 4 na taon po dito, lagi pong sinasabi yung tradisyon. Minsan, yung rules na yan, nawawala yan. Ilang beses na ako naguluhan dito dahil, teka, sundin natin yung tradisyon kaysa yung rules. 2 beses na po nagkaroon ng impeachment. Yung unang impeachment, ang nag-preside ay yung Chief Justice kay Pangulong Estrada. Yung sumunod po, nandito na po ako noon. Ang nag-preside ay ang mahal na Bicolanong kaibigan ko, Senador Escudero. Yun po kasi yung nasasabi sa saligang batas at tradisyon. Yun na po yung nangyari. Ngayon, gusto ko pong tanungin yung mga kasama ko sa majority. Personal na tanong po ito. Nung hinihikayat po akong sumama sa majority, isa lang ang sinabi ko. Kung si Senator Escudero ang kababayan kong Bicolano ang gagawin yung Senate President, lilipat ako sa inyo. Ang hindi ko maintindihan, bakit ngayon pinipilit natin na ang ating presiding officer si Escudero? Ba't hindi natin siya ginawang Senate President nun? Yun lang po ang tanong ko. Maraming salamat.
The remarks of the gentleman is noted. Senator Marcos, what is your pleasure? Lady may do so. You have 2 minutes, ma'am. Kindly be mindful of the clock.
Yes, thank you very much. Ang sabi sa atin ng bata tayo, kapag mali ang umpisa, mali na ang lahat na susunod. Ayoko naman magkamali sa umpisa pa lamang na napakahalagang paglilitis na ito. Unang-una, paulit-ulit na nating sinaad na ang ating saligang batas ay hindi maaaring balputin. At napakaklaro nito. At ang sinasabi ng ating Constitution of 1987, Article 11, Section 3, Number 6, all other impeachable officers ang sinasabi, carving out therefore the exception that proves that rule, that the Chief Justice is the single exception and otherwise the presiding officer should be the President. It is the exception that proves the rule. Palibasa na uso ang Latin, may kabaliktaran din sa kinote ni Senator Soto, expressio unius est, exclusio alterius. Palibasa, hindi naman in-exempt, ibig sabihin na laging dapat ang Senate President ang presiding officer. Ikalawa, nakita naman natin ang mga debate, ang listahan ng mga sinabi at paliwanag nung dating Chief Justice natin, si Mr. Davide, nung panahon ng convention. Contextual reading and the thorough debate do not allow for any interpretation whatsoever. And we should abide by that. Ikatlo, yung kaduda-dudang forum noong June 3 na pinapaliwanag ng aming minority leader na hanggang ngayon nakatenga pa rin. Kung tutuusin, nung sinasabing na amyenda, yung Supreme Court petition ay pending pa. Kaya hindi karapat-dapat na yun ang sundan. Ikalima, it's not the impeachment court but the Senate that amended the rules. Kaya para sa akin, napakaraming dahilan. Huwag sana nating sayangin itong napakahalagang responsibilidad natin at huwag mag-umpisa sa mali itong paglilitis. Maraming salamat.
Thank you, Senator Marcos. Duly noted and entered into the records. The pleasure of Senator Judge Legarda.
Thank you, Mr. Presiding Officer. Where the Constitution is silent,
He will explain her vote or make a manifestation.
it's a manifestation. Which
may proceed with the
seems like a
manifestation.
manifestation vote. Thank you. Where the Constitution is silent, the intent of the framers should guide the choice of the presiding officer. Any departure from the traditional arrangement must be approached with caution, as it may place the validity and the legitimacy of the entire impeachment in doubt. Mr. Presiding Officer, I also respectfully place on record that there is a pending challenge before the Supreme Court involving the June 3rd Senate proceedings, including the authority of the body then that adopted Senate Resolution number 430. This manifestation is made to place on record that we are not yielding our position in the pending case and is without prejudice to the final determination of the Supreme Court. Thank you, Mr. President.
Thank you, Senator Legarda. The presiding officer would like to make a statement.
Sa mga ginagalang kong kapwa Senator Judge, sa ating mga minamahal na kababayan, sa mga partido sa kaso na kabinbin ngayon sa Senado, isa pong maganda at pinagpalang hapon sa ating lahat. Sa araw na ito, muling gagampanan ng Senado ang isa sa mga pinakasagradong tungkulin iniatas ng saligang batas. Ang pag-upo natin bilang isang impeachment court para litisin at husgahan ang pangalawang Pangulo. Kinikilala ng ating saligang batas na may mga opisyal na may hawak ng kapangyarihan at pananagutan na napakabigat para sa kanila lamang itinakda ang impeachment bilang tanging paraan para sila ay panagutin. Article 11, Section 2 of the Constitution enumerates these officials: the President, the Vice President, the members of the Supreme Court, members of the Constitutional Commissions, and the Ombudsman. They are not ordinary public officers. According to the late former Juan Ponce Enrile, they hold, quote, the highest and most sensitive offices of government. They may be removed from office only upon conviction for offenses of the highest constitutional gravity: culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of the public trust. Impeachment is a means to preserve constitutional government through the removal and disqualification, if so warranted, of an unfit official from a position of public trust. 5 opisyal pa lamang ang na-impeach ng Kamara de Representantes sa ating kasaysayan sa ilalim ng 1987 Constitution. Una, si dating Pangulong Joseph Estrada noong 2001 na ang paglilitis ay naungusakan ng mga pangyayaring humantong sa EDSA 2. Ikalawa, si Ombudsman Mercy Gutierrez noong 2011
na nagbitiw bago pa man mabuksan ang kanyang paglilitis ng Senado. Ikatlo, si Chief Justice Renato Corona noong 2011 din na nilitis na patunayang nagkasala at inalis sa tungkulin ng impeachment court bilang punong maestrado. Ika-apat, si dating COMELEC Chairman Andres Bautista noong 2017 bagamat nagbitiw siya sa pwesto bago pa man mapadala ang articles of impeachment sa Senado. At ikalima, si Vice President Sara Duterte noong 2025. Subalit ang nasabing articles of impeachment ay dineklara ng Korte Supremang null and void ab initio kung kaya't ito ay in-archive ng Senado. Siya ay muling na-impeach sa kasalukuyang taon at ngayon nahaharap sa paglilitis na ito. Ipinakikita lamang na may kintalaan ito na ang impeachment ay hindi isang pangkaraniwang kaganapan. Turing nga ng Korte Suprema, quote, "It is the most difficult and cumbersome mode of removing a public officer from office." Subalit, ang paglilitis na ito ay hindi lamang hindi pangkaraniwan. Ito ay tunay na bukod tangi. Bakit? Una, si Vice Presidente Sara Duterte ang kauna-unahang opisyal na 2 beses na na-impeach ng mababang kapulungan. Pangalawa, siya ang kauna-unahang Vice Presidente na haharap sa paglilitis ng isang impeachment court at pangalawang opisyal lamang na halal ng sambayanan na sasailalim sa prosesong ito. Pangatlo, siya ay hinahalal ng may pinakamalaking mandatong pinagkaloob ng sambayan ng Pilipino sa sinumang kandidato sa ating kasaysayan. Mahigit 32 milyon o 61% ng kabuuang boto para sa ikalawang Pangulo. Pang-apat, ang articles of impeachment laban sa kanya ay inendorso ng 277 na miyembro na kumakatawan sa ating mga mamamayan mula sa iba't ibang distrito at sektor at ng ating bansa. Nakatumbas ay mahigit 80% ng kabuuan ng Kamara de Representantes. Terminating an elected mandate before the end of its term is among the most drastic acts our constitutional democracy can undertake. This is why the trial must be guided with prudence, tempered by caution, and marked with unquestionable impartiality. We must avoid even the appearance of impropriety and observe the cold neutrality of an impartial judge at all times. May I therefore caution my fellow senator judges, the prosecutors, the respondent and their respective counsels and witnesses to refrain
judicial review, render it in case either one or both panels in front of us should they deem it as a grave abuse of discretion by this court. I submit, Your Honor.
The response of the presiding officer is in the affirmative. In fact, the journal that we just approved contains a similar inquiry by Senator Judge Cayetano yesterday when he inquired if it was the position and ruling of the presiding officer, and the presiding officer answered in the affirmative. So to clarify, yes, I believe it may be considered already as a justiciable controversy, although it is not for us to dictate that but the courts, given that it is a ruling of the chair not objected to nor appealed by a member of this court, and then
Yes. I confirm that yesterday we heard the same thing, and when the transcripts come out, of course, then it will be available to everyone. Basically, yesterday I clarified whether that was the opinion of the elected um, presiding officer, and of course, without any offense to my brother and friend Senator Escudero, we have a continuing objection. I asked him whether this was already a ruling of the court, because if it's the ruling of the court, then as a threshold issue, we will have no further questions. Section 22, Article 22 of our rule says that all orders, decisions may be acted upon without objection, or if objection is heard, the orders and decisions shall be voted on without debate by ayes and nays, which shall be entered in the record, subject, however, to operation of Rule 6, and Rule 6 speaks of whether the presiding officer will rule on relevance, admissibility, and giving any movement 2 minutes. So I may also correct that yesterday I was not allowed to, when I objected to Senator Lacson, I should have been given 10 minutes. In accordance with 22, but I do admit that before that, in the point of order, Senate President Gatchalian was liberal in allowing us to explain. Anyway, everything has been explained yesterday as part as the Constitution. In writing, we will do so. But just on this point of the threshold issue of 2/3 of all members, there is actually a pending case in the Supreme Court entitled Cayetana versus Aquino. That is my on this issue itself. And I just like to make sure today and further clarify, no objections that as of today, the stand of that of all members means that as long as you're still a member, so meaning when are you not a member anymore? When you die, when you are removed by penalty, and when you resign. Otherwise, you are still a member, so you are still counted. And it is in that spirit that we asked and were preparing maybe a memoranda for all members to allow Senator Marcoleta and Senator Jinggoy, since they are going to have a vote. And if they are not allowed to vote, then that will be counted as a vote for acquittal. And that might be favorable to the defense rather than a part of giving a fair trial. So all I wanted to clarify today, Mr. President, is that we will continue to thresh out if there are any constitutional issues. But as of today, it is very clear that as a court, we have decided that 2/3 of 24, there are 24 members of the Senate today. 20 are present here today, but there are still 24 members, and 16 number of senators needed to convict on any of the articles, Mr. President. Mr. Presiding Officer, thank you.
What is the pleasure of Senator Judge Pangilinan?
Thank you, Mr. Presiding Officer, Mr. Senate President. Just to place on record that I would like to clarify that the ruling of the chair of 16 is as to the issue of whether the threshold number of conviction. The matter of whether or not Senators Marcoleta and Senator Estrada should be participating in the process of the trial is another matter that we will have to discuss perhaps in camera or on the floor at a later date, Mr. President.
Noted. If there are no other senator judge who wishes to make a manifestation, the lead prosecutor, Representative Luis Reyes, once again recognized. What was your earlier manifestation and motion, ma'am?
Your Honor, we respectfully reiterate our request that counsel for the panel of prosecutors, Attorney Lorna Capunan, be recognized.
Counsel for the panel of prosecutors, Attorney Lorna Capunan, is recognized. We
will you be the one to present your first witness, ma'am?
Good afternoon, Your Honors, Senate President, Presiding Justice. I do have manifestation. Well, in direct answer to the query of the presiding Senator Judge, I am not presenting the witness today. But I would like, with your permission, Your Honors, to manifest a query that we request be addressed by this Honorable Court, Presiding Judge, to the defense.
The lady may proceed.
We are informed, and in fact, we have seen an interview conducted in the Senate premises on the Vice President herself. And she had been quoted as saying that she is expecting a bloodbath and a bludgeoning, but maybe blooded but unbound. My respectful query, Your Honors, please, which could be directed to the defense counsels, is if the Vice President is in the premises, does she intend to appear personally before this impeachment court? And that is preliminary to another manifestation that I would like to make.
Kindly proceed with your next one, counsel. Because the chair is not yet sure if it will even address this to the counsel for respondents, or will simply answer the query of the counsel for respondents.
This is relevant to the presentation that we will be making this afternoon, Your Honors. This court will recall your own statements, Mr. Presiding Judge, that on Tuesdays, every Tuesday of every week, that the prosecution must indicate who the witnesses they intend to present before this court will be. This is to enable the impeachment court to issue, when appropriate, and if deemed necessary, a subpoena for such witness. And that is my query this afternoon, because a net presentation of witness on the first article that we will be presenting, which is grave threats and acts of sedition, Your Honor. The one of the key witnesses, hostile, albeit hostile, would be the Vice President. And therefore, if we can inquire if it is her intention to again appear in the premises of the Senate, because we are already respectfully informing this Honorable Court that we will manifest, that we will have a written request for her presence in connection with this article on grave threats. You know, that is the relevancy of my manifestation.
The chair would like to rule on the manifestation and request of the counsel for prosecutors instead of throwing the question to the counsel for respondents, for the simple reason that I do not want the parties to engage in a debate before this court. You can very well do that with the presentation of your witness through direct and cross-examination, redirect and recross. To answer, the impeachment rules do not mandate nor require the respondent to attend any hearing or trial of the impeachment court. Whether she was in the building earlier or arrived after, it is totally up to the respondent, because from the point of view of the court, she is represented in this court through her counsel already. Should the counsel for the prosecutors desire to call the respondent herself, the court will act on that motion and request once it is made and or filed, and need not make a ruling at this point in time. Because of course, when that motion is made, we will ask the counsel for respondent to make a comment and or reply.
Thank you, Sir Presiding Judge, Justice, Senator Judge. We yield to the wisdom of your decision.
Thank you.
With that, we will reserve the right. We are not waiving the right to call her at the appropriate time and to file the appropriate request for subpoena to sistecum and subpoena testificandum. For that, on that matter, Your Honor, I have no further questions. questions and would like to turn over the floor to our lead public prosecutor.
Thank you, Council Prosecutors, Attorney Lorna Capunan, for your remarks, which are duly noted. Yes, the lead prosecutor is recognized.
Your Honor, as manifested yesterday, the articles of impeachment is divided into 4 teams, and I would like to turn over to the head prosecutor of Article 4, that is threat, the Honorable Lawrence Defensor. May I request that he be recognized, Your Honor?
The member of the panel of prosecutors, Congressman the Honorable Lawrence Defensor, is recognized for his introduction of Article 4, I presume.
Thank you so much, Mr. Presiding Officer. May I be allowed to make a manifestation to introduce Article 4?
Before you proceed, Senator Judge Cayetano is recognized.
Before that, I ask for your indulgence from the prosecution and the defense. There are certain issues that we are more than willing to listen to the debate here. I'm speaking for myself, but I think for also other senator judges, and of course will give us much leeway. But there are certain issues that we also need time to study. So if we look at our rules of impeachment, supplementary kasi yung rules ng rules of court. And the difference between asking the accused to take the stand and asking someone who's not the accused, but we may say something that is incriminatory. There's a wide difference. So the accused, under the rules of court, hindi mo pwede forced to take the stand. Pero yung hindi accused, they have to take the stand and wait for the question. And then they can claim the right against self-incrimination. But it could be argued that this isn't exactly a criminal court, a criminal offense. It's an impeachment court. So if it pleases the court, or if the prosecution is sure to ask for the subpoena, may I propose the presiding officer that both sides give us a memoranda in advance so that we can also do our part and study rather than spend much more time during the debates, because I really like to study that issue also. Thank you, and sorry for the interruption, Congressman.
Noted, Senator Cayetano. However, it is premature at this time. We will do what we did with respect to the motion for the issuance of subpoena at this Testificandum Indus Tecum in regard to the bank accounts of the spouses Duterte and Carpio, as well as the MLC records. We require the parties to submit a memoranda, and we will be scheduling it for oral arguments by the parties. If that is the desire of the Honorable Senator Judge Cayetano, we will do the same with respect to this once the motion has been filed formally by the panel of prosecutors. The Honorable Defensor is recognized. You may proceed, sir.
Thank you so much, Your Honor. Honorable Senator Judges, noong 22 ng Hunyo 2026, nagulat at nagdalamhati ang buong bansa sa pamamaril sa isang paaralan. Sorry, excuse me. Your Honor, may I be allowed to finish my manifestation? I will not disrespect and interrupt the defense counsel. Yes, but before once she has started. There's no disrespect.
Counsel for respondent is recognized.
Thank you, Your Honor. Your Honor, this is improper. The improper for trial. Manifestation, this is not a manifestation proper for court procedure. This is instead them telling a story. This is a narration by the prosecution, which is not allowed. This is not allowed by any rule in any court. So what is proper is that they present their first witness, and we will be presenting our witness, Your Honor. However, please allow us to freely advocate our position. That's why you're including the defense when it's their turn. We will not object to this.
Kindly let him finish.
Thank you so much.
To respond to you. Yes, you were saying.
Thank you, Honorable Senator Judges. Noong ika-22
Sir, kindly finish your reply to the objection of counsel for respondent.
Allow us to freely advocate our positions through the proper and respectful discourse. This is not prohibited under the rules. In fact, the court has declared that yesterday, the rules will not comply with the strict procedures of a judicial proceeding. Each article is a separate complaint, and it would be the proper guidance for the senator judges, lalo na po sa ating mga kapwa Pilipino na nanonood, para mas lalo nilang maunawaan ang ipipresenta naming ebidensya. The impeachment is a sui generis. Sui generis dahil kakaiba ito, hindi ito judicial, administrative, o civil o criminal proceeding. Hayaan niyo po kaming magbigyan ng 5 minuto para mailatag namin kung paano namin maipresenta at ang basihan namin sa pagpresenta ng aming ebidensya. Your Honor, may I respond?
The presiding officer, Sir Rule, although indeed we will interpret the rules liberally, and although indeed this is a sui generis proceeding, neither will we allow any dilatory moves and or tactics, and I will bind and hold you to your 5 minutes, Honorable Defensor.
Absolutely, Your Honor.
Clock it.
Your Honor,
we will afford the same opportunity to the counsel for respondents when their turn arrives.
Thank you, Your Honor. May I proceed, Your Honor?
You may proceed.
Honorable Senator Judges, noong ika-22 ng Hunyo 2026, nagulat at nagdalamhati ang buong bansa sa pamamaril sa isang paaralan sa Tacloban City na ikinasawi ng 3 batang mag-aaral at ikinasugat ng maraming pang iba. Ang mga salarin, mga minor de edad, sa kabila ng kanilang murang edad, agad na pumilos ang mga otoridad.
So, senior ko kasi
ang mga umiiral na batas. Ang mensahe ay malinaw. Ang pagtigiging bata ay hindi nangangahulugang walang pananagutan. Ang pananagutan ay umiiral. Bagamat iba ang paraan ng pagpapatupad nito sa ilalim ng batas. Kamakailan, isang pasahero ang inaresto sa airport at kinasuhan matapos itong magbiro na may bomba sa kanyang bagahe. Dahil mahigpit, pinapatupad ng mga otoridad ang patakarang zero tolerance policy sa anumang pagbabanggit ng bomba o anumang pangpasabog. Sa isang hiwalay na pangyayari noong Mayo 2020, isang public school teacher ang inaresto, pinusasan at kinasuhan ng NBI sa Zambales matapos magbiro na magbibigay ng pabuya sa sinumang papatay sa presidente ng Republika. Ano ang prinsipyo dito? Ang pananagutan ay pinapairal sa lahat. Bata man o matanda, nasa laylayan man o nasa katungkulan. The prosecution comes before you today to present evidence for Article 4 establishing that Vice President Sara Duterte committed acts that betrayed the public trust, committed culpable violation of the Constitution, committed high crimes in publicly admitting through a live broadcast that she contracted someone to assassinate the President, the First Lady, and the former House Speaker. We acknowledge the burden of this trial on the senator judges as well as the Filipino people. But it is a duty that we must discharge together, lest the public come to believe that threatening public officials and fostering a culture of impunity are conduct that may be tolerated or condoned, especially coming from the second highest official of the land. Ang mga kilos at salita ng Vice Presidente ay hindi dapat ituring na simpleng krimen sa ilalim ng batas, kundi tuwirang paglabag sa saligang batas. Kaya ang paglilitis na ito ay mahalagang mekanismong itinakda upang tiyakin na ang kapangyarihan ay laging may kaakibat na pananagutan. Accountability must apply to all or none at all. At the heart of this impeachment proceeding lies a fundamental question para sa ating lahat. Can we continue to entrust one of the highest constitutional offices to a public official who, on multiple occasions, purposely and willfully and repeatedly resorted to threats of violence against the very institutions that she swore to uphold and protect? The evidence presented in this article are not just derived from testimonies and authenticated documents, but from the Vice President's own words, own conduct,
were neither accidental nor taken out of context. They were uttered publicly with the intention to be taken seriously. Huwag kang mag-alala, ma'am, sa security ko. Kasi may kinausap na ako na tao. At sinabi ko sa kanya na kapag pinatay ako, patayin mo si BBM, si Lisa Marcos, si Martin Romualdez. No joke. No joke. What makes these threats especially sinister is that they do not come from an ordinary citizen, but from the Vice President herself, an official who, under the Constitution, stands to succeed the President of the Republic. Such statements carry a gravity far from the exercise of one's freedom of expression. They strike at the very heart of government. This is especially significant given that she has publicly declared her intention to run for president in the next election. What values do we expect from those who occupy the highest office in the land?
Call your first witness,
Your Honor, may I be allowed also to... Your Honor, we move to strike that opening statement. It's improper for trial. It is not evidentiary in nature. And it only provides conclusions of fact and law. Most of it is irrelevant. And fact of the matter is, the prosecution should present evidence and not manifest in this improper manner. May I be recognized, Your Honor?
No need. Motion is denied. Let it remain in the records and as instructed by the chair for the center judges not to consider, deem whatever statements were given by the Honorable Defensor as evidentiary in any way, shape, size, or form. Again, counsel, call your first witness.
Your Honor, may I permission to recognize counsel for the panel of prosecutors, Attorney Virgil Ligutan, to conduct the examination of our first witness. Your Honor, will be under the direct suspension and control
what is your pleasure?
of the panel. May I register my continuing objection to the opening statement by the prosecution.
Well, I don't think he'll do it again, but nevertheless, so noted.
Thank you. Your Honor, may I request that Attorney Virgil Ligutan be recognized to conduct the examination of our first witness.
Counsel for prosecutors, Attorney Virgil Ligutan, so that we can have the records clear. Did I pronounce your name correctly, sir?
Your Honors, magandang hapon. My full name is Attorney Armando Virgil Descartes Ligutan, Your Honor.
And you've entered your appearance yesterday?
Yes, Your Honor. Duly entered my appearance as one of the counsel for the prosecution.
You may proceed, sir. Call your first witness.
Thank you so much. Mga kababayan, we call to the witness stand the first witness for the prosecution in the person of NBI Senior Agent John Mark Santa Ana Calino.
Kindly bring the witness to the witness stand. Please remain standing. Clerk of Court is instructed to kindly administer the oath to the witness.
Please raise your right hand. You, John Mark Calino.
I, John Mark Calino.
Do swear.
Do swear.
That the evidence you shall give
evidence that I give
in the case now pending
is in the case now pending
between the Philippines and Vice President Sara Zimmerman Duterte
and Vice President Sara Zimmerman Duterte
shall be the truth,
shall be the truth,
the whole truth, and nothing but the truth.
and nothing but the
So
truth.
help me God.
So help me.
Your witness, counsel.
Thank you so much, Your Honors. Your Honors, mga kababayan, the testimony of the first witness for the prosecution, NBI Senior Agent John Mark Santa Ana Calino, is offered to prove the following. Number one, si Agent John Mark Calilong ay isang senior agent of the National Bureau of Investigation. Number two, he is well-trained and experienced in the field of digital forensic examination, having undergone extensive training in the field, making him competent in identifying, preserving, collecting, and authenticating digital evidence. Pangatlo, si Agent Calilo ay bahagi ng NBI Cybercrime Division Team na inatasang mag-imbestiga sa mga pahayag at pagbabanta ng Vice Presidente laban sa Pangulo ng Pilipinas, unang ginang at dating Speaker ng House of Representatives sa isang online media briefing noong Nobyembre 23, taong 2024. Pang-apat, partikular na sinabi sa publiko ng Vice Presidente na may kinontrata na siyang tao na papatay sa Pangulo, unang ginang at former Speaker ng House of Representatives. At ito ay nakatatag na sa kasaysayan ng ating bansa bilang unang pagkakataon na ang isang Vice Presidente ay nakipagkontrata sa isang mamamatay tao upang patayin no less than the President of the Republic of the Philippines. Panglima.
Your Honor, may I object? Is this a speech or an offer?
Your Honor, please, with all due respect to counsel, it should not be.
May I register my continuing objection?
No proper ground. This is offer of testimony. Please hold your horses. Number 5, the public statements and threats of the Vice President were publicly live streamed and captured on video. Number 6, Agent Calilong is a designated agent on case for the investigation. Number 7, as agents on case, Agent Calilong personally conducted and participated in the cybercrime and open source investigation relating to the subject video and related digital recordings. Pangwalo, sa takbo ng open source investigation na pag-alaman ng NBI na ang Vice Presidente ay nagpahayag din ng iba pang kahawig na pananakot sa buhay ng Pangulo. Kasama na ang sinabi niya sa publiko na minsan naisip niyang pugutan ng ulo ang Pangulo ng Republika ng Pilipinas. Number 9, in the course of the investigation, Agent Calilong duly identified, preserved, collected, and authenticated the subject video and other related digital recordings. And number 10, the last offer of testimony, Your Honors, Agent Calilong will testify on such other matters as may be relevant, material, incidental to the issues involved in this impeachment proceeding, and well-identified, relevant, and material documentary and object pieces of evidence. That is the offer of testimony of our first witness, Your Honor, please.
Mr. Honors, I will now hear the objection and or comments, if any, of the counsel or respondent to the offers made by counsel for the prosecution.
Your Honor, may we move for the exclusion of Agent Calilong for being not previously attached to the Cebalya and Cabrera complaints, as well as exclusion on the ground that he was not included in the articles of impeachment transmitted to the Senate Impeachment Court.
Can I respond to that, Your Honor, please?
Counsel for prosecutor may do so.
Mga kababayan, in this stage of the proceedings, the prosecution is about to present a witness, and the defense is invoking the fact that this witness is not listed as one of the witnesses in the Sabaya complaint. The Sabaya complaint already lived its natural life. Your Honor, this is the impeachment proceeding of the articles of impeachment filed by the House of Representatives. Sabaya itang is done. That should not be a proper objection, Your Honor, please. As to the number 2, I think the good counsel mentioned that it is not part. This witness is not part of the articles of impeachment. Your Honor, please, I have been practicing for quite some time. I don't see that.
Your Honor, may I allow to reply?
Can I finish? It's not a ground. And in fact, Your Honor, please, to settle the matter, this witness is listed in the pre-trial order. The issue is settled. The issue is passé. No ground for objection. Let me proceed, Your Honor.
Of course not, Your Honor. There were no rulings.
Counsel for respondent is recognized for a final rebuttal on this issue before the chair will issue a ruling.
Your Honor, there were no rulings on the pre-trial order on exclusion of witnesses. We have a current petition with the Supreme Court in the very essence of the prosecution to allow the presentation of evidence that were not attached to the Sabaya or Cabrera impeachment complaints would allow the House of Representatives and the prosecution to circumvent the very procedural abuse condemned in Stonehill versus Jokno and allow the violation of the respondent's constitutional rights as held in Duterte in the House of Representatives. Your Honor, the prosecution says the Sabaya complaints have lived and they died their natural deaths. However, Your Honor, this precisely does not cure what the prosecution did. This does not cure the violation of the rights of my client.
If I may, Your Honor, please.
The chair will make its ruling. The motion to exclude by the counsel for respondent is hereby denied. Chair cites Enrile versus Sandigan Bayan, which states that the prosecutors may add or rely on evidence during pre-trial even if the evidence is not stated in the complaint or articles because only a summary is required to be stated in the articles of impeachment in this case and or complaint and not a complete list of the prosecution's evidence and or witnesses. The court in general will not shackle the prosecution by limiting it to the evidence mentioned in the information and or the articles, especially when it is mentioned in the pre-trial brief, not only order but brief of the counsel for prosecutors. But in relation to this witness, even if you will do cross, you can register your continuing objection, counsel for respondent.
We are registering it, Your Honor, please.
So noted. Counsel for the prosecution may proceed.
Thank you so much, Your Honor. John Mark Calidon.
Your Honor, may I register my objections to the purposes?
Please, I think the purposes must be specified. What are your objections?
Exactly,
On what grounds?
May comment on the offer. The testimony of this witness for the record.
Your Honor, for the purpose number 3, this is a conclusion of fact and law. For the fourth purpose, it is also a conclusion of fact and law. And the 8th purpose, it is a conclusion of fact and law.
Mr. President.
Counsel for respondent. Before we, yes, Senator Judge Guerra.
Yeah.
Pia.
I would just like the defense, when you say item number 3, can you repeat what it is? Because I'm trying to follow exactly what your objection is. So either you say it or he repeats it so we can follow.
I was about to do that actually.
Thank you.
Item number 3 in the offer of this witness is that the NBI agent being presented is part of its cybercrime unit that investigated this matter. That's what you're referring to as a conclusion of law, counsel?
Sorry,
That's number 4.
number 4, Your Honor. Yes.
Not number 2. So number 4 and what else?
Number 8, Your Honor.
Number 8 on other threats other than the video mentioned in the press briefing.
Yes, Your Honor. Correct, Your
Would
Honor.
that be all?
Yes, Your Honor. We will not reply to that, Your Honor, please.
Yes, please.
May I continue, Your Honor, please?
You may continue to present your first witness, counsel.
Thank you so much, Mr. Calilo. Reminder, nakikinig yung taong bayan, pakilakasan ng boses. Okay? Okay. Mr. Witness, maaari bang sabihin mo ano yung pangalan, edad, at other personal circumstances?
I am Senior Agent John Mark Calilo, a Filipino citizen, 31 years old, with office address at NBI PhilInvest Cyberzone Bay City, Papagal Boulevard, Pasay City, sir.
And Mr. Witness, reminder you may answer in Filipino or Tagalog or Filipino or English. Okay? Mr. Witness, what is
Currently, nasa National Bureau of Investigation po ako. I'm an agent since 2021 and was recently assigned at Cyber Investigation and Assessment Center in April 2026.
okay? You said that you have been an agent at the NBI since 2021, pero you were recently assigned to the Cybercrime Investigation and Assessment Center of the NBI. Now, ano ba yung position mo before you were assigned to the Cybercrime Investigation and Assessment Center, kung meron na?
In 2022, I was assigned at Digital Forensic Laboratory Division and in 2024 in Cybercrime Division, sir.
Okay, now, you said that you were assigned to the Digital Forensics Laboratory Division in 2022. Now, yung tanong, ano ba yung mga naging primary duties and functions mo bilang ahente ng division na yan?
In digital forensic, my primary duties is to identify, preserve, collect, analyze, and present digital evidence in court, sir.
Now, preliminary question, have you undergone any training as an agent of that Digital Forensics Laboratory Division?
Yes, sir.
Now, kung alam mo, ano ba yung naging trainings in that division?
I have undergone computer hacking forensic investigation training, mobile forensics, computer forensics, and photo and video authentication training, sir.
Okay, so the last part of your answer, Mr. Witness, you mentioned that you were trained, na sinasabi mo, into photo and video authentication. Now, specifically now, ano ba yung naging trainings in that regard? Photo and video authentication, kung meron man.
I was trained for 2 weeks intensive training in July 2022 by Max Court Intervention, sir, in digital forensic.
Now, sabi mo, ano nga ba yun? 2 weeks of intensive training. Yung tanong, Mr. Witness, specifically, what happened in that you said 2 weeks of intensive training?
I was trained to perform digital forensics examination, sir.
Now, Mr. Witness, you tell the public, what is the objective, if any? What is the objective, if any, if you know, of that digital forensic examination that you said you were trained to do?
To present digital evidence, sir, admissible in court. Ginawa ko na to multiple times.
Multiple times. You appeared in court multiple times. Specifically, how many times?
At least 30 times, sir.
And for how long have you been practicing digital forensic examination?
2 years, sir.
For 2 years. Now, let's go back, Mr. Witness. You mentioned that you were an agent of the NBI Cybercrime Division in 2024. Now, what were your primary duties and functions as an agent of that Cybercrime Division?
To investigate cases in violation to the cybercrime law, sir.
Cybercrime law. Now, Mr. Witness, you are testifying in this impeachment case proceeding trial against the Vice President, the respondent in this case. Do you know the respondent in this case?
Yes, sir.
And why do you know the respondent in this case?
Because she is the Vice President and my team conducted an investigation involving her, sir.
So aside from being the Vice President, your team, you said, investigated the Vice President. The question now is, what was this investigation, if you know?
It's an investigation on the statement uttered by the Vice President during an online press conference briefing dated November 23, 2024.
So, statements uttered by the Vice President in an online live stream press conference held on November 23, 2024. Now, yung tanong, ano ba yung naging participation mo, Mr. Witness, kung meron na?
I am the agent on case of the investigation, sir.
Now, sinabi mo ikaw yung agent on case. Now, you tell the court, you tell the public, ano ba yung pagiging ahente on the case? Ano bang ibig sabihin niya kung alam mo?
It means that I gathered evidence necessary for the investigation, sir.
Okay. You mentioned you gathered evidence. Now, you tell us, what do you mean? Kung meron man, kung alam mo, ano bang ibig sabihin when you quote, gathered evidence and quote?
It means that I viewed, identified, preserved, collected, and authenticated digital evidence in the course of the investigation, sir.
Okay, now, you mentioned you viewed, identified, preserved, collected, authenticated, sabi mo mga pieces of evidence that you found in the course of your investigation. Tama ba? Now, Mr. Witness, yung tanong is, ano ba yung mga ebidensya na nakalap ng inyong team?
One of the pieces of evidence that we gathered during our investigation
in the briefing ng Vice President noong November 23, 2024, ano ba yung mga hakbang kung meron man na ginawa nyo to preserve that video?
The NBI Cybercrime Division, through me, initiated a preservation request po kay Meta.
Okay, you initiated a preservation request to Meta. Now, sinabi mo kanina na live stream yung subject video sa isang Facebook page ng isang Harry Roque, di ba? Now, yung tanong, why is it that your request was made to Meta?
Si Meta po kasi yung parent company po ng Facebook. Under po ng Meta, si Facebook, si Instagram, siya si WhatsApp. All requests on that platform will go to Meta po.
Alright, now, Mr. Witness, what proof, if any, do you have that you initiated a preservation request to Meta in order to preserve the subject video?
I have a screenshot of the preservation request, a screenshot of the web page wherein I made the preservation request, sir.
Who took the screenshot?
I did, sir, and I used my laptop.
Anong ginawa mo sa screenshot kung meron man pagkatapos yan?
I first saved po yung electronic copy sa laptop ko, then printed it.
Where is this print out of the screenshot now?
Sinubmit ko po sa Committee on Justice of House of Representatives.
Your Honor, with the court's indulgence, may I move that this representation be assisted by co-counsel for the sole reason of facilitating the presentation of the documents to the witness, Your Honor, please. For that reason alone.
Sa Tagalog siya mag-aabot?
Yes, Your Honor. Siya po yung mag-aabot ng mga dokumento na amin pong ipapakita for the witness to identify po.
So may proceed.
Thank you so much. Assisted by Attorney Stephen Magayon. Now, if this printout is shown to you, will you be able to identify the same?
Yes, sir.
Now, we invite the defense to also peruse the document.
Your Honor, may I request that one of our counsels be allowed to peruse the document?
Yes, one of the counsels for respondent may look at the document being presented to the witness.
May I continue, Your Honor, please? Thank you. Now I'm showing you. Defense, can we give the document to the witness, please? Your Honor, the document must be presented to the witness.
Your Honor, we
Give them some time to look at it. But is this one of the documents pre-marked?
Yes, Your Honor, please.
For the record, can you state the pre-marking of this document just so that we can catch up?
Much obliged, Your Honor, please. That would be P dash Roman numeral 4 dash 7 for the prosecution, Your Honor, please.
Noted. Your Honor, may I manifest for the record that this is not a certified true copy?
Noted.
Your Honor, can I respond to that, Your Honor, please? This is an electronic copy. The rules on electronic evidence says a printed version of electronic copy is an original. Your Honor, please.
Your counsel for the prosecutor, counsel for respondent did not object. He just simply made an observation regarding the document. So you may proceed as soon as the document is returned to the witness.
Thank you so much, Your Honor, please. What relation? Mr. Witness, are we ready? What relation, if any, does these documents have with the printouts of the screenshot that you mentioned?
This is the copy of the printout that was submitted to the Committee on Justice, sir.
Okay, Your Honor, please, may I proceed with the next question, please? Question, Mr. Witness, how faithful, if at all, is this printout from the actual screenshots?
The printout accurately reflects the screenshot, sir.
And how do you know now that this printout accurately reflects the screenshot?
I compared the printout with the screenshot and with the web page of my preservation and found that the contents are identical, sir.
Thank you so much. Now, Mr. Witness, ano ba ang nangyari kung may after you made the preservation to request to Meta in relation to the investigation you did on the Vice President?
Meta acknowledged our preservation request, sir.
Your Honor, please, the exhibits as they come, as they are identified by the witness, are also simultaneously being presented on the screen already. Okay, now you said that Meta acknowledged the preservation request, correct?
Yes, sir.
Now, yung tanong ay, ano bang pruweba mo? Kung meron man, that's in fact, Meta acknowledged the request.
I have a screenshot of the acknowledgement of Meta email acknowledgement.
Now, who took the screenshot?
I did, sir, and I used my laptop.
What did you do with the screenshot kung meron man?
Sinave ko muna po yung electronic copy ng screenshot sa laptop ko and printed it.
Where is this printout of the screenshot?
Sinabit ko po sa Committee on Justice of House of Representatives.
Now, kung yung printout ng screenshot ipapakita sa'yo, will you be able to identify the same?
Yes, sir.
Now, we are now in the process of showing you yung isang printout ng isang screenshot ng isang tugon o reply ng Meta. Your Honor, that is previously marked as Exhibit P dash Roman numeral 4 dash 8 for the prosecution.
Your Honor, may I have time to peruse?
Kindly show the document to one of the counsels for the respondent.
Your Honor, we note that the Exhibit P-I
IU-8 is not an original or certified true copy, and we object to the introduction of this and the identification of this.
What does counsel for the prosecution say?
Again, I reiterate, if it is a printout of the electronic document, the rules are clear, that is an original one.
Your Honor, if you look at it, there's on the bottom left-hand portion, there is a mark, certified true copy. This certified true copy would not have appeared in any correspondence with no reply at records.facebook.com. So it is not a printout. It's not an original. Would not reflect what accurately was printed out or appeared on the screen.
2 points.
Counsel for the prosecutor say?
2 points, Your Honor, please. Settled now, 2019, assuming that the counsel is correct. Photocopy now is considered as an original, Your Honor, please. And number 2, Your Honor, please. With all respect, presentation of evidence, objection to the admissibility of object and documentary evidence happens when the documents are formally offered in evidence. We're just in the process, Your Honor, please, of presenting this evidence. So therefore, the defense may object thereto when we formally offer the exhibit, Your Honor, and that's not happening yet.
Your Honor,
as a last point, counsel for respondent, before the chair makes a ruling.
Your Honor, true that photocopies are now considered originals. However, the photocopy must be an accurate and exact reproduction of that original or that printout. This, Your Honor, may I read it for the record? The bottom left-hand copy, it says certified true copy, NBI-cybercrime, signed Safira T, date 4/10/26. Is counsel for the prosecution telling us now that this marking came from Meta, the email of Meta, of Facebook?
Can you respond, counsel, before the chair makes a ruling? I'm interested to hear your responses.
I'm so sorry. Could you repeat the question, please?
It was rhetorical, Your Honor. He did not answer.
He was basically questioning the fact that if it indeed came from Meta and is a computer printout, why the need for someone to certify it as a true copy?
I do recall, Your Honor, please, that was submitted to the Committee on Justice. Along the way, there was a need to certify that, Your Honor, please. But be that as it may, certification of a printout of an electronic document is not even necessary, Your Honor, please.
The objection of the counsel for respondent is overruled. The counsel may proceed.
Thank you so much,
He may raise his objection at the proper time when formal offer is made of documentary evidence, and any correction may be made thereafter, or rather before that, by the counsel for the prosecutors.
All right.
Please proceed.
Thank you so much. Mr. Witness, you met... Now, I'm sorry, Your Honor, please. I recall the last question. I have to proceed to presentation of the documents. Now, Mr. Witness, if this printout of the screenshot of Meta's reply is shown to you, will you be able to identify the same?
Yes, sir.
Now, what relation, if any, does that document have with the printout that you mentioned earlier?
This is the printout that I submitted, sir.
Now, Mr. Witness, Your Honor, please, again, as previously manifested, the documents identified by the witness has been previously marked as Exhibit P-4-8 for the prosecution. Okay, how faithful, if at all, is this printout from the actual screenshot?
The printout accurately reflects the screenshot, sir.
And how do you know that this printout accurately reflects the screenshot?
I compared the screenshot with the printout and the email confirmation of Meta and found that the contents are identical, sir.
Okay. Now, Mr. Witness, you mentioned that Meta quotes acknowledged and quotes the preservation requests. Now, based on your experience, and if you know, ano ba ang ibig sabihin kung yung Meta nag-acknowledge ng isang preservation requests?
Objection, Your Honor. He would be to say that.
Your Honor, please.
Counsel for the prosecution, what do you say?
Your Honor, please. This is an NBI agent that has been practicing digital forensics for 2 years, appearing in court for 30 times, and underwent training for 2 weeks. No other person in this room is more competent to answer the question than this witness. Let the witness answer.
Nevertheless, Your Honor, he's incompetent. He's not from Meta. He doesn't know Meta procedures. The mere fact that he's an NBA agent doesn't make him competent.
Can I reply to that, Your Honor, please?
Overruled. Chair will allow it. If the witness knows, he may reply. If he does not know, he should so admit also. Witness may answer.
It means that Meta have taken necessary action to preserve the evidence, sir, and assign a case number on it.
So, took reasonable steps to Now, yung question now is, after receiving this acknowledgement from Meta, ano ba yung ginawa mo kung meron man, in relation to the investigation you conducted on the statements of the Vice President?
I further preserve the video and authenticate the same, sir.
Alright, so you said you...
With the permission of the counsel for the prosecutors, witness, Mr. Witness, what do you mean by Meta assigned a case number to it? What does that exactly mean?
It means that yun po, they have taken reasonable action. Yung case number po is for monitoring namin kasi multiple multiple requests po from different investigation. Yung case number na yun for specific request po.
So pag may ni-request kayo sa Meta i-preserve ang isang digital footprint o data, lalagyan nila ng case number?
Yes po.
Lahat kayo na mag-request na i-preserve yun, ilalagay sa ilalim ng case number na yun yung mga request?
Hindi po. Per request po yung case number.
So each request will have a separate case number from Meta?
Yes, Your Honor.
And the case number for this one would be what?
911615, Your Honor.
Saan po nakasulat yun?
Your case number is 91, nasa upper part po, Your Honor. 91.
Ayun, 911654?
Yes, Your Honor.
You may proceed, counsel. Thank you.
Thank you so much. Mr. Witness, you said that you proceeded to further preserve and authenticate the subject video. Now, let's go to that proceeded to further evidence. What does it entail, if any, and if you know?
It means that I further preserve it using a screen recording, open source broadcast software studio, OBS. I screen record what appears on my screen, the video, the online live stream November 23, 2024, from beginning to end, including its URL.
Okay. Now, what about authenticating the video? Ano bang ibig sabihin yan kung alam mo?
After screen recording, there's an output video. I compared the output video with the November 23, 2024 video and ensure that the contents are identical. After ensuring that the contents are identical, I now generated a hash value calculation on the video to ensure that the video won't be tampered until presented in court, sir.
Mm-hmm. Mr. Witness, ano ba yung pruweba mo kung meron man that you authenticated the subject video?
I have executed an affidavit of authentication of digital evidence dated January 13, 2025, sir.
Okay, now, kung yung affidavit of authentication of digital evidence dated January 30, 2025 ay papakita sa iyo, will you be able to identify the same?
Yes, sir.
Now, in the process of the prosecution is in the process of confronting the witness with a document that is previously marked as Exhibit B-Roman numeral 4-9 and series, constituting of 29 pages, including the attachments. Or please, the defense is invited to peruse the documents.
Oh.
Your Honor, we object to the introduction of this affidavit of authentication. This is not an original copy of his affidavit. This is not electronic evidence. And if you look at the affidavit, even the appendages, which supposedly consist of USBs and CD, there's no USB, there's no CD, and even the signatures are not wet signatures, Your Honor.
What is counsel for the prosecution? We will not comment to that, subject to the proper response to that when the time comes in the formal offer of exhibit, Your Honor, please.
Your Honor, the objection of the counsel for respondent is noted as to the admissibility of the offered document. However, as correctly pointed out by counsel for the prosecution, the proper time to object to the same and for the court to rule it will be during formal offer, once the prosecution has already rested its case. Sorted.
Thank you so much. Please, Mr. Witness, what relation, if any, does that document have with the affidavit that you mentioned?
Your Honor, may I just make a quick manifestation?
Counsel for the respondent. Yes, you may, sir. Please
Your Honor, during pretrial, the parties got together and agreed that originals of the documents that were to be marked will be presented during trial. We agreed to expedite the proceedings. And now, what is happening is photocopies of documents that we want to peruse and see are being presented. So we object to this, Your Honor.
If I may, can I reply? Sorry, I'm so sorry.
The manifestation of the counsel for respondent is duly noted.
Thank you so much, Your Honor.
Please proceed, counsel for the prosecution.
On page 3 of the affidavit of authentication of digital evidence, may makikita dyan yung isang pirma sa ibabaw ng pangalang John Mark Caligo. You see it?
Yes, sir.
Yung tanong now is, whose signature is that, if you know?
This is my signature, sir.
Your Honor, at this juncture, Your Honor, please, despite the prosecution's understanding that a photocopy is now the original, is now considered as an original, but to address the concerns of the defense, Your Honor, please, I move that we be allowed to present the original of the documents that was confronted, that the witness was confronted with. Sorry, it's a certified true copy of the affidavit of authentication, Your Honor, please.
Counsel may proceed.
Okay, now, you mentioned, so I will go back. Now, Mr.
Without prejudice to the counsel for respondent viewing the same with respect to its certification.
Affidavit of authentication of digital evidence dated January 30, 2025. Now, we are confronting you now with a certified true copy of the same document. After perusing the same, you have to tell us what relation, if any, do the documents before you have with the documents, affidavit of authentication of digital evidence that you mentioned.
Your Honor.
Yes, counsel for respondent. We'll finish perusing, Your Honor.
Yes, yes. Oh. Yeah, I know. Stephen, can I ask somebody? Can you do that? Pass. Yeah.
Your Honor, for...
Yes, counsel for the respondent.
Thank you.
You may proceed, sir. For your comments.
Sir, for Your Honor, for P-I, P-4-9H. Your Honor, there is a CD in the original. Line 4, ba? Line 4.
Just look at the
Counsel, what are you referring to again? P dash. P dash 4 dash 9 what?
I'm not sure.
Before. Yeah.
P dash.
May matanggalan yung ano. Is this the same sequence? Sige, punta ka sa C. Hanapin mo yung C. Hindi ko. Okay, next page.
Yan.
Okay, next page. Next page. Okay, next page. Yeah, spot the difference.
Your Honor, for P-4-9H, in the original, there's a marking, November 23.
And in the photocopy, it is only a photocopy of the CD, Your Honor. So there's a difference.
Noted. Can reply to that, Your Honor.
Counsel, let's get all of his comments first. The page.
Thank you.
Your Honor, the page after in the original is a USB, which is Annex E-1 with markings October 18, 2024 video, CL. So it is not the same document. It's not faithful reproduction of anything, Your Honor.
The photocopy is not a faithful reproduction of the certified true copy. That's what you're stating.
Yes, Your Honor.
What does the counsel for the prosecution say?
Your Honor, counter manifestation that the documents that the defense are producing have been identified by the very that exhibit. So, Your Honor, please, we move that the comments of the defense be noted, Your Honor.
We're saying is that this is not the copy mark. It is not the same as the original, which he says it's the same thing that should identify. What he's saying is off that. What he identified earlier, which is the marked copy, which is the copy marked during pre-trial, is not the same document as they are passing on as an original. Your Honor, this is the
Counsel for respondent. That is a proper subject matter too for your cross to point, if at all, the distinction and difference between the two copies, which counsel for the prosecution can use as a subject matter for his redirect.
Thank you, Your Honor.
Because you can confront the witness with respect to the certified true copy that is different from what he identified earlier, impugning, if at all, his credibility as a witness in this case.
Thank you so much.
So we note the comments and observations of the counsel for the respondent. I got lost. So it's being
registered our continuing objection.
So noted and so registered.
Thank you so much. Can we proceed?
Before we proceed, the presiding officer was not there during pre-trial. As manifested by the counsel for respondent, was there indeed such an agreement that the originals will be presented during the trial?
Yes, Your Honor.
By both parties. Can the counsel for the prosecutors also confirm that?
Your Honor, please. We do not confirm. I conferred with my team, the team who actually participated in the marking for Article 4. Your Honor, please. Be that as it may, Your Honor, please, we would like to put into record certain realities of the law. A photocopy is now considered as an original. 2019 amendments in the rules of evidence. Number 2, Your Honor, please. This is the person who authenticated the documents. So there's no other person who is competent to testify as to the veracity of those documents other than the witness.
Your Honor, that's only a so you do not confirm.
No,
you do not confirm such an agreement during pre-trial.
We do not confirm that, Your Honor.
So, Chair would like to advise the parties. The court understands the exceptions to the original document rule and will so implement the rules in that regard. However, if it does not fall under the original document rule exceptions, then to save on the court's time, the party presenting the document should present the original during trial to omit what we are seeing now. Perhaps in the next time you present a witness, counsel for the prosecutors and for response.
We will, Your Honor. We appreciate that. Your Honor, please, we understand that will be for the next
for the next one. Please
thank you so much. Are we done now? We move, Your Honor, please. That
Your Honor, may I request that he not also address me directly?
So ordered, so instructed. Kindly address all of your queries and statements to the presiding officer and use the third person when referring to your fellow counsel for the other party.
Much obliged, Your Honor, please. We move, Your Honor, please, that the marking in the affidavit of authentication of digital evidence that was previously identified by the witness in photocopy, the markings of the same be transposed, Your Honor, please, to the documents that this witness is being confronted with at present, Your Honor, please.
We object to this, Your Honor. This is precisely our earlier just the objection. They're marking a new document. That's why they're asking that it be marked again, which defeats the very purpose of our pretrial.
If I may reply, Your Honor, please. Can I continue? I was
allow the counsel
withdraw that motion. We will stand by the presentation, the photocopy allowed by the rules and identified by the witness who actually executed the affidavit. May proceed, Your Honor, please.
I hope to satisfy his counsel for respondent. You may proceed, sir.
Thank you so much, Your Honor. Okay. Sa ibabaw ng pangalang Attorney Jeremy C. Lotok. Now, kaninong pirma ito kung alam mo?
Pirma po ni Attorney Lotok.
Now, how do you know that it is the signature of Attorney Lotok?
Nakita ko pong pinirmahan niya yung document. May mga document po ko na nakita at enacted upon bearing signature, kaya pamilyar po ako.
Thank you so much. Your Honor, please, we proceed. Mr. Witness, now, what action did you perform, if any, after you authenticated the subject video in relation to the investigation you conducted on the statements of the Vice Presidents?
I first saved the video on my laptop and saved a copy of the video on a DVD and a flash drive.
Okay, now, you mentioned that you saved a copy in a flash drive. Mr. Witness, kung yung flash drive ipapakita sa iyo, will you be able to identify the same?
Objection,
Yes,
Your Honor. We object.
What is the objection of the counsel for respondent?
The document identified by the by the witness was the photocopy, and the appended there's no flash drive, CD, or anything appended upon that. So there's nothing, no foundation for this question.
I have to reply to that, Your Honor, please. This is a
counsel for the prosecution.
This is a non-issue. I asked the witness, what did he do after saving the video, and he said he saved it in a flash drive without referring to any document attached to the affidavit of authentication. Basis is laid, Your Honor, please. This is a non-issue. We may proceed, Your Honor, please.
Your Honor.
This is not a surprise. This was several flash drives were pre-marked during the pre-trial.
Your Honor, may I reply first before?
I believe 7 on the part of the prosecution and several on the part of the respondent too. But you may proceed, sir.
Your Honor, that is not my objection. My objection is the very basis upon which the witness introduced this flash drive was the affidavit. The affidavit. And there was no affidavit upon there was no attachment upon the affidavit which they introduced. So the very questions that he has do not have any foundation.
Counsel for the prosecution, before the presiding officer makes a ruling.
Ako yung magiging parang sirang I just said that this witness said that he saved a copy of that video in a flash drive. So the logical question now is to ask him if this flash drive is presented to him, is he able to explain and or identify the same? I don't see any proper basis for an objection to that, Your Honor, please.
Presiding officer will make a ruling. Objection is overruled. The prosecution, counsel for prosecution, is trying to comply with the requirements enunciated by the Supreme Court insofar as such pieces of evidence is concerned. Number 1, establishing its origin. Number 2, to trace the chain of custody insofar as the transfer to a storage device is concerned. And finally, how it reached this court. So the objection is overruled.
Thank you so much, Your Honor, please. Now, Mr. Witness, Attorney Bagalion, please confront the witness with the flash drive. Mr. Witness, I'm now showing a flash drive that is previously marked as Exhibit P dash Roman numeral 4 dash 10A, containing the subject video that is previously marked as Exhibit P dash 4 dash 10 for the prosecution. Question: what relation, if any, does this flash drive have with the one you mentioned?
May I know if this was appended upon any...
For respondent is recognized.
Thank you, Your Honor. Your Honor, may I know if this was appended upon any document?
Counsel for the prosecution will please reply.
Your Honor, please.
The answer is no, I presume.
No.
The basis, if at all, counsel for the respondent is the testimony of the witness. When asked, again, to establish not only the origin, but also how he transferred it to a storage device, and if at all, how it reached this court. So, Chair replies, and if that is an objection, overrules the same. Witness may answer.
Permission to unseal the flash drive.
You may do so, sir.
Thank you, Your Honor.
Your Honor, the witness manifestation is now in the process of unsealing the object evidence.
Witness will please answer.
This is the flash drive where I saved the recording, sir.
Now, Your Honor, please, at this juncture, we are about to confront the witness with the video contained in the flash drive.
Your Honor, kindly let the counsel for the prosecution finish.
Yes, Your Honor. Thank you so much. And in the interest of time, Your Honor, please, we move that we allow Attorney Bagalion to transport himself to the technical booth to facilitate, Your Honor, please, the playing of the video when the time comes.
Counsel for respondent.
Your Honor, may we know how long the video is?
We will arrive to that, Your Honor, please.
No, I'm also curious. How long
Alright,
is
now.
this good for us to know? How long is this particular video? Namely, Exhibit B, Roman numeral number 4, 10A.
Your
How
Honor,
many
please.
minutes or seconds would this be?
Exactly, the video is 2 hours and 26 minutes and 10 seconds. But wait, Your Honor, please. We will aid the court in this regard. We will not be showing the entire 2-hour video, Your Honor, please. We will be presenting the relevant portions of the video, Your Honor, please, sanctioned by the rules and subject to the defense doing whatever they want with the remainder of the video, Your Honor, please.
Your Honor,
So, what will you play exactly, counsel?
Your
How
Honor,
many minutes or seconds?
We counted it's 2 minutes and exactly 18 seconds, Your Honor, please. 2 minutes and 18 seconds of a 2-hour, 26-minute and 10-second video, Your Honor, please.
Your Honor,
Counsel for respondent say?
we object. Based on Your Honor, based on the rules, part of a video documentary must be presented, Your Honor.
Come again?
I'm sorry, counsel?
Yeah, hold on, Your Honor.
I'm sorry, counsel? I did not get what you
Hold
said.
on, Your Honor. Your Honor, under Rule 132, when part of a transaction, writing, or record given in evidence, the remainder must be shown. When part of an act, declaration, conversation, writing, or record is given in evidence by one party, the whole of the same subject may be inquired into. And when a detached act, declaration, conversation, writing, or record is given in evidence, any other act, declaration, conversation, or record necessary to its understanding must be given into evidence. Your Honor, we request that the entire video be played.
Your Honor, can I respond to that, Your Honor, please? Can I respond to that?
What does the counsel for the prosecution say before the chair makes a ruling?
Your Honor, please, we don't want to put the defense on the spot, but that is a misreading of the rules. Your Honor, please, counsel cited Rule 132, Section 17. With all respect to the defense, that doesn't serve your interest. It serves the interest of the prosecution. May I explain? Reason. If we read Section 17 of Rule 132, it says, when part of transaction, writing, or record given in evidence, the remainder is admissible. When parts of an act, declaration, conversation, writing, record, when part is given by one party, and in this case, that is the prosecution, the whole of the same may be inquired into by the other side. Meaning, it's simple. This rule, Section 17, Rule 132, allows exactly the prosecution to present a 2-minute portion of a 2-hour video subject to the defense, the presentation of the remainder of the same. Be that as it may, Your Honor, please, the rules are clear. Number 2, we invoke, Your Honor, please, the ruling that it is for the prosecution to decide what to present, when to present, how to present, and whether to present at all. Be that as it may, Your Honor, please, the defense will not be prejudiced exactly because when the time comes for the defense to present their evidence, they can present the remainder of the 2-hour video. What we are saying, Your Honor, please, for the interest of time, for the prosecution's presentation of evidence, we deem that's only a 2-minute portion of the 2-hour video is relevant at this point in time, Your Honor, please. We move for a ruling.
Your Honor, if I may respond.
As the last response,
Your Honor,
the
prosecution cannot be allowed to present a truncated part of a whole 2-hour, 26-minute video. That will not provide the context necessary for the understanding of what occurred during that night on November 23, and also not allow the proper identification by this witness.
Your Honor, sorry, I will not even reply to that, Your Honor, please.
Chair would like to ask, who did the edit? From the how many hours? 2 hours?
No. Your Honor, please, if I make an reply to that.
Who did the edit? Was the witness the one who did the edit, or was it already the prosecution?
Your Honor, there's no editing done. There's no editing done.
Who got that shorter portion?
No, Your Honor, please. What we are presenting are portions of the entire 2-hour video. But this witness, I think, will be able to identify the specific timestamps of that preserved, not edited portion. If I may repeat, Your Honor, please, we are not presenting any edited portions, but only snippets, portions of the 2-hour video. And this witness, I suppose, will be able to identify which specific portions that he would like the court to view at this point.
So when it is shown, the witness will testify and attest to the portion of the entire video that it was found insofar as the timestamp is concerned.
Yes, Your Honor, please.
But as evidence at the proper time, you will be offering this entire 2-hour or so video.
Yes, Your Honor, please.
And simply highlighting the 2 or so minutes. Would that be correct?
That's a very keen observation. I agree 100%, Your Honor, please.
Your Honor, the prosecution cannot be allowed to do this because the entire video will show the context upon which the utterances were made.
That is a matter for the counsel for respondent to do and present during their time, because I believe the counsel for respondent also identified and marked, if I'm not mistaken, the same video for over 2.5 hours. It can do so during its time to present its evidence in chief. The objection is overruled. Counsel is instructed to go to the booth accompanied by a counsel from the respondent in order to make sure that indeed the USB identified by the witness is the same USB that will be played in the tech booth of the Senate.
Okay. While they're doing that, may I propound the next question, Your Honor, please?
Yes, counsel, you may proceed.
Mr. Witness, John Mark, listen. Now, you mentioned kanina that you authenticated the subject video by recording the same through sinasabi mong open broadcaster software OBS, and then you compare the contents of the recording and the subject video. That's one. And you also said that you investigated certain statements made by the vice presidents on November 23, 2024. Yung tanong, no? What particular statements of the vice president did the NBI deem proper to investigate?
The statement of the vice president where she uttered that she already talked to someone to kill the president, the first lady, and the former speaker of the house if something's happened to her.
Okay, now, the next question now, Mr. Witness, is in what particular portion of the subject video, did the respondent utter that she already contracted a person to kill? Objection, Your Honor. Oh, wait.
Allow the counsel to finish his question.
Done. Relax. To kill the president, the first lady, and the former speaker of the house. Objection, Your Honor.
What is the objection of counsel for respondent?
Your Honor, the no basis for the question, Your Honor.
Overruled. Witness may answer.
May I refer, sir, to my notes to identify the specific timestamp, sir?
Okay,
So witness may do so if it is available to him. You may refer to your notes. While he's doing that, while the witness is doing that, Senator Judge Alan Cayetano is recognized. You may proceed, sir.
Your Honor, may I question what notes he is referring to?
Counsel for respondent.
Apologies,
The
sir.
presiding officer recognized Senator Judge Alan Cayetano. You may proceed, sir.
Just some thoughts, presiding officer. This is not yet an appeal from your ruling and maybe a question to the counsel of the defense. Just to refresh our memory, Rule 132, Section 17, when part of a transaction, writing, or record given in evidence, the remainder admissible. When part of our act, declaration, conversation, writing, or record is given in evidence by one party, the whole of the same subject may be inquired into by the other. And when a detached act, declaration, conversation, writing, or record is given in evidence, any act, declaration, conversation, writing, or record necessary to its understanding may also be given in evidence. So I'm not appealing yet. I see the logic of the ruling of the presiding officer. Ito lang po ang tanong ko, is the defense going to ask later on for the showing of the whole video? Because if they are, why don't we just watch the whole of it? Because we're going to have to assess the context. If it was really a threat, what did she say before or after? And I don't really want to go home today believing one thing based on a 2-minute clip and then come back next week to watch the 2-hour clip. I think most of us saw parts of the clip. Of course, I don't also feel like watching the 2-hour, I don't even watch 2.5-hour movies, much less this. But I'm just putting this at the feet of the presiding officer and my colleagues na kung gagawin din naman natin eventually yung 2.5 hours, mas gusto ba natin putulin muna ngayon at may iniisip tayo and then later on the 2 hours? Or can the two parties agree of the 2.5 hours, which one yung may context? So I'm not criticizing the prosecution's motion. I see what you mean. May I ask that one question to the defense, if they're going to ask presiding officer? Precisely.
For the presiding officer, we cannot dictate nor predict what either counsel for the prosecution or respondent will do during the presentation of their evidence in chief. Even if they say yes to us now,
yes,
actually they have every right to change their mind and
yes, I agree, Your Honor, but
so anymore.
But if they do answer want it shown, may we consider? I mean, if I'm the only one who wants to see it as a whole, then I will submit to everyone else. But if everyone else is saying we will eventually watch the whole of it, we might as well get it over and see the context of the whole video. Unless the two parties can agree that they only want to look at 30 minutes or 1 hour. I don't know what context they're talking about. I'm just trying to expedite
both parties, Senator Judge Alan Cayetano, marked the same video.
Yes. May I ask
which is over 2 hours.
May I just ask the defense, do they plan to ask us to watch the whole?
Counsel for Defense will please reply to the question of Senator Judge Cayetano.
First, Your Honor, precisely why we're asking to watch the video is because we don't know what the contents of that video is. We don't know if it's any different or the same with our video. And to answer the question of the Honorable Senator, yes, we will be asking the entire 2-hour, 26-minute video to be presented and watched later on during our process.
So on that point, Mr. President and Presiding Officer, hindi naman nakalagay sa Section 17 when. And usually, at least for myself, if I have to watch 30 minutes and then may emphasize na 30 seconds, 2 minutes, 1 minute, pinapanood mo na yung buo and then saka papanoorin yung maikli na ine-emphasize para walang prejudgment. Kasi pag nauna yung portions na maliliit and then saka mo lang sasabihin later on, eto pala context nito, medyo umiiba. But again, no, I'm only one of the 24, so I leave it to my colleagues. If we're going to have to watch it anyway, may I ask the presiding officer what the pleasure is? But since the rule doesn't say, personally, I'd rather watch the whole thing and get it over with, then allow the prosecution to pick out the portions that quickly say that goes into the center of the controversy or what they want to prove.
Without disagreeing with Senator Judge Cayetano, for the presiding officer, it's just that I don't think the court should impose or dictate upon either party how they will present their evidence in chief. Although it would save the court some time but we can also waste a lot of time arguing about this instead of watching the 2-minute video.
Mr. Presiding Officer, I'm not saying we dictate because there was an objective. You ruled. You can change your ruling or we can appeal. But I'm saying I'm just one. So if everyone agrees na portion muna, I will submit to that. But if everyone else thinks na panoorin na yung buo, then baka I can appeal your ruling without voting. So I'm just bringing this issue for expediency, but I leave it up to what everyone else thinks about it.
You know, Your Honor, if I may, we also move for the reconsideration of the earlier ruling of the Honorable Court.
Counsel cannot move for the consideration of the ruling of the chair. Only a senator judge.
Your Honor, may we manifest that we would. During cross-examination, Your Honor.
Presiding officer declares a brief recess.
Thank you so much, Your Honor. Very good.
counsel for the parties to kindly situate themselves in their respective tables, as well as the senator judges, as we will resume in a minute. During the break, the presiding officer had a discussion with the senator judges, including Senator Cayetano. The presiding officer would therefore like to make of record the following. Number one, should the counsel for the respondent rather, decide as it has manifested to present the entire video, this court shall allow it during the time for the respondent to present its evidence in chief. We will not interfere with how each party or either party presents their case, with a caveat that a portion of an entire video being presented is not only to save on time, but also to be able to support the allegations from the point of view of the prosecution insofar as their articles of impeachment is concerned. No need to say that the counsel for the respondent will also present the evidence that they deem best that will prove the innocence of the respondent in this case. Senator Judge Cayetano? The mic, please, of Senator Judge Cayetano.
Sir Presiding Officer, I submit and I think there's a consensus. May I ask just one question about authentication? I may proceed, sir. Clarified with my indulgence to the prosecution and defense. Just to the witness, please correct me kasi hindi ako techie talaga dyan. So sabi mo, pag in-authenticate mo, you get the video tapos may hash.
Yes, Your Honor.
So you get the hash tapos you download the video. Tama po ba?
No, Your Honor. The video was screen recorded, Your Honor.
Okay, so screen recorded, then yung hash na nakuha mo.
Yung hash value po is kinalculate from the recorded po.
Okay, then you have to compare that with the original one, right?
Yes, Your Honor.
So the original one, yung hash niyan, nasa Facebook, tama ba?
Yung hash po, hindi po kinalculate yung hash from the Facebook. Kasi ang purpose po ng hash value is to calculate po yung value ng mismong video na ni-record ko. Dahil hindi po siya yung for authentication purpose, but for the integrity of the video that I screen recorded na if matampered siya during the time na sinabit siya at presented in court, makikita po na
video was recorded using open broadcaster software or OBS. Just for the benefit of the court, could you briefly explain what OBS is and how it was used in the course of your investigation?
It's an open source na software na pwede pong i-access na kahit sino.
So it's generally available to the
yes,
public?
Po. And ang purpose po niya is may two functions siya, is live stream and screen recording po.
And stream recording?
Screen recording, Your Honor.
Could you explain the capabilities nitong OBS as well as any considerations that investigators take into account pag ginagamit po itong recordings generated through this particular software as part of your investigation?
Yung OBS po, capable po siya i-screen record kung ano po yung nakikita sa screen. After po nun, makakapag-generate po siya ng output. Yung output po na yun, yung minamanually compared ko with the live stream video, Your Honor.
To authenticate?
Yes po.
Thank you. Thank you, Mr. Presiding Officer. Thank you.
Thank you, Your Honor.
Noted and entered into the records. What is the pleasure of Senator Judge Rafi Tulfo?
Mr. Presiding Judge, just a statement.
The gentleman may proceed.
In Rule 132, Section 17, it is not mandated that the whole record be shown to the court. The video being shown in open court and it being in evidence is completely different. That's all, Mr. Presiding Officer.
Noted and entered into the records. What is the pleasure of Senator Judge Pangilinan?
Yes, Mr. President, just one or two quick questions to the
gentleman may proceed. Witness will please answer the questions of Senator Judge Pangilinan. He has 2 minutes.
Mr. Carilong, ikaw nabanggit mo kanina na nag-training ka, no?
Yes, Your Honor.
Hindi lang dalawang linggong training lamang.
2 linggo on the start, pero during the tinatrain po ako ng chief ko. During the process.
So continuing training?
Yes po, kasi nagpe-present po ako sa...
At saan yung training? Na sinabi mong 2 linggo, nabanggit mo ba?
Sa office namin siya ginawa, pero ang nag-handle is MaxCore po.
Ano yung MaxCore?
MaxCore Interventures.
So ano nga yun?
Provider po namin ng forensic softwares.
At kumpanya siya?
Yes po.
Ng computer...
Ng mga pang-forensic po.
Pang-forensic, okay.
Yes, Your Honor.
Thank you.
Judge for prosecutor will please proceed.
Your Honor, maybe alam mo ba kita magpadayon in Tagalog it means in English. Can we proceed?
Counsel may proceed.
Thank you so much, Mr. Witness. Now, in what particular portion of the subject video did the respondent utter
I was literally about to ask
that she already contracted a person to kill the president, the first lady, and the former speaker of the House of Representatives?
Are you done?
Objection?
Objection, Your Honor.
Kindly state objection, counsel for response.
Your Honor, the question is misleading. There was no mention anywhere before that the of the president. Yeah, there's no mention in any testimony earlier. There's no mention that video.
Your Honor, again, with all respect, the records will bear me out. Bases have been more than complied with. This witness mentioned many times over that the subject of the investigation is the statement of the Vice President that she already contracted a person to kill the President, the First Lady, and the former Speaker. There's no basis for the objection, Your Honor, please.
Your Honor, may I ask for a readback? He was the only party who said that, Your Honor.
Can you use the third party in referring to opposing counsel?
Yes, Your Honor.
If I may, Your Honor.
May I ask Your Honor for a...
Let the counsel for the finish the statement.
May I ask Your Honor for a reading of the transcript, as the witness, to my recollection, never mentioned that the Vice President did those things.
All right. If I may, Your Honor,
counsel, kindly lay the basis.
Yes, Your Honor, please. Now, Mr. Witness, you said that your office, the NBI, conducted an investigation for a statement made by the Vice President noong Nobyembre 23 taong 2024. Naalala mo yun?
The subject matter of a digital forensic examination by the witness pertaining to the former Vice President. That was the instance, if the counsel will recall. that counsel for the prosecutors asked the witness if he knew who the Vice President was. So the objection is overruled. Witness may answer.
Your Honor, may I state for the record, my objection is on the part of the question where he said that the Vice President hired someone to kill the First Lady and the Speaker of the House, not on the identification of the Vice President.
Noted. Court already made a ruling. Witness will answer.
Mr. Witness, naalala mo ba yung tanong?
Can you repeat the question?
Okay now.
Kindly repeat the question, counsel.
In what? At the subject video, in that online media conference of the Vice President, did she utter that she already constructed a person to kill the President, the First Lady, the former Speaker? In what portion?
Objection, Your Honor.
What is objection?
Your Honor, this honorable court already ruled on this question. The discussion later on was on the leading question made by the prosecutor. If you recall, Your Honor, this honorable court said, prosecutor, please lay the foundation, the basis for your question.
Your Honor, please, if I make a response.
The presiding officer will ask the witness. Mr. Witness, out of the 2 or more so hours of video that you downloaded, do you know if at all the timestamp that pertains to any statements made by the Vice President pertaining to any of the allegations in the articles of impeachment, particularly Article 4, the subject matter of this case, in relation to alleged threats made by her in that video?
Yes, Your Honor, but may I refer to my investigator's note, Your Honor?
You may do so. Senator Cayetano,
Presiding officer.
Alan Cayetano, sorry.
May I know from the records, is this the first time that the
Dalahin
witness
na ni Ethan yung report.
mentioned that the Vice President uttered threats against the President, the former Speaker, and the First Lady?
Your Honor, if I may,
Because it will violate the rules. So against any group.
Senator Judge Cayetano, it will take some time before we can quote-unquote appeal to the records. I'm trying to have them get it. But in lieu of that, that's why the chair tried to intervene. Can counsel kindly lay the basis for the witness to be able to identify the timestamp portions of the 2-hour video? Counsel for the prosecutors, may proceed.
This will be quick. Mr. Witness, you said that your office conducted an investigation on the statement made by the Vice President dated November 23, 2024, correct?
Objection, Your Honor. Leading.
Kung ayaw niya, meron.
Your Honor, he's not on the record.
Overruled. Witness may answer.
Yes, sir.
Pero water na doon, yung mainit masyado.
Ano ba exactly yung sinabi ng Vice President noong araw na yan, November 23, 2024?
Objection, Your Honor.
Wait, I'm not yet done.
Your Honor, the bosses of the prosecution are very confusing.
Kindly let the counsel for the prosecutors finish his question before you object.
May I ask also may I ask, instead of this, Your Honor, may I ask that the Honorable Court direct the witness to allow me to object before answering. Because precisely the questioning of the prosecutor is there are many pauses, which it's confusing if he's done or not.
Counsel, witness even on occasion forgot what the question was because he did not respond to the question of the prosecutor.
Yes, Your Honor. So I just
Court will make sure of that.
Thank you, Your Honor.
So kindly finish your question.
Yes,
If you want to state it again, counsel for the prosecutors.
If it's the tone, I mean, what particular statements of the Vice President on that day did you investigate?
Oo,
Objection,
tapos
Your Honor.
kunin mo yung water.
Wait.
Please.
Take counsel for respondent. A bit of patience. Let the counsel finish. I don't think he's finished.
The question is that what particular statement on that day did you investigate? How's the meeting?
Objection, Your Honor.
Wala mo
Vague.
rin. Dinner ka na?
Your Honor, please. Can I say that, Your Honor, please? Can I?
What was the counsel? What's the basis of the objection?
I will
It's a
indulge.
2 hour,
Your Honor, please.
36.
I will indulge, Your Honor, please. I will indulge. I will add these two phrases. It will never be that. Now, Mr. Witness, what statements did the Vice President utter on that day?
Okay.
If any.
Your Honor, same objection. There's a 2 hour 26 minute. What? Let the witness answer.
Counsel, this 2 hour and so minute video was done on the same day.
Correct, Your Honor, but the question must be given with particularity.
If the witness knows, witness may answer.
Answer.
Witness will please answer.
Can I refer for my notes to identify the exact statement because I might say a statement that's not part of the actual statement.
Presiding officer will allow the witness to refer to his notes to refresh his memory. Go ahead, Mr. Witness.
The specific statement, quote and quote, yes, huwag kang mag-alala ma'am sa security ko kasi may kinausap na ako na tao. Sinabi ko sa kanya, kapag pinatay ako, patayin mo si BBM, si Lisa Araneta at si Martin Romualdez. No joke, nagbilin na ako ma'am. Pag namatay ako, sabi ko, huwag kang tumigil hanggat di mo sila mapatay. Hanggat di mo sila mapatay sila. And then he said yes.
Please proceed, counsel.
Thank you. Now, in what particular portion of that video recording that you authenticated of that online media briefing on November 23, 2024, did the Vice President utter those words?
If I may, sir, I think we should include the question first. It starts at 1 hour and 15 minutes to 1 hour 17 minutes and 18 seconds, sir.
Your Honor, so the witness manifested as an answer to the question in what portion he said, timestamps 1 hour 15 minutes 0 second to 1 hour 17 minutes 18 seconds, and we computed all of this. It's a 2-minute 18-second portion of that video. At this juncture, Honor, please, bases have been laid. The nation can finally see it. The court will do. We move. That's 2-minute and 18-second portion of that video be presented at this juncture, Your Honor, please.
The Secretariat is instructed to play the USB given to the tech behind that was observed and witnessed by both counsels for the parties. Order. Kindly play the video.
Vice President, thank you so much na po yung hearing na pumunta kayo for PRRD. Kami yung nasa likod niyo po, yung tinawag niyo ng bastos kasi po malaki. Congresswoman.
Kindly pause it. Ganyan ba talaga?
Your Honor, please, Your Honor, please, the witness said that he would like to include that question propounded to the Vice President.
So, ganyan nga, hindi nalalakihan yan? Ganyan lang yan? Or it will get bigger?
It will get bigger, Your Honor, please.
Okay, please proceed.
Thank you, ma'am. Nakakain kami. Ako po
Kayo, hindi na kayo mag-quiz. Sige,
Ma'am, mag-iingat po kayo. Nasa teritoryo kayo ng kalaban.
Okay
Nag-aalala po kami.
ma'am, kasi sila naman sila talaga yung bastos eh. You read what you saw.
Yeah. Mag-ingat po kayo kasi sa dinami-rami po ng inyong mga pasabog ngayong gabi, it seems like marami po talaga kayong alam about them, no? Dahil sa pagkakasama niyo sa kanila during the campaign and during the 2022 elections. Baka po mamaya kasi totoo yung mga naririnig namin or yung, I don't know if it's true, na meron daw silang Operation Romanovs and baka bala kayong ubusin ang inyong pamilya dahil hadlang kayo sa kanilang mga balakin in the future. So mag-iingat po kayo. Kami po kasi kami ng EDSA Friday 2, kami yung bumababa every Friday dyan sa EDSA because we believe yan yung tamang venue sa dinami-rami na ng problema natin. Ang kaya lang naman po namin gawin ay manawagan na bumaba na yan. Ano po kaya ang remedy naman inyong mga nasa posisyon o ng mga kayang labanan itong napakarami na pong ginagawang korupsyon at krimen laban sa taong bayan? Ano po ang pwede nyo maging remedy para matapos na ito, lalo't nagsisigaw na po ang taong bayan na mag-people power?
Yes. Huwag kang mag-alala, ma'am, sa security ko. Kasi may kinausap na ako na tao. Sinabi ko sa kanya, kapag pinatay ako, patayin mo si BBM, si Lisa Araneta, at si Martin Lumales. No joke. No joke. Nagbilin na ako, ma'am. Pag namatay ako, sabi ko, huwag ka tumigil na hanggang hindi mo mapatay sila. And then he said yes.
That's the end of that 2-minute and 18-second portion of the video, Your Please. Pwede ba kita magpadayon? Can we continue?
Council may continue, may proceed.
Now, Mr. Witness, what relation, if any, does that video that you viewed with the video you mentioned earlier, the Vice President uttering that statement?
It is the portion of the video that I authenticated, sir.
Okay. Let's continue. What happened next, Mr. Witness, kung meron man, after mong ma-authenticate yung subject video na yan?
Our team conducted an open source investigation to identify previous statement of the Vice President that had similarities to the November 23, 2024 video, sir.
Okay. Now, sinabi mo that your team conducted yung tinatawag mong open source investigation for any prior statements made by the Vice President against President Marcos Jr. and his family members. Yung tanong nga, ba't kailangan pa mag-conduct ng open source investigation for any prior statements na ginawa, kung meron man, ng Vice President against laban kay President Marcos Jr. at saka yung pamilya?
As part of our standard procedure, sir, kailangan namin makita yung full context kung bakit ito nagsimula. Kaya nagtingin kami ng mga prior statement made the Vice President against the President and the family.
Alright, now, ano ba yung 2024?
Okay ka lang, ma'am?
To set the exact statement, may I refer to my investigator's notes, sir.
Move, Your Honor, that this witness be allowed to peruse his notes to answer the question as to ano ba yung naging exact statement ng Vice President on October 18, 2024, Your Honor, please.
Witness may confirm with his stance.
Quote and quote, gusto ko tanggalin yung ulo niya ba? I just imagine myself cutting his head.
Wait, so sinabi ng Vice President, gusto kong tanggalin ng ulo niya, I imagine myself cutting his head. Now, ano pa yung naging statement kung meron ba?
So doon, na-realize ko, toxic na, di ba? ganyan na yung imagination mo. Sinasakal mo na yung tao. And then, I said, this is over.
Alright, kung meron pa, ano pa yung naging statement ng Vice President sa araw na yan?
Hindi marunong maging presidente ang nakaupo. Kasalanan ko ba yun?
Kung meron pa, ano pa yung naging statement ng Vice Presidente sa araw na yan?
Hindi ko alam. Pero isang beses, sinabihan ko talaga si Senator Amy. Sabi ko sa kanya, kung hindi kayo tumigil, huhukayin ko yung tatay nyo, itatapon ko siya sa West Philippine Sea.
Your Honor, please,
Diba wala na to?
there's a manifestation of the good Senator Tito Soto. He did not hear the last statement.
No such manifestation was heard by the presiding officer. Council may continue. Please proceed.
Thank you so much.
Kindly stated for the record, Senator Judge Soto, apologies from the presiding
Thank you.
officer.
I did not get the exact words that were uttered during the last statement.
Will the witness kindly repeat his answer to the last question propounded by counsel for the prosecutors?
Yes, Your Honor. Hindi ko alam. Pero isang beses, sinabihan ko talaga si Senator Amy. Sabi ko sa kanya, kung hindi kayo tumigil, huhukayin ko yung tatay nyo, itatapon ko siya sa West Philippine Sea.
Huhukayin. May proceed, Your Honor, please.
Counsel may proceed.
Ano pa yung naging mga statements, kung meron pa, ng Vice Presidente sa araw na yan?
Last statement, kung presidente nyo siya, okay lang. Ako hanggang vice president lang ako. Hanggang number 2 lang itong bansa na ito. Wala itong number 1 para sa akin.
Are these all the statements, Mr. Witness?
Yes, sir.
Now, proceed. Now, ano pa yung nangyari kung meron man pagkatapos madiskubre ng NBI yung mga naging statements ng Vice President nung araw na yan, October 18, 2024?
Like what we did to the main video, the November 23, I proceed to preserve and authenticate the October 18, 2024 video, sir.
Again, for ano ba yung ibig sabihin when you preserve the video?
It means that I make the necessary action to ensure that the evidence will be accessible at any time, sir.
Alright, now, ano ba yung ibig sabihin? After mo ma-authenticate yung video, ano bang ginawa mo kung meron pa?
I saved the video on my laptop and on a flash drive, sir.
Now, sinabi mo yung flash drive kung saan sinave mo yung mga video recording mo sa mga naging statements ng Vice Presidente sa araw na yan. Now, kung yung flash drive na yan, ipapakita sa iyo, ma-identify mo ba?
Yes, sir.
Your Honor, please, we are now in the process of confronting this witness with a flash drive that is previously marked as Exhibit P14-11, small letter A, for the prosecution, containing the recording of October 2024 press conference of the Vice President identified by the witness that is previously marked as Exhibit P-4-11 for the
To unseal the flash drive.
You may do so.
Thank you, Your Honor.
manifestation, Honor, that the witness is in the process of checking the flash drive. question, Mr. Witness, what relation, if any, does that flash drive have with the flash drive you mentioned?
This is the flash drive where I saved the recording, sir.
All right. Now, okay. Now, Mr. Witness, you mentioned earlier that you authenticated the subject video by recording the same through open broadcaster software, and then you compared the contents of the recording and subject video. And you also said that you found out that the respondent said, ito sinabi niya, gusto ko tanggalin yung ulo niya. At saka, I imagine myself cutting his head. Do you follow? Now, Mr. Witness, in what particular portion of that subject video did the Vice President utter, gusto kong tanggalin yung ulo niya, I imagine myself cutting his head?
Permission to refer back to my investigator's notes, sir.
Witness may do so.
Your Honor, may I approach a witness? Your Honor, may I approach the witness?
Counsel may do so.
Thank you, Your Honor.
For the first statement, timestamp 1 hour, 35 minutes, 57 seconds to 1 hour, 36 minutes, and 10 seconds. And on the part na, I just imagine myself, 1 hour, 36 minutes, and 52 seconds to 1 hour, 36 minutes, and 58 seconds, sir.
Okay now? What about the statement that sinabi niya, so doon na-realize ko toxic na, di ba? Ganyan na yung imagination mo. Sinasakal mo na yung tao. And then I said, this is over. In what particular portion of the video did the Vice President utter that statement?
From the authenticated video, timestamp 1 hour, 38 minutes, and 32 seconds to 1 hour, 38 minutes, and 48 seconds, sir.
Okay, now, what about the statement, hindi marunong maging presidente ang nakaupo? Kasalanan ko ba yun? In what particular portion of the subject video did the Vice President utter that?
Timestamp 55 minutes, 26 seconds to timestamp 55 minutes and 37 seconds, sir.
Okay. Now, what about the statement that I quote, hindi ko alam. Isang beses, sinabihan ko talaga si Senator Amy, pag di tumigil, huhukayin ko ang tatay nyo at itatapon ko siya sa West Philippine Sea. In what particular portion of the video did the Vice President utter those words?
Timestamp 1 hour, 11 minutes, and 28 seconds to 1 hour, 11 minutes, and 42 seconds, sir.
And finally, as to the statements, I quote, kung presidente nyo kay siya, okay lang, ako hanggang Vice President lang. Hanggang Vice President lang ako. Hanggang number 2 lang itong bansang ito. Wala itong number 1 para sa akin. In what particular portion of that video did the Vice President utter those words?
On timestamp 1 hour, 4 minutes, and 2 seconds to 1 hour, 4 minutes, and 16 seconds.
Your Honor, this representation took notes of the timestamp. So, Your Honor, please. We now move for, we go to the next question. Now, Mr. Witness, I'm about to show you the specific portions of the recording of the October 18, 2024 press conference. Now, you tell us, after viewing these portions, what relations do they have with the subject video of that October 18, 2024 video that you identified, if any, okay? Now, Your Honor, we move that Attorney Stephen Magallaon be allowed to proceed to the technical booth to bring the flash drive and for the Secretariat to play specific portions of the video identified by the witness.
Conditioned upon counsel being accompanied by a representative of the counsel for the respondent so that the exact same USB flash drive will be the one that will be played.
To guide the Secretariat, Your Honor, please, these are the timestamps that the prosecution would like to present. First, from 1 hour, 35 minutes to 57 seconds to 1 hour, 36 minutes and 10 seconds at the first video, and the second video is from 1 hour, 36 minutes, 52 seconds to 1 hour, 36 minutes and 58 seconds. So move, Your Honor, please.
Secretariat is instructed to kindly play the video in the presence of both counsels for the parties.
Gusto ko, ang galing yung ulo niya ba? I realized
And the second video, please. Timestamps 1 hour 36 seconds to 36 minutes to 52 seconds to 1 hour 36 minutes and 58 seconds, please. How is that? Is that it?
cutting his head. Gusto ko, ganun din ang gusto ko.
Mr. Witness, you heard the Mr. Witness, you heard the Vice President mentioning cutting somebody else's head. Mr. President, you also mentioned timestamps 1 hour 38 minutes to 32 seconds and 1 hour 38 minutes to 48 seconds. May we have that specific portion be played?
So, na-realize ko, toxic na, di ba? Ganyan na yung imagination mo. Ang imagination mo, sinasakal mo na yung tao. And then I said, this is over.
Okay. Then what about from timestamps 55 minutes 56 seconds to 55 minutes 37 seconds, please?
Elaborate po. Hindi marunong maging presidente ang nakaupo. Kasalanan ko ba yun? Hindi. Ba't sinasabi ng mga tao, kasalanan mo kasi hindi ka tumakbo, ikaw sana yung presidente. But then I said, maaga ako nagsabi, tatakbo for president. May madaming mga
Timestamps 1 hour 11 seconds. 1 hour 11 minutes 28 seconds. 1 hour 11 minutes.
Hindi ko alam. Pero isang beses sinabihan ko talaga si Senator Amy. Sabi ko sa kanya, kung hindi kayo tumigil, huhukayin ko yung tatay ninyo. Itatapon ko siya sa West Philippine Sea. Sinabihan ko si Senator Amy.
Thank you. What about from timestamps 1 hour 4 minutes to 02 seconds? 4 minutes 16 seconds.
mainit. Okay lang. Ako, hanggang Vice President lang ako. Hanggang number 2 lang itong bansa na ito. Wala itong number 1 para sa akin. Yeah.
If any, do these portions of that specific video have with the video you authenticated as to the press conference of the Vice President on October 18,
Those video presented were portions of the video that I recorded and authenticated, sir.
Thank you so much. Mr. Witness, ano ba yung nangyari kung meron pa? After you authenticated, identified and authenticated the video ng Vice President on October 18, 2024.
We perform open source investigation to identify naman po yung mga naging responses ng iba't ibang tao in response to the statement of the Vice President po.
Ano ba yung naging resulta kung meron man sa naging open source investigation nyo?
We found that the President himself, the former Speaker of the House, and different governmental agencies made their statement po in response to the statement of the Vice President.
So yung Presidente, yung Speaker, former Speaker of the House, saka yung mga sinasabing mga governmental agencies, nagbigay ng kanilang mga tugon sa mga nasabi ng Vice President. Now, ano ba yung mga governmental agencies na ito that you are referring to, aside from the President and the former Speaker of the House of Representatives?
The Armed Forces of the Philippines, the Philippine National Police, the National Security Council, and the Presidential Communication Officer.
Okay, now, nasabi mo na yung Presidente ay nag-issue ng kanyang statement in relation sa naging mga pahayag ng Vice President. Ano ba yung naging pruweba mo sa naging statement ng Presidente?
I have taken a screenshot of the statement of the President on the official webpage of the Presidential Communication Office. And I also have a video recording which I authenticated wherein the President made such a statement, sir.
Okay, so nasabi mo, isang screenshot saka isang authenticated recording ng Presidente. Now, let's go to the screenshot. Sino yung kumuha ng screenshot kung alam mo?
I did, sir, and I used my laptop.
Ginamit mo yung laptop mo. Ano ba yung ginawa mo kung meron man sa naging screenshot mo sa laptop mo?
I first saved an electronic copy po ng screenshot.
Now, saan na itong screenshot?
Pinrint ko po.
Ha?
Pinrint ko po.
Print mo. Now, saan na yung printout ng screenshot na ito?
Sinabit
ang naging statement